sa iyong tanan. We'll start with the law on succession, okay? Professor Rado would consider the law on succession as the most difficult, okay, field in civil law. But he would say also that yet it is the most interesting, okay? I actually fully agree with Professor Rado, okay? That it appears to be the most difficult, but it is the most interesting field in civil law. I don't know why, okay? Maybe because of death. Palaging may namamatay dito, okay? But maybe because of the inheritance, okay? Or because of mathematics, okay? So may aspect dito ng mathematics. So hopefully at the end of these lectures, okay, you would agree with Professor Rado. Now, as far as the distribution of the questions under succession, you would notice that the questions are really almost evenly distributed except for a few topics, okay? If you would notice, this is subjects of succession, meaning the heirs, etc. And then this one is legitimes, okay? And finally, this one is intestate succession. In other words, these three concepts would actually be 1/3 already, okay, of the questions. So I will also devote about 1/3 of your time to these topics. The heirs, who are the heirs, kinds of heirs, compulsory heirs, their legitimes, in case of intestacy, what will be their shares, okay? I would claim that there would never be a bar exam without a question on any of this or a combination of these three topics, okay? But if there is one single favorite topic, that is the governing law, okay? This one. And last year was really no different, okay? Out of the 16 MCQs, 6 dun, governing law. Ganun siya kapaborito, okay? So I will also devote time discussing the governing law, okay? So, in fact, I would discuss the governing law ahead of anything, okay? Because if the governing law is a foreign law, then wala tayong pag-uusapan, di ba? Because I cannot presume to know foreign laws unless, of course, there is a case which would tell us what is the foreign law of a country. But the questions of our exam would only ask you what law shall govern. Is it Philippine law? Is it the foreign law? Is it the law of his domicile? It is the law of where the will was executed, etc. So as to the very substance of that law, kung foreign law, wala tayong discussion dyan. Okay? Now, if it is Philippine law, then we will really discuss those laws. Okay? So, as to the other topics, again, they are really evenly distributed. Even last year, after the governing law, tig-isa lang halos. Okay? Of course, the essay would fall under the three, which I mentioned. Yung kinds of heirs, legitimes, and shares in intestate succession. About 10% siguro nandun sa topics na yun, sa essay. So, consider again the nature. Let's start with the nature of the concept known as succession. Last year, ito ang tanong, the characteristics of succession are as follows, okay? It is a legal contract, only property rights and obligations to the extent of the value of the inheritance are transmitted. The transmission takes place only at the time of the death. The transmission takes place either by will or by operation of law, okay? You may not agree with the term used, characteristics, okay? But nonetheless, you have just to know the sense of the question. In a way, he is asking for the exception. Only property rights, these three would actually be found sa definition. Okay? Kaya ang tamang sagot is, it is a legal contract. We are looking for an exception. It is not a legal contract. In fact, before the family code, there have been debates as to whether there can be contractual succession. Not anymore. Okay? With Article 84 ng family code, this debate had been banished. Okay? In other words, there can be no transmission of successional rights through a contract. It has to comply with the formalities prescribed by law as to wills, okay, under Article 84. Now, then into this, the following rights are extinguished by the death, except legal support, parental authority, right to inherit, agency, okay? Clearly, obviously, the answer is the right to inherit. Why would it be extinguished? In fact, the right will be vested upon the death, not be extinguished. Okay? The right of the heirs are inchoate until the death of the person. Okay? Pero pag namatay na, then the rights will be vested. Rights will be transmitted upon death. Okay? Now, into the governing law. Okay? Example, the order of succession shall be governed by, okay, the national law of the heir, the law of the country where the decedent died, the law of the country where the decedent was a resident at the time of his death, the national law of the decedent, the law of the country where the properties of the decedent are located. MCQs like this, and I told you, gawa-gawa ko lang ito, ay formulated this mga months before the bar exam noong 2011. Okay? And this clearly, order of succession shall be governed by the national law of the decedent. Okay? This is Article 16, Paragraph 2, which expressly provides that the order of succession shall be governed by the national law of the decedent. In other words, it's not the law of the heir, it is irrelevant, it's not the law of the place where the decedent died, wala din, okay? It's the national law, okay? If you are given a set of facts, and it is clear na he is a citizen of France, then you should say it is French law because under Article 16, okay, the order of succession shall be governed by, okay, the national law of the decedent, okay? Now, order of succession here, if you remember, Article 16 pertains to three aspects ng succession, okay? Intrinsic validity, amount of successional rights. Do not confuse these three. Magkakaiba ito, okay? Yung order of succession would pertain to sino ang una, who would be the first, in case the first set of heirs would not inherit, who would be the second, okay? Which we have also in our own law, okay? Like the primary compulsory heir first, and then in the absence, secondary compulsory heirs, that pertains to the order, okay? But whether a person would inherit or not, it doesn't pertain to the order, basically, on his own, okay? Now, thus, applying this rule under Article 16, a citizen of France, X, but a permanent resident of Canada, suffered heart attack and died in Japan while attending a conference. He was survived by his wife, an American citizen, his parents, sister, 2 children, both Filipino citizens. He left properties in the Philippines and France. He left a will which he executed in London. The capacity of his children shall be governed by, again, focus on the question. Clearly from this problem, the question pertains to the capacity of the children to succeed. And the answer is French law, okay? Because the decedent is a citizen of France, okay? In other words, it's not British law. British law pertains to the execution of the will. The law of Japan, because he died in Japan. The law of Canada, because the resident of Canada. Philippine law, no, we follow the nationality principle. But a common mistake dito sa reason ay, because Article 16, Paragraph 2 provides, wrong. As far as the capacity to succeed is concerned, it is not covered by Article 16. It is covered by Article 1039. Okay? Kaya pag mag-explain kayo, tapos Article 16 is a cite nyo, the examiner may not give you points. Nagtsachamba ka lang. Okay? The basis is Article 1039, which also provides that it is the national law of the decedent which shall be considered whether an heir has the capacity to succeed. Okay? This early, I would have to emphasize to you that just because a person is an heir doesn't mean that he will inherit. One good reason why he will not inherit because he doesn't have the capacity to succeed under the circumstances. Okay? Now, but 2011, ito ang tanong. An Australian living in the Philippines acquired shares of stock worth 10 million in food manufacturing companies. He died in Manila, leaving a legal wife and a child in Australia, and a live-in partner with whom he had 2 children in Manila. He also left a will done according to Philippine laws, leaving all his properties to his live-in partner and to their children. What law will govern the validity of the disposition? This time, validity of the disposition does not go into the order of succession, does not go into the amount of successional rights, but it goes into, one, the intrinsic validity. Okay? Of course, the validity of the disposition may also pertain to the capacity of the heir to succeed, but it basically would go into the intrinsic validity of the will. Okay? Kaya, ang options niya, Australian law, since his legal wife and legitimate child are Australians and domiciled in Australia, or Australian law, since the intrinsic validity of the provision is governed by the decedent's national law, or Philippine law, since the decedent died in Manila and he executed his will according to such law, or Philippine law, since the decedent's properties are in the Philippines. As mentioned earlier, as far as intrinsic validity is concerned, we follow the nationality principle. Okay? So it is the nationality of the decedent, not the nationality of the wife, of the heirs. Okay? So the answer is letter B. Okay? Now, last year, the capacity of an heir to succeed shall be governed by, okay? As simple as that. Sana ganyan pa rin kasimple ang mga tanong this year, okay? Although Dinriano is thinking na baka problem-based na ang mga tanong kasi last year, codal lang talaga, objective, okay? Capacity shall be governed by national law of the decedent's heirs. Take note, it's not the national law of the decedent. Baka nakita nyo lang decedent, yun na. Yung pala may heirs pa pala, decedent's heirs. Okay? Or the law of the country where decedent was a resident. No, the national law of the person who died is the correct answer. Okay? Properties, it doesn't matter. The law of the country where the properties are located is the first paragraph of Article 16, di ba? Lex recite. But that is not applicable as far as succession is concerned in relation to those aspects: order of succession, amount of successional rights, intrinsic validity, capacity to succeed. Pero yung lex recite, okay, where the properties are located would be relevant as to the probate, okay, because would a probate proceeding or petition prosper if there are no properties in the country where the petition was filed? There's no sense, okay? Ba't ka magpapaprobate in a place na wala namang properties to be distributed? Okay? Now, then, the extrinsic validity this time, okay? The extrinsic validity of the will of X, a Filipino but a permanent resident of Canada, shall be governed by Filipino siya. Law of the country where the will was executed, law of the country where the decedent died, law of the country where the decedent was a resident at the time of his death, national law of the heir, or the law of the country where the properties of the decedent are located. This time, pag Filipino, Article 17 is applicable. Lex loci celebrationis, where the will was executed, as long as that will is consistent with the law of the country where the will was executed, that will can be probated in this country. Pag ang tanong na examiner, may the will be probated, okay? Ang premise niya nun ay sa Pilipinas, okay? Unless the problem is very clear na may the will be probated in Japan, okay? Di ba? But normally, ang tanong should be Philippines. Actually, ang reason doon, anong alam natin sa law of Japan, di ba? Why would he ask a question on whether a will may be probated in Germany? Ibahala ang law on Germany if that will can be probated or not, okay? Now, does this one again? Ex-Filipino muna, but a permanent resident of Canada suffered heart attack, similar facts, survived American citizen. He left property in Philippines. He left a will which he executed in London. The will may be probated if it was executed in accordance with the law of the United States dahil American citizen ang asawa niya, or the law of Japan because he died in Japan, or the law of Canada because he's a permanent resident of Canada, or Philippine law, or French law. As far as Filipinos are concerned, okay, aside from Article 17 and Article 815, 815 would tell us that a Filipino who is abroad may execute his will in accordance with the law of the place where he may be, which is consistent with Lex loci celebrationis, di ba? But there is nothing in the Philippine law which would tell us that a Filipino may who executed his will abroad may execute his will in accordance with Philippine law. Walang problema dito sa Pilipinas because that would be Lex loci celebrationis. But if the Filipino, as in this, he executed the will in London, okay? May he execute such will in accordance with Philippine law? I would fully agree that to the position that he may validly execute his will in accordance with Philippine law because that right is given to aliens. Okay? Under Article 816 and 817, an alien may execute his will in accordance with his national law. So why would if aliens are given such a right, why would Filipinos not be given also such a right, di ba? Parang second citizen naman ang ating mga kababayan sa sariling batas natin, which I cannot also agree, okay? Kaya that would be a good reason why Philippine law would be the answer, okay? In the first place, we should even be happy, okay, that he's a Filipino and he is abroad, pero alam niya ang Philippine law, okay? Yung mga nasa bansang ito nga, hindi alam kung anong Philippine law. Kaya, dapat matuwa tayo sa kanya, okay? But also, it's because more often than not, he is there para kumita at mga Pilipino sa bansang ito ang nag-benefit, di ba? So, why can't we not afford him such right, okay? To execute his will in accordance with Philippine law. Now, so, a bar exam question. One is a Filipino citizen residing in Tokyo, Japan. State what laws govern his successional rights as regards his deceased Filipino father's property in Texas. The intrinsic, extrinsic validity of the last will and testament which the one executed while sojourning in Switzerland, and the intrinsic validity of such will, of said will. So, into the number 2 question, his successional rights. What laws govern? Okay? Philippine law, because one is a Filipino? Or is it Japanese law, because one resides in Japan? Or U.S. law, because the property is located in USA? Or Philippine law, because the deceased is a Filipino? Letter A is really wrong, because Juan is not the deceased. Okay? Juan is the heir. Okay? It is the father, his deceased Filipino father's property, okay, which is to be distributed. Kaya it is the national law of the deceased, okay. It is Philippine law because the deceased is a Filipino, again under Article 16, Paragraph 2, okay, in relation to the successional rights, okay. But as to the second question, parang wala. Extrinsic validity of the last will and testament. Parang something went wrong. Okay? Ang sagot dito, extrinsic validity of the last will, it may be executed in accordance with Swiss law. Okay? Because of Lex Loci Celebrationes or Article 815. Pareho lang effect niyan. But he may also execute his will in accordance with Philippine law, as I mentioned earlier. Okay? Now, the last one, intrinsic validity. Clearly, intrinsic validity of will. This is the will of Juan. It is Philippine law because Juan is a Filipino. Okay? Siya ang testator. And this is again, Article 16, Paragraph 2. And then this one, last year. Any disposition made upon the condition that the heir shall make some provision in his will in favor of the testator or of any other person shall be void. Here, both the condition and disposition are void. What principle is being referred to? Okay. If the examiner did not mention the nationality of the testator, you can presume that the decedent is or the testator is a Filipino. And therefore, it should be Philippine law which should govern. And under Philippine law, ang principle na ito is known as disposition captatoria, okay? Which is a void disposition. Now, also last year, this one, if a will is executed by a testator who was born a Filipino but became naturalized Japanese citizen at the time of his death, what law will govern its testamentary provisions if the will is executed in China and the property being disposed is located in Indonesia? Apparently, the question will govern testamentary provisions. It pertains to the intrinsic validity. And because hindi na siya Filipino, naturalized Japanese citizen na siya, the answer is Japanese law, okay? It is the national law of the decedent which shall govern, okay? Now, ito, inano ko lang pala sa extrinsic validity. It is Philippine law or Swiss law. Again, because of Lex Loci Celebrationes and because he is a Filipino, okay? Now, another one. Last year also, Attorney Buko, a Filipino, executed a will while he was in Spain. The attestation clause of said will does not contain Buko's signature. It is valid, however, under Spanish law. As its probate in Manila, it being opposed on the ground that the attestation clause does not contain Buko's signature, is the opposition correct? Letter A, yes, because it is a fatal defect. Letter B, yes, the will is not valid under Philippine law. Letter D, no, attestation clause is not an act of the testator. Letter D, no, the governing law is Spanish law. Okay? It's about the attestation clause. It's about the formalities. Okay? Pag formalities, then the correct answer here, if not the best answer, is letter D, that the governing law is Spanish law. Actually, nagkataon kasi that it is valid under Spanish law. A will may be executed as to form in accordance not only with one, but maybe with two or three, or even four laws. Okay? And as long as it is valid in accordance with one, okay na yan. That may be probated in this country. It doesn't have to be valid in two, in three, in four laws. magkakaibang batas, napakahirap naman gawin yon. Okay? So, here, even if under Philippine law, can he execute his will in accordance with Philippine law? Yes. But if you will consider Philippine law, that will would be void. But because, strictly speaking, but Philippine law actually allows, okay, this person to execute his will in accordance with Spanish law, okay, where the will was executed. So, in Philippine law, it appears even also to be valid. Okay? So, hindi totoo ito na is not valid under Philippine law because our law allows him to execute his will in accordance with the Spanish law or the law where the will was executed. Okay? Now, a Filipino executed a will in Kuwait while there as a contract worker. Assume that under the laws of Kuwait, it is enough that the testator affixes his signature in the presence of two witnesses, and that the will need not be acknowledged before a notary public. Okay? May the will be probated in the Philippines. Okay? Executed a will, laws is enough. Okay? May the will be probated? The answer is readily yes. Okay? But the reason yes, because A is a Filipino, or yes, under the Lex Loci Celebraciones, no, because the will shall be governed by Philippine law, or no, under the domiciliary law. Okay? The best answer here is letter B, under the Lex Loci Celebraciones. But actually, okay, you can answer also this question. May the will be probated? Yes, depending on the kind of will. Okay? If this is a holographic will, then there's no need for these witnesses, 3 witnesses. There's no need for acknowledgement. But even as a notarial will or an ordinary will, the will may still be probated, okay, in accordance with the Lex Loci Celebraciones principle, because it is valid under the law of the place where it was executed. Okay? Now, again, itong mga witnesses, acknowledgement goes into the formalities. Okay? Then, this one is a good question. If a will is executed by a testator who is a Filipino citizen, what law will govern if the will is executed in the Philippines? And what law will govern if the will is executed in another country? Explain your answers. Okay? Yung number 2 dito sa question, okay, is if the will is executed by a testator, he is an alien. Okay? But let's start with Filipino. If the question, and I would tell you there have been so many such questions, what law will govern? Okay? Always consider that there are 2 aspects as far as the validity of wills. May intrinsic, may extrinsic. You should be able to cover both. Kung i-cover mo lang isa, I will not get full points. Okay? So, pag ang tanong, what law shall govern the validity, may intrinsic dyan, may extrinsic. Pag Filipino, which is the correct answer, if executed the Philippines, a Philippine law both as to intrinsic and extrinsic, okay na ba yan? Or, if executed the Philippines, the law of the place where the properties are located, both as to intrinsic and extrinsic. Letter C, if executed abroad, the law of the place where the will was executed, both as to intrinsic and extrinsic. And letter D, if executed abroad, the law of the place where the properties are located, both as to the intrinsic and extrinsic. The worst options, in a way equally mali, ay B and letter D. As to the 2, parehong mali. Okay? As to the intrinsic, mali. It's not the law of the place where the property. As to the extrinsic, hindi rin. Okay? Ganon din dito. Even if executed abroad. Okay? In other words, ito at least tama ng isa. If executed abroad, it is the law of the place where the will was executed, but only as to the extrinsic. As to the intrinsic, it has to be Philippine law because he is a Filipino citizen. Again, under 816. Ito is the correct answer, letter A. As to intrinsic, this is Article 16, Paragraph 2. As to extrinsic, this is Lex Loci Celebraciones, Article 17. Okay? Now, kung foreigner, for instance, a Japanese, residing in the Philippines, what law will govern if the will is executed in the Philippines? And what law will govern if the will is executed in Japan or some other country, for instance, the United States? This is a good question because it requires yung distinction as to a will executed by a foreigner abroad and a will executed by a foreigner here in the Philippines, because the applicable provisions are different. Sa a will executed by a foreigner abroad, it is Article 816. But if the foreigner executed the will here in the Philippines, it is 817 that should be applied. Okay? Thus, to the first, if executed in the Philippines, Philippine law both as to intrinsic and extrinsic, which is wrong, because as to intrinsic, it has to be Japanese law. Okay? Dahil Japanese citizen siya. As to extrinsic, it doesn't even have to be Philippine law only. Okay? Even if not consistent with Philippine law, as long as consistent with another law, pwede pa rin. Okay? Letter B, if executed in the Philippines, only Japanese law, both as to the intrinsic and extrinsic. Mali, as to extrinsic. Kasi as to intrinsic, tama yan. Japanese law lang yan. Okay? Pero the word only in reference to extrinsic, mali. Okay? Because he has other options. Okay? He may execute his will in accordance with other laws. Ang sagot nandyan sa isa. If executed in the US, okay? If executed and executed in Japan or any other country, for example, US, Japanese law as to intrinsic, tama yan. And Japanese law, Philippine law, or US law as to extrinsic, that is really correct. Okay? In other words, if a foreigner, okay, executed the will abroad, Article 16 would allow him to execute his will in accordance with Article 16, tatlo lang, okay? His national law, his domiciliary law, or Philippine law. But, isama mo ang Article 17, Lex Loci Celebraciones, 4 ang kanyang options. As long as his will was executed in accordance with one of these 4, that will can be probated in the Philippines. That can be a valid will. Okay? Kaya ito Japanese law kasi he's a Japanese citizen, national law. Kaya Philippine law dahil Article 16 nga also included. US because Lex Loci Celebraciones. Okay? Although, ang residence niya is also Philippines, nagkataon. Kaya walang pang-apat na law. Okay? Kung nag-residence siya ng Canada, pwede pa. Law of Canada. Okay? But ang intrinsic is always Japanese. Okay? Under Article 16. Only Japanese law, really wrong. Wrong as to extrinsic. Okay? He may execute his will in accordance with Philippine law. Yun lang. Kasi residence yung domiciliary Philippine law din yun eh. Okay? Tapos, he executed the will in the Philippines. In Japan, pwede rin, hindi rin US, kasi US, iba ito, okay? If he executed the will in US, Lex Loci, okay? Now, then, this one. Ex-French national but a permanent resident of Canada suffered heart attack, died in Japan, etc. He left a will which is in London. The will of X cannot be probated if it is executed in accordance with. Isa lang dito ang mali. Okay? So, cannot be probated. Philippine law, pwede kasi French national siya. And he executed the will abroad. So, he may execute this will in accordance with Philippine law 816. Law of Japan, yes. No. Law of Canada or British law or French law, he cannot if it was in accordance with the law of Japan. Because ang law of Japan is only the law of the place where he died. Nothing to do with either intrinsic or extrinsic. Doesn't matter kung saan siya namatay. Ang place of death may matter in relation to the venue sa korte natin. Okay? But not as to what law should be applied. Okay? Bakit law of Canada? Because he's a permanent resident of Canada. This is domiciliary law under Article 816. Of course, Philippine law is in 816. British law is because he executed the will in London, so Lex Loci, and French law is the national law. Okay? And then last year again, Pedro and his wife Jane, who is an American, Pedro Filipino, executed a joint will in Canada where such joint will is valid. Now, in case the joint will is probated in Japan, what law will govern the formalities of the joint will? Anong pinakatamang sagot dito? Okay? Is it American law dahil Jane is American, Philippine law dahil Filipino siya, Canadian law, or Japanese law? Okay? Well, even the experts, when we discuss this answer kay sa UP Law Center, medyo tingin ng iba, di maganda ang tanong, okay? Because it is a will to be probated in Japan. Diba? Pakialam natin dyan, di ba? So, bahala ang law of Japan, okay? In order to consider. Baka yun lang naman ang ibig sabihin, okay? Kaya lang, there will be no question. There can only be a question here in the Philippines in relation to this matter if the probate is here in the Philippines. Diba? Is in Japan, ay bahala ang batas ng Japan if that will can be probated in Japan. But, kung gustong i-probate sa Pilipinas yan, it will be Philippine law which will govern. Okay? Whether pwede ba ang law of Japan, pwede ba ang law of the United States, dahil Philippine law should govern. Now, another one, mahilig siya sa mga governing law, okay? The will of a Filipino executed in a foreign country cannot be probated in the Philippines, may be probated in the Philippines provided that properties in the estate are located in the Philippines, or cannot be probated before the death of the testator, or may be probated in the Philippines provided was executed in accordance with the laws of the place where the will was executed. Okay? Cannot be probated, sobrang sama naman yan. Diba? Pinoy na nga siya, cannot be probated in the Philippines. Ang question lang naman is what law shall govern if the probate proceeding is, the probate petition is filed in the Philippines. Ito, cannot be probated before the death ay hindi na totoo under Philippine law. 2012 ang exam, hindi naman sinabi kailan final ang petition. It is now under the Civil Code of the Philippines, and the Civil Code allows ante mortem probate. Okay? Parang si Doña Chito Madrigal. Pinaprobate niya ang will niya before she died. Okay? Kaya hindi totoo ang letter C. Which one is the correct answer? May be probated provided the properties in the as allocated, or may be probated provided it was executed in accordance. I told you a while ago that there is no sense filing a petition for the probate of a will in relation to a decedent if he doesn't have properties in the Philippines. Kaya parang letter B ang tamang sagot, but actually I will consider letter D to be a better answer, that it may be probated, provided was in accordance with the laws of the place. This one, provided the properties in the estate are located, it doesn't have to be all the properties of the decedent. Okay? Maski isang lupa lang ang nandito, kailangan i-probate ang will. Okay? For the distribution of that land to the heirs. So, kung iba niyang properties nasa Malaysia, nasa China, okay, the will still may be probated in the Philippines. Okay? That's why I consider this a better answer. Now, ito na ang rules. Okay? As to form, and the testator is an alien, and he executed the will abroad, apat ang choices niya. Okay? It's not and, it is or. Okay? In accordance with any of the four. Lex loci celebrationes, Article 17, the law of the place where the will was executed. Lex domicilii or the domiciliary law, the law of the place where he resides. This is Article 816. Okay? Ang premise ko ay the alien executed the will abroad. Okay? Now, lex nationalii, the nationality principle, the law of the place where he is a national, and Philippine law is under 816, again, if he executed the will abroad. But if he executed the will here in the Philippines, dalawa lang ang choices niya under 817. He should execute his will either in accordance with his national law or Philippine law. But Philippine law is consistent with Article 17, Lex Loci, because he executed the will here in the Philippines. Ang wala lang sa 817 ay domiciliary law. Okay? He may not choose to execute his will in accordance with the law of the place where he resides. Okay? Now, this one, into the another bar exam question, which is a good question. December 1, 2000, Dr. Juanito Fuentes executed a holographic will wherein he gave nothing to his recognized illegitimate son, Jay. Dr. Fuentes left for the U.S., passed the New York medical exam, resided therein, and became naturalized American citizen. He died in New York in 2007. The laws of New York do not recognize holographic wills or compulsory heirs. The first question, can the holographic will of Dr. Fuentes be admitted to probate in the Philippines? Why not? Pag sinabing probate, that goes into the extrinsic validity. Okay? Pero siyempre, assuming the will is probated, can J validly be given his legitim? This obviously pertains to successional rights. Okay? Now, into the first, can the holographic will of Dr. Fuentes be admitted to probate? Take note, under New York law, it does not recognize holographic wills. The options, yes, because an alien can execute his will in accordance with Philippine law. Okay? Or yes, because he was a Filipino when he executed the will. No, because the laws of New York do not recognize holographic wills. Or no, because the will is intrinsically void. Take note, it is a probate in the Philippines, kaya dapat Philippine law. And under Philippine law, as far as the extrinsic validity is concerned, what should be applied is the law at the time of the execution of the will. At the time of the execution of the will, he was a Filipino. And can a Filipino validly execute a holographic will? Yes. Okay? So it's not because he is an American, okay, or an alien, but it is because he was a Filipino at the time of the execution of the will, okay. As to the formalities, okay, it is the law at the time of the execution, okay. Sa mga successional rights, it's the law at the time of the death. So it's his citizenship at the time of the death. Kaya sa pangalawang tanong, assuming the will is probated, can J validly insist that he be given his legitim? The answer is definitely no. Okay? Because New York law shall apply. And under New York law, there are no compulsory heirs. Sabi, there are no compulsory heirs and only compulsory heirs have legitims. Okay? Yung ibang option, yes, because a compulsory heir cannot be deprived of his legitim, but as mentioned, it is the law at the time of his death which should be applied. At the time of his death, he being already a citizen of New York, it is the national law of the decedent, which is New York law, which is applicable. And under the law of New York, walang legitims. Okay? Yes, because J was preterited. Preterition is a concept which presupposes that he is a compulsory heir. Kung wala nga compulsory heir, so walang preterition. Okay? So in so many countries, walang concept na preterition. Okay? I would want to believe the Philippines is one of the few countries na would still maintain yung mga compulsory heirs. Okay? Now, no, because he was validly deprived. Again, he cannot be deprived if he doesn't have it in the first place. Okay? And the answer is letter D. This one is also a good question. Okay? Alex was born a Filipino but was naturalized Canadian citizen at the time of his death. Okay? Left behind a last will and testament in which he bequeathed all his properties, real and personal, in the Philippines to his acknowledged illegitimate Filipino daughter and nothing to his two legitimate Filipino sons. The sons sought the annulment of the last will and testament on the ground that it deprived them of their legitimes, but the daughter was able to prove that there were no compulsory heirs or legitimes under Canadian law. Who should prevail? Okay? The daughter, because his two sons were validly deprived. The daughter, because Canadian law shall apply. Or the two sons, because they cannot be validly deprived. The two sons, if the will was executed when Alex was still a Filipino. Itong letter D is really wrong, diba? Because it's about the form. Okay, it's not about what will be the share in the inheritance. Okay, so it has nothing to do with the question. But this one are really wrong, letter A and letter C, because the premise of these options, the two sons are compulsory heirs na may legitimes. Therefore, they cannot, they were validly deprived. Wala kang i-deprive sa kanila eh. But ito cannot be validly deprived. In the first place, there's nothing to be deprived of. Okay? Because the daughter should prevail because Canadian law shall apply, and under Canadian law, there are no compulsory heirs, walang legitimes. Therefore, the testator can give his entire estate to anyone he pleases. As long as that person has the capacity to succeed, then that person may inherit. Okay? Now, then an Englishman who had resided in the Philippines for a long time executed a will in France disposing of his real and private properties in the Philippines. What law governs the validity? Again, always consider the two aspects. Okay? Ang sagot dito, as to the intrinsic validity, it is English law because the decedent is the testator. Okay? Is a citizen of England, okay? And under Article 16, it is the national law of the decedent that should govern the intrinsic validity. But as to the extrinsic validity, the Englishman may execute his will in accordance with English law, in accordance with French law, and or in accordance with Philippine law. Tatlong batas, okay? Makachamba siya sa isa, okay na. That will can be probated here in the Philippines. Okay? English law, Philippine as to the extrinsic validity. Ang mali dito as to intrinsic. Okay? Only English law as to mali dito sa extrinsic naman. Because only English law as to intrinsic and extrinsic. As to intrinsic, but only, ang word na only ang mali. Okay? It's not only the lex loci celebrationis. You should apply 816. Okay? Mga second to the last. X, a Spanish citizen resident of Los Angeles, California, executed a will in Tokyo. May such will be probated in the Philippines. May his estate located in the Philippines be distributed in conformity with the provisions of the said will. Again, pag may lang naman ang tanong, kung pwede naman, your answer should be yes. Walang it depends sa sagot. Okay? May the will be probated? Yes. As long as it is in accordance with Spanish law, or in accordance with law of California, or in accordance with the law of Japan, or in accordance with Philippine law, then it may be probated in the Philippines. Ang dapat na ilagay nyo ay or, hindi and. Okay? Pangalawa, may SSL can be distributed in conformity to the provisions? Sure, why not? As long as it is in accordance with his national law, Spanish law. Diba? As to the distribution of his estate would go into the intrinsic validity. Okay? Kaya, yes, if executed in accordance with Philippine law as to the first, probate in accordance with the law of Spain, in accordance as to extrinsic, intrinsic, okay, sa Spain. Now, this one, Michelle, the French daughter of Heinrich, a German national, died in Spain, leaving real properties in the Philippines as well as valuable personal properties in Germany. What law determines who shall succeed the deceased? Who shall succeed goes into the, you can either consider this the capacity to succeed at saka the order of succession. Okay? Kasi sa order of succession, some heirs may be excluded by the others. Okay? But capacity to succeed, he may be an heir, even a compulsory heir, but he may not succeed because he's incapacitated. Okay? What law regulates the distribution of real properties in the Philippines? Okay? What law governs the distribution of personal property in Germany? Okay? We are talking here about death. Okay? Namatay. So mukhang succession ang problem. Okay? Kaya, as of the first, what law shall succeed? It will definitely be, ang common na maling sagot dito ay German law. Kasi Heinrich a German. Okay? Which is wrong. Kasi ang namatay dito ay si Michelle. Okay? Michelle, the French daughter of Heinrich, died in Spain. Ang namatay ay hindi si Heinrich. Ang namatay ay si Michelle. Okay? So read the facts so carefully. Okay? Ang pinaka-importante, I would always say, sa succession, ang pinaka-star, in fact, superstar, ay ang namatay. Okay? Totoo yan. Kasi tingnan nyo sa lamay, sinong star? O di ba ang patay? In fact, in one of those wakes, sa mother ng kaibigan ko, a really good friend, okay? Hindi ba pag pumapasok ang mga nakikilamay, pupunta ka agad sa relatives, either asawa, anak, at magpapakwento ka agad yun, bakit namatay? Anong namatay? Sabi ng isang anak, yung kaibigan ko, naku, si Papa, pagod na, sa kakukwento ng bawat pumapasok kinikwentuhan kasi cancer din, matagal ang struggle. Sabi niya, nag-recommend na nga kami sa Papa i-video na lang niya para lahat ng papasok nandun na, naka-video na lahat ng kwento ng namatay, bakit siya namatay, etc. Although, tingin ko tama yung nangyayari na every time may papasok, nagkukwento, because it relieves the person ng lahat-lahat ng mga burden. Iyon ang way para mailabas-labas niya. By the time mailibing na yan, wala na, okay na cool na yan. Diba? Lahat ng mga hinanakit dyan, mga pinaghirapan, na ilabas mo na, nasabi mo na, inakwento mo na sa 1,000 pumasok sa wake. Pero yung wake na yun is the only wake na napasukan ko na unusual. Okay? Ang pinaglalamayan, hindi yung katawan. Ang pinaglalamayan niya ay ang ash. Okay? Hindi ko napansin nung una. Kaya nang later bakit walang ataol? Yung pala ash na inuna nilang crenimate bago nagkaroon ng wake. Which is iba, di ba? Ang usual ay saka na-cremate after ng wake. Okay? Pero sila iba. Kanya-kanyang trip lang ito, pati sa patay. Now, the answer therefore is French law because this goes into the order of succession under Article 16 or this may go into Article 39, capacity to succeed, so French law. Yung ibang mga tanong, what law regulates distribution of real properties? It will still be French law, okay? Does it matter kung real property or personal property? It doesn't matter. It will still be the national law of the decedent. It will still be French law. Okay? Kaya ito na yata ang last into the governing law. Pursuant to private international law or conflict of laws. Okay? To what law is real property as well as personal property subject? Are there any exceptions to the rule? If there are, name them. Tapos, what are the 4 aspects of succession which are governed by the national of the decedent if he is a foreigner? and then this problem, okay? Into the first, okay? Pursuant to private, international, or conflict of laws, to what law is real property as well personal subject, as mentioned earlier, this is the first paragraph of Article 16. It is the law of the place where the property is located, which is lex re site, okay? Or lex situs, okay? Now, but are there exceptions? There are many exceptions. At ang exceptions, basically, nasa succession, okay? Ang exceptions, nasa pangalawang tanong, okay? What are the 4 aspects of succession? Again, governed by the national law, 3 nasa Article 16, yung isa nasa Article 1039, okay? Capacity to succeed. Article 16, order of succession, amount of successional rights, intrinsic validity. Basta basahin nyo ang facts because the facts will tell you ano ang problema. Baka nasa intrinsic validity, baka nasa amount, baka pinaglalabanan nila amount lang, okay? Thus, into the last, okay, letter C. A citizen of California, USA, but domiciled in the Philippines, died testate in Manila, survived by 2 acknowledged natural children, B and C. In his will, he left more than 500,000 to B and only 3,000 to C. It is admitted that under the Civil Code of California, the domiciliary law of the decedent shall govern questions involving the validity of testamentary provisions. C, who is contesting the validity of the disposition in favor of B, now contends that the Philippine laws with respect to succession are applicable. Is this correct? If you consider the facts carefully, this is, I am sure, based on the case of Christensen, Christensen. Yun lang, hindi 500,000 ito. Walang exact figure. Pero malinaw na 3,000 ang ibinigay kay Helen Christensen. Only 3,000. But Helen Christensen claimed that despite the fact that his father died as a citizen of California, it should be Philippine law that should be applied. In the distribution of the estate, the civil code provision should be applied. Tama ba si Helen Christensen? Okay? As in this problem, is this correct? The answer is yes. Okay? Under the Renvoi doctrine. Okay? Because we adhere to the nationality principle, okay? So our law will refer the matter to the national law of the decedent, which is the law of California. But the law of California is specifically yung kanilang external law, okay? In a way, as discussed in the case, California law, in a way, there are 2 laws. May internal, may external. The internal law would pertain to the rules as to the disposition of the estate of their citizens who are residents in their country. But yung external are the rule which provides for the applicable what law should be applied as to their citizens who are domiciled abroad. Ang nakalagay sa kanilang, in a way, external law as to their citizens domiciled abroad, their estate shall be distributed in accordance with the law of the place where they are domiciled at the time of the death. Nagkataon si Christensen, as in this case, was domiciled in Manila at the time of his death. Therefore, applying the Renvoi doctrine, in other words, referring back, okay? Ni-refer na natin sa law of California, but the law of California refers the matter back to Philippine jurisdiction. Then, Philippine law being applicable, Helen Christensen is not only entitled to 3,000 because the estate is a much bigger estate, and with Philippine law, she is entitled to her legitimate, okay? Ang illegitimate child could be much more than 3,000 in this case, okay? Now, take note, the Renvoi doctrine is not inconsistent with the nationality principle, okay? It is consistent with our law kasi in-apply natin ang ating batas, we refer the matter back, kaso na-refer naman ng law nila sa atin, okay? Under the Renvoi doctrine. Yun nga lang, what if, instead of what if the decedent was a citizen of California, but at the time of his death, he was not domiciled in the Philippines? What if domiciled siya sa Malaysia? Okay? What would happen is, we would refer the matter to law of California, but the law of California would refer the matter to a third country. Okay? Ang tawag dito ay transmission theory. Okay? Hindi na ito covered ng Renvoi doctrine. Okay? Kaya ang sagot dito ay yan, Renvoi. Lex recite, as I mentioned, is just a general rule not applicable to succession. Okay? No, if the internal law do not recognize legitimacy, it doesn't matter kasi internal law applicable only to their citizens domiciled in their country. Okay? Under transmission theory, not applicable because it was referred back to the Philippines, not to a third country. Okay? Now, thus, we go to the subjects. Okay? After the governing law, when we discuss these topics, ang premise ko niyan ay Philippine law. Okay? We are now into Philippine law on all these matters unless sabihin ko na ito ang law ng Pennsylvania, etc. Dahil sa kaso lang yan. Not because I studied the law of Pennsylvania. Okay? Now, subjects. Okay? Who are the subjects of succession? I already told you whom I consider the superstar in succession. It is the decedent. Why I would always ask you to focus on the decedent? It's because it is his properties which are to be distributed, diba? Sa kanya naman yun eh, okay? But pangalawa, everybody else, yung relationships would depend on him. Pag sinabi ng examiner, those are the five are the father, the sister, the cousin, lahat yun, the father of the deceased, the cousin of the deceased, the daughter of the deceased, unless otherwise provided or stated by the examiner. Kasi minsan sasabihin ng examiner, A is the brother of the wife of the deceased, mga ganyan. E di syempre, hindi siya brother ng deceased. He's just the brother of the wife of the deceased. Okay? Otherwise, lahat yan, father, mother, brother, nakafocus sa deceased. Okay? But, deceased, or should he be called the testator? Okay? If the person who died, if the decedent executed a will, by all means call him a testator. Okay? Do not merely call him a decedent. Because you should have it in your mind that a will was executed. Okay? Does it matter if the will is void? It doesn't matter. The fact is there is that will. Why? Would there be a difference kung total void naman? Baka wala ding silbi. Baka naman we can consider him to have died intestate. When we say he died intestate, it means he died without a will. You can never call him a testator. Okay? But if he executed the will, you should call him still the testator. Why? Because there may be some effects as to that will. Example, if you remember the case of this De La Serna versus Potot, the will was probated. Even if the will, the properties of the decedent, one of the testators here, were validly distributed in accordance with that will, which is extrinsically on its face void. Kasi joint will executed by Filipinos. The will should not have been probated. But nonetheless, it was probated. The judge released this decree of probate and no one questioned. Naging final and executory ang decree. Kaya, would that bind everyone? Lahat bound. Okay? No one can question that decree even if it is erroneous. Kaya, wala. The properties have to be distributed in accordance with that will, even if the will is void. In other words, may hawak-hawak ka na will, maski tingin mo void, gusto mong ipaprobate, why not? Baka biglang inapprove ng korte, prenovate ang will, okay? But the other one is, if you remember a rule here, in that will, okay? If this is it doesn't matter whether it is holographic or notarial, okay? But if an illegitimate child is recognized in that will have an effect, even if the will is void, okay? So, kung ikaw ang lawyer ng illegitimate child and the child was not recognized by the deceased, hindi ka na masyado magpo-problema because even if the person is already dead, filiation may be proven because there is a public instrument recognizing the child as an illegitimate child. If you remember in person, in the family code, an illegitimate child can no longer cite the grounds for proving filiation under the second paragraph of 172 if the putative father is already dead, kung patay na, okay? Kaya mas mahirap mag-prove ng filiation ng illegitimate children kung patay na ang magulang, okay? Now, so, call him the decedent clearly only pag walang will, okay? Sinabi ng facts, he died intestate. I do not call him the testator, okay? Alam ka agad ng examiner, mukhang hindi mo alam ang sinasabi mo, okay? Pero kung may will, regardless of the validity, call him the testator, okay? Now, in other words, a decedent is a testator? Not necessarily, because he may have died without a will. But a testator is a decedent? Not necessarily, okay? Because a person is called a testator if he executed a will. Natural, buhay pa siya nung nag-execute siya ng will. In fact, pag nag-petition siya for the probate during his lifetime, ang tawag sa kanya, testator. Petitioner ang testator. Hindi pa siya patay, okay? But if he died with a will, testator din siya, okay? Di ba? Now, but, siyempre, ang pinaka may gusto sa topic na ito ay hindi ang testator, okay? Normally, ang may gusto sa topic na ito ay ang heirs, okay? Talagang sila ang interesante sa mga naiwanan, okay? Now, as to the heirs, okay? First, there are two kinds of heirs under the civil code, okay? There are two kinds, mayroong heir in the general sense, may heir in the specific sense, okay? A person who is called to the inheritance, okay, either by will or by operation of law, okay, called to the succession, okay, is an heir in the general sense. So whether that person is a compulsory heir, a legal heir, a legatee, a devisee, instituted heir, heir siya in the general sense, okay? But there are heirs in the specific sense. If you notice, there are some paragraphs nakalagay, some provisions sa civil code. Heirs, legatees, devices. In other words, from that provision, mukhang ang legatees and devices are not treated as heirs. Otherwise, that would be a redundancy. But kapag magsasabi ng heirs, devices, legatees, if devices and legatees are heirs, in the specific sense, an heir would be a person to whom an aliquot portion or the entire estate is given. In other words, kung ang binigay sa kanya is 1/2, 1/4, 1/8 of the estate, or maybe the entire estate, ang tawag sa kanya ay heir in the specific sense. A good example here are the provisions on institution of heirs. Doon sa mga provision na yon, ang heir dyan is in the specific sense. Hindi kasama dyan ang mga heirs who would receive a specific property, like a house and lot, motorcycle, etc. As to those heirs who would receive either personal or real property, ang applicable provisions nasa legacies and devices. Diba? There is a specific chapter on legacies and devices. Do not confuse a legacy from a device. Sa legacy, personal property. Pag device, real property ang ibinigay. Okay? Now, so more or less you know the different kinds of heirs, but of course, there are also heirs known as compulsory, voluntary, and intestate or legal. So, consider these problems, okay? The following are compulsory heirs of X, a Filipino. Okay? Except surviving spouse, illegitimate child, grandchild by legitimate son, brother, legitimate daughter. Okay? Again, if the examiner did not mention the date, okay, the relevant date, consider that even the date you took the exam. Okay? So at the time you took the exam, hindi pa naman siguro mababago ang batas. Okay? The answer here. But some would have this misconception. Illegitimate children are not compulsory heirs. Or, mas common, illegitimate children were considered compulsory heirs only under the family code. Maling-mali. Okay? 1950 pa lang, compulsory heirs na sila. Okay? Under the Civil Code of the Philippines, they have already been considered compulsory heirs. Okay? Kaya hindi ito ang sagot dahil except, okay? Grandchild by legitimate son, brother, legitimate daughter, brother is the correct answer. Hindi compulsory heir ang kapatid. Ito, grandchild by illegitimate son. Compulsory heir ba siya? He is a compulsory heir. Ang sabi ng batas, legitimate children and descendants. In other words, as long as legitimate siya, okay, he is a compulsory heir under 887, but do not confuse yung pagiging compulsory heir niya sa pagmamana niya. He may be a compulsory heir, but he may not inherit for one reason or another. As I would say, there are 1,000 reasons why an illegitimate child a compulsory heir may not inherit. Ang pinaka-obvious, ayaw niyang magmana. Diba? Trip lang niya. Okay? He would renounce his share. Ba't siya magmamana? Ayaw nga niya Pipilit ba natin siya? But there are many other reasons which we will be discussing, okay, as we discuss the law on succession. Okay? I will discuss the reason why hindi siya compulsory heir in a way. Pero ang who are compulsory heirs are enumerated in 887. Okay? But if he is not one of those mentioned, would he be considered as a compulsory heir, or may this person have the rights of certain compulsory heirs? The answer is yes. Okay? Marami pang iba. Like legitimated child, like adopted child, like a child by artificial insemination. Okay? Kaya, pero try to really understand 887. Okay? Unahin nyo ang 887. Now, this one. Of the following who survived X, who will not inherit if X died intestate? In other words, ang tanong dito ay, who are the intestate heirs? Also called the legal heirs. Okay? Who will not inherit, mukhang hindi siya intestate heir. Okay? Letter A, surviving spouse. B, illegitimate child. C is grandchild by legitimate son who predeceased. Letter D, legitimate daughter of his son who predeceased. Letter E, legitimate daughter. Okay? Ang sagot dito ay letter D. Okay? Take note, even under 887, hindi siya compulsory heir. Kasi kailangan legitimate children and descendants. Hindi siya legitimate. Okay? But other reason here is Iron Curtain Rule. Okay? In intestate succession, an illegitimate child cannot inherit ab intestato from the legitimate relatives of his parents. Pag if the heir was mentioned, okay, like the child of, okay, and there is nothing in the facts which would lead you to the conclusion na illegitimate, okay, then you should presume na legitimate siya, okay. Especially kung nakalagay, the spouses, mag-asawa, you presume that the marriage is a valid marriage. Okay? Kaya ang anak nila ay legitimate. Sasabihin naman ng examiner na the child is a child by his girlfriend, o mukhang hindi mag-asawa, di ba? Kaya the child may be illegitimate. Okay? Now, into this, the legal heirs of X a Filipino are, again, even if the examiner would not say a Filipino, you can presume na Filipino siya. Okay? Alangan naman ang tanong niya hapon, okay? Ang namatay. The cousin of his grandmother, great-grandchild, first cousin, brother, child of sister, okay? Legal heirs, okay? Sino ang hindi legal heir or intestate heir? Letter A, the cousin of his grandmother. Because ang legal heirs, as to the collateral line, would only extend up to the 5th civil degree, okay? So dapat you know how to compute, okay? Yung mga degrees. Una, okay? Into the compulsory heirs, into the direct line, walang limitation ang batas. Hindi sinabi ng batas na as far as the ascending or descending, they are within the 5th civil degree. Wala. Okay? In other words, even if that heir is 6 degrees removed from the decedent, he is still an heir. Okay? And he may inherit. Kaya lang, syempre, pag 6 degrees removed siya, more often than not, nung pinanganak siya, matagal nang patay ang person whose property is under consideration. In other words, in real life, sa physical limitation ng tao, okay, ang usual ay, if ever mayroon, ay hanggang dito lang, di ba? 2 degrees. In the direct line, a degree is by generation. In other words, the son is 1 degree removed from his father. Okay? Isang henerasyon. And therefore, the grandchild is 2 degrees removed from the grandfather. Okay? Kaya lang kung 6 degrees, C, D, E, F, pwede pa ba si F? 1, 2, 3, 4, 5, 6 degrees na si F from X. Ang requirement for F to inherit is he must be living at the time of the death of X. Can that happen? It can happen. Okay? Mathematically, pwedeng-pwede. In fact, my mother, hanggang dito na siya. Okay? Ito ang tawag natin sa Tagalog, apo. Di ba? Ito ay apo sa tuhod. Ito ay apo sa paa. Ito ako sa ilalim ng lupa. Okay? Pababa ng pababa. Okay? But take note, especially those who were married under the Civil Code of the Philippines, and I will always tell you, yung tunay na mga namamatay ngayong mga araw na ito, except for a few. Okay? Normally, they were married under the Civil Code of the Philippines. Yung mga tatay nyo, buhay pa naman siguro. Pero they were married in the 50s, in the 60s, in the 70s. Kaya pwede silang nag-asawa at the age of 14 yung nanay nyo. 14 anyos pa lang. In other words, kayo, pinanganak kayo, 14 anyos siya, pwede. Kasi 13 pa lang buntis na. Nung kinakasal, manganganak na. O, diba? So, legitimate. Magbilang ka ng 14, 14, 14. By the time na conceive si F, si X may only be 80 years old. Diba? Kaya it is possible. Siyempre, nasa dugo nila, nasa gene sila, ang 14 pala nag-aasawa na. Diba? Talagang mana-mana lang ito. Okay? Ikaw nanay, 14 ka. So ako din, 14. Okay? Mag-aasawa. Pero in the collateral line, how do you compute yung degrees? You first go to the common ancestor. Okay? In the collateral line, ang pinaka-closest ay kapatid. Di ba? Pero ang magkapatid, ang common ancestor nila ay tatay or nanay or both. Okay? Kung pareho sila ng tatay at nanay. So you go up to the common ancestor. In other words, go up sa taong may kasalanan kung bakit ka nabuhay. Okay? So, you go up to the father and you go down to the person who is claiming to be an heir or who is the decedent, depende saan ka magsisimula. Walang difference. Okay? Although, personally, I would always recommend that you start with the decedent. Okay? Para malinaw na kaagad. May template na kayo kumbaga. Mula sa decedent, sino nag-claim na heir siya? Go up to the common ancestor nilang dalawa. Okay? In other words, ang first cousins, ilang degrees? Ang common ancestor nila ay lolo-lola. Di ba? And from you to your lolo-lola, 2 degrees. So yung pinsan mo pababa, 2 degrees din. Therefore, ang first cousins ay 4 degrees removed from each other. Okay? I'm not encouraged to use second degree, third degree. Parang first degree burn. Parang ganun ang dating. Parang may sunog o nasunog. Okay? 2 degrees removed from each other. Okay? 2 degrees. Pwede na rin. Okay? Kung nagmamadali ka. Okay? In other words, kung within the 5th civil degree, ang ina-allow in the collateral line, sino lang ito? Hanggang sa anak ng first cousin mo. Okay? In other words, my nieces, sa kapatid ng pinsan ko, sa pinsan ko, first cousin ko, are my heirs. But I am also their heirs. Patas-patas lang ito. Di ba? Pero more often than not, silang magmamana sa akin kaysa ako magmamana sa kanila. Pero malay natin, mauna sila kaysa sa akin, di ba? Yun na ang buhay. may tita was there sa St. Peter's. My tita is already 80 plus. Pero nauna pa sa kanya ang pamangkin niya. O di ba? Sabi ng tita ko, panahon lang yan. Una-una lang yan. Okay? Inauna ang pamangkin. Okay? But, aside from the children of the children of first cousin, sino pang within the 5th? The brother of the great-grandfather. Okay? Ang grandfather mo 2. Ang great-grandfather mo 3. So, ang kapatid niya, 3 plus 2, 5. Ito, lolo, tapos tatay ng lolo natin, di ba? In other words, tayo, apo sa tuhod. Okay? Pero may kapatid yon minsan o madalas. Okay? Kaya, yung kapatid niya, heir pa tayo niya. As much as reciprocity lang yan. Okay? We are the heirs of that person, but that person is also our heir. Okay? Kaya ito, ilang degrees ito? 6 degrees. Okay? Wala na. Ang 6 degrees would include second cousins. Kaya ang mga second cousins hindi na pwedeng magmana ab intestato by operation of law. Kung gusto mo magmana, will, through a will. Okay? Second cousin. Now, the legal heirs of ex of Filipino, widow, illegitimate child, child of first cousin, on, grandchild of first cousin. The answer is the grandchild of first cousin. Kasi ang first cousin mo ay 4 degrees. Ang grandchild niya ay 6 degrees. Kaya beyond the 5 degree limit. Okay? Now, ang widow, siyempre, is an heir. Child of first cousin, as I mentioned, ay 5 degrees. Eksakto. Within the 5th pa rin siya. Now, ang ilang degrees? 3 degrees. Okay? Kapatid ito ng tatay mo o ng nanay mo. Okay? So, 1, 2, 3. Okay? 3 degrees. Illegitimate child is a compulsory, is an even and compulsory heir. The following can be a voluntary heir, except compulsory heir, legal heir, the state, the dogs. Alam mo na ang sagot. Mukhang naiiba talaga siya. Pag iba pa ang nasagot mo, talagang wala na. But actually, you must have read articles na like in Britain, ang nagmana ay ang mga pusa na maraming pusa. Well, not in the Philippines. Okay? It cannot happen that a dog or a rat will inherit. Okay? But if you want your dogs to benefit from your estate, you can do that. Ibigay mo sa isang tao with an obligation to take care of those dogs. Okay? Pero siya magmamana. Okay? Ang tawag dito ay modal institution. Okay? So there is a purpose. Okay? Kung bakit mo siya pinamanahan para mag-alaga ng mga tuta. Yun yung rason. Now, private corporations by express provision. The state nag-appeal na ito sa bar exam. Okay? Even compulsory heirs, even legal heirs can also be voluntary heirs. Okay? And you should know in what capacity a person would inherit. Is he inheriting as a voluntary heir, or is he inheriting as a compulsory heir? Why? Ang isang magandang principle relevant ay right of representation. Okay? Because kung voluntary heir siya and he predeceased, do you think his heirs can inherit what he would have inherited had he not predeceased? Wala. Okay? Because until he dies, wala siyang mamanahin na pwede niyang i-transfer to his own heirs. Pero pag compulsory heir siya at namatay siya, yung heirs niya may inherit by right of representation. Okay? And we will discuss this right in detail mga next week. Next week, Doods. Okay? Thus, bar exam questions. Don died after executing a last will and testament, leaving his estate valued at 12 million to his common law wife, Rochelle. He is survived by his brother, Ronnie, and his half-sister, Michelle. Okay? In succession, pagdating sa distribution ng estate, I will always advise you na mag-drawing kayo. Unless yung brain nyo napakagaling talaga. Talagang alam na alam nyo kung nasaan ito, sino ito. Kaya lang minsan komplikado ang buhay. Just like sa bar exam, komplikado ang facts. You have to draw. Okay? In this scenario, ito yon. Wala pa ito, wala ito. Ito lang, yung apat na ito. Si Don, may common law spouse. Pero meron siyang full-blood brother, mukhang ito ang misconception. Na pag half-blood brother or sister, the half-blood brother ay illegitimate. That is not necessarily true. Okay? Dahil half-blood, hindi ibig sabihin ay illegitimate. Ang tawag natin, anak sa labas. Okay? Meaning sa labas ng marriage. Well, malay mo, nauna pa siya. Sa unang kasal siya. Okay? Namatay nga lang ang tatay niya, kaya ang nanay niya nag-asawa ulit. So there are children who are full-blood from the same marriage. Pero yung isa could be a legitimate child from another marriage, a previous marriage. Okay? Do not presume, okay? Unless the facts would lead you to that conclusion na kabit lang yung isang nanay, okay? Na paramour lang, okay? But this one, ang nag-survive si Ronnie, si Rochelle, si Michelle. Ang tanong, was Don's testamentary disposition of his estate in accordance with the law on succession? Whether you agree or not, explain your answer. Take note under the facts, he left his entire estate to his common law wife. Walang ibinigay sa kapatid at saka sa sister, sa half-sister. Okay? Is this in accordance with the law on succession? The problem requires you to know whether those who survived are compulsory heirs. Because if they are compulsory heirs, the testator cannot validly deprive them of their legitimes except through a valid disinheritance. Di ba? Without that, they would be entitled at least to their legitimes. Okay? Kaya, may compulsory heirs ba? The answer is no. Walang compulsory heirs who survived because Rochelle is not the lawful wife. Okay? Ang tawag sa kanya, common law wife. Okay? Pangalawa, si Michelle at saka si Ronnie, brother-sisters, they are not compulsory heirs. Okay? Therefore, the testator can give his estate to anyone he pleases. Kaya lang, ito ang options. Okay? Yes, because a testator can dispose all of his estate as he pleases. As general as that, hindi totoo yan under Philippine law. Because of the limitations provided by our law, specifically, pinaka-importante, legitimates. Okay? So you cannot, a person cannot freely dispose, lahat-lahat. Okay? Meron lang tayong tinatawag na freely disposable portion. Okay? Letter B, yes, because no compulsory heir survived Don. Or letter C, no, because Rochelle is only entitled to 6 million, one half of the estate, while Ron is entitled to 4 and Michelle 2. Ito, ang premise dito ay Rochelle is the lawful wife. Okay? Kung siya talaga ang kasal, asawa talaga, kalahati ang kanyang share, and the rest, the brothers would share depending on full blood or half blood. Okay, the half blood would get half the share of the full blood. Okay, but this one, no, because the testamentary disposition in favor of Rochelle is void as it is contrary to morals. Tama ba ito? Ibinigay sa common law wife, kaya contrary to morals. Hindi totoo yan. Okay? But that is a common misconception na pag common law ay kabit. Okay? Hindi kailangan maging kabit. Nagiging kabit lang siya if the person is married to another. But under the facts, si Don is not married. Therefore, yung common law spouse niya is just that they are living together without the benefit of marriage. It is not necessarily contrary to morals under our law. Baka sa Roman Catholic Church, that would be immoral. Nagli-live-in kayo, hindi kayo kinasal, but not under Philippine law. Okay? The answer is letter B, because no compulsory heir survived Don. Kaya pwede niyang ipamigay sa iba. But into the other questions, if Don failed to execute a will during his lifetime, as his lawyer, how will you distribute his estate? Pag ang problem, failed to execute a will, clearly, this person died intestate. Ang iisipin mo dapat automatically, who are the intestate heirs of this person? Okay? Doon sa tatlong ito, okay, sino ang intestate heirs? Kaya ito ang options. Okay? This one, ang premise dito, ito mali ka agad ito. Automatic nga ito eh. Yung tatlong ito. Hindi. Rochelle pala. Ang Rochelle is the common law spouse. Itong dalawa automatic mali. Because she is not married to the deceased. She will never have a share in the estate. Sa intestate succession. Okay? But, alin dito? Okay? Michelle 4 million, Ronnie 8, or hati sila? Well, there is a provision that as to full blood and half blood, okay? In intestate succession, the full blood will be entitled to twice the share of the half blood, okay? Kaya, practically, ang 12 million, i-divide mo lang into 3. Ang resulta para sa half blood, i-times to mo yung resulta para sa full blood. Okay? Therefore, si Ronnie, 8 million, si Michelle, 4 million. Maski hindi kayo marunong mag-mathematics, kaya nyo ito. Okay? Basta alam nyo lang ang principles. Okay? Dahil half blood yung isa, full blood, you will not give them equal. Dahil hindi sila kasal, you will not give Rochelle anything. Diba? Zero kaagad. Okay? Now, into the third. Assuming he died intestate, survived by his brother Ronnie, his sister, half-sister Michelle, his legitimate son, how will you distribute? I must have warned you already. In bar exams, dahil minsan dalawa, tatlo ang questions, sub-questions, okay? Yung the second, the third may modify the facts, okay? Pwede niyang baguhin ng konti ang facts. So yung dating nakalagay na set of facts, do not presume na applicable yan sa lahat ng tanong. Okay? As in this case, may panibagong sumingaw. Okay? May legitimate child na lumabas. Okay? So, how will you distribute this estate? Again, sino ang mga nag-survive? Legitimate child, brother, sister, wala. The legal heirs who are not compulsory heirs will be excluded by a compulsory heir. Meron lang isang compulsory heir who will not exclude collateral relatives maya-maya. Okay? Isa lang siya. All the other compulsory heirs will always exclude collateral relatives like brothers, sisters, nephews, uncles, aunties. Okay? Wala lahat yun. Kaya ang sagot, automatically, letter C, Jason, you should distribute the estate in this manner, 0, okay? Ito, wala. No basis at all, okay? 642, 444, parang equal lang sila. Same kinds of heirs, okay? Now, the last one. Assuming further he died intestate, survived by his father Juan, his brother Ronnie, his half-sister Michelle, his legitimate son Jason, how will you distribute? This time, you will know the answer if you know that the father is just a secondary compulsory heir. And therefore, under 887, in a way, he will only inherit, okay, in the absence of legitimate children and descendants. Kaya, he can be excluded by a legitimate child. You should specify legitimate. It's not that a father can be excluded by a child, because an illegitimate child cannot exclude a legitimate parent. Okay? Kaya, ang sagot, letter C pa rin. Nothing to the brothers and sisters, nothing to the father. Okay? They will be excluded by a legitimate child. Okay? Now, this one is really a good question. Okay? Luis was survived by 2 legitimate children, 2 illegitimate children, his parents, 2 brothers. He left an estate of 1 million. Who are the compulsory heirs of Luis? How much is the legitimate of each? And how much is the free portion of his estate? Para medyo yung mga takot sa numero dyan, okay? Una, I have mentioned already, focus on the principles. Pag alam niyo ang principles, there should be nothing to be worried about. Second, okay? Ang mga examiners normally would give you figures na exact ang magiging result. Walang sagot na 1.87345. Walang ganon, okay? Normally, ang sagot 200, 100, 150. Hindi kayo masyadong papahirapan sa division or multiplication, okay? Kaya, halimbawa, 1 million, who are the compulsory heirs of Luis? Paminsan-minsan lang may ganun, okay? How much is the legitim? Pag ang tanong legitim, natural, ang una mong titingnan, who are the compulsory heirs in the problem, okay? And how much is the free portion? We will never know the free portion hanggat hindi mo na una na-identify compulsory heirs at pangalawa, nalaman ang legitims nila, okay? But, sa computation ng legitims, okay? Palagi, kung may estate, buo ito, okay? Half of that always would go, ang tawag dito sa half ay basic legitim, okay? Meaning, if only one compulsory heir survive, or 2 or more heirs of the same kind, entitled sila sa 1/2. In other words, 5 legitimate child, they will be entitled to 1/2. Okay? 5 illegitimate child, wala nang iba, 1/2 din. 5 asawa, 1/2. Hindi naman, isa lang. Okay? Ang exception lang dito, asawa, surviving spouse. If you remember, the legitim of the surviving spouse, even if he survived alone as a compulsory heir, may not be 1/2. It may be 1/3 if the marriage was in articulo mortis and the one who was at the point of death died within 3 months from the marriage. Importante yon na ang naghihingalo siya dapat ang mamatay. Okay? Malay natin, ang naghihingalo after the marriage biglang lumakas at ang kabila ang namatay. Okay? But for the 1/3 to apply, in articulo mortis, the one at the point of death died, but there are other requisites. They must not have been living together for at least 5 years. Kasi if they have been living together for at least 5 years, pero walang kasal, the 1/3 will not apply. You go back to the 1/2. Kasi parang ang implication ng batas, kaya mo lang pinakasalan dahil naghihingalo na. Okay? Kaya, entitled ka lang sa 1/3 na legitim. Pero if you've been living together for 5 years, ay mukhang hindi dahil sa mamamatay na siya. Siguro dahil mahal mo talaga siya, kaya mo papakasalan. Okay? Or for the benefit of the children, etc. So, again, 1/2 yan. But, okay? If there are legitimate children at mayroong illegitimate o kaya spouse, ang kanilang legitim will be in this portion. Ang tawag sa portion na yan ay free portion. Kaya lang dahil mababawasan ito ng mga legitimes ng concurring compulsory heirs, the spouse, and the illegitimate children. Kung may matira pa, ang tawag dyan ay freely disposable portion. Yung tanong niya na free portion, I would consider that ang ibig niyang sabihin, the freely disposable portion. Kasi may illegitimate child illegitimate children. Okay? Kaya, dito kukunin niya sa free portion. In fact, is it possible that there will be no freely disposable portion? The answer is yes. Pag maraming illegitimate children, katulad ni former Senator Revilla, okay? Wala, mauubos yan, okay? And these illegitimate children may not even be entitled to half the legitimate of a legitimate child. May examples dito maya-maya, okay? Thus, ano ang sagot? Dito, bilangin mo kaagad ang legitimate children, 2. Kung 2 sila, which means hatiin mo ito. Which means 1 million divided by 2, so 500. So each one, 250. 250. Kailangan mo yan because the shares of the spouses at saka spouse at saka illegitimate children will depend on the legitimate of the legitimate child. Okay? Kung they concur, kung sila lahat. In other words, the 2 illegitimate children in the problem, again, this is the family code. So far, I can assure you for the past 10 years at least, ang namamatay during the family code. Kaya, wala na kayong problema sa civil code depending on the kind of illegitimate child. Pag spurious, 2/5 lang. Pag acknowledged natural child ay 1/2. Wala na. Mas madali na mathematics ngayon. 1/2 lahat. Okay? Regardless of the kind of illegitimate child, ang legitimate niya is 1/2 the legitimate of a legitimate child. Okay? Tao-tao ito. Kasi yung iba ginugrupo-grupo. Okay? Illegitimate child na isa, ang legitimate niya, half the legitimate of one illegitimate child. Which means, 2 illegitimate equivalent sa isang legitimate. Kaya ang lalabas, 250 ang ibibigay sa 2 illegitimate children. Dito, 2 legitimate children, they are compulsory heirs. 2 illegitimate children, they are also compulsory heirs. 2 brothers, they are not compulsory heirs. Wala silang legitimate parents. Ito ang medyo debated ang parents because nakalagay sa 887 that ang implication, they are only compulsory heirs in the absence of yung mga legitimate child descendants. The better interpretation to this provision ay they are compulsory heirs, but they will not inherit in the presence of the legitimate children or descendants. Okay? Kaya in the problem, of course, they will not inherit, okay? And they will not have legitimes kasi merong legitimate children. It's not even because of the illegitimate children. It's because of the legitimate children, okay? Kaya wala na silang legitimate, and ang lalabas, yung freely disposable portion would be 250, okay? Kaya for example, dito sa options, again, X, kapatid niya 2, parents niya 2 legitimate, 2 illegitimate. Pag mayroong mga dotted lines, illegitimate yan. So far, for the past 30 years, isang examiner pala ang nag-drawing ng ganyan sa kanyang exam. Talagang nilagyan niya ng dotted lines. May drawing ang kanyang exam. Okay? But that pertains to an illegitimate relation. Kaya alam mo na kaagad, yung legitimate children, kalahati. Yung bawat isang illegitimate child, half the legitimate of a legitimate child. Dahil 2 sila, equivalent yan sa isa dito. Wala. They are not compulsory heirs. They are excluded by legitimate descendants. Okay? Legitimate children. Thus, ang tanong, if any, dito, out kaagad ang 500 each, di ba? Otherwise, wala na para sa mga illegitimate children. Okay? Again, hatiin mo kaagad yung kalahati na yon para sa legitimate children. Kaya lang dalawa sila, so 250 each. Out na yan. Kaya lang, dito, legitimate ito, no? Legitimate muna. Ito would be wrong. Okay? 125 para sa parents kasi nga excluded nga sila ng legitimate children. Ito lalong mali. Brothers, 125, wala. Walang legitimate ang brothers. So, even if you don't know how to multiply or divide, alam mo dapat ang sagot, letter A. Okay? Because you can exclude the others by knowing the rules. Okay? Now, kaya ito, consistent ito. Yung legitimate ng isang illegitimate child is half the legitimate of one legitimate child. Parents excluded, they are not compulsory heirs. Therefore, the free portion is 250,000. Okay? Now, into the second question, suppose Luis in the preceding question died, who are his intestate heirs and how much is the share of each in the estate? The problem, pag may compulsory heirs, sila din ang intestate heirs. Natural, sino ang pinakamas malapit sa kanya? Yung mga compulsory heirs din. Okay? Kaya, ganun din ang rules. The father will be excluded, the parents will be excluded by the legitimate children, the brothers would have no share, they will be excluded by compulsory heirs. Okay? Kaya ito, mali na kaagad. This one is wrong. If only because yung 125, 375, hindi siya kalahati. Dapat even in intestate succession, the share of the illegitimate child ordinarily should be half the share of a legitimate child. Kung ang share ng legitimate child 250, ang share ng isang illegitimate child should be 125. Okay? Now dito, mali. Kasi brother will have no share in intestate succession. Kaya ang lalabas, ito ang tamang sagot. Okay? Because there are 4 heirs who would inherit. Okay? 2 legitimate, 2 illegitimate. The 2 illegitimate is equivalent to 1. Diba? 1 legitimate. You practically divide the estate into 3. At ang quotient, bawat isang legitimate yun. Okay? Pero ang dalawang illegitimate, maghahati doon sa 1/3. Okay? Kaya, 166,666. Okay? Kung essay ito, maski fraction lang, okay na yan. Actually, kung ako ang mag-check, as long as all the principles are present, out of 5, at least I'll give you 4. Out of 10, I'll give you 9. Okay? Kung hindi ka lang marunong mag-divide talaga, okay na yan. 9 out of 10. Ang figures are important in a way because this will also check yung principles mo. Kasi kung ang principles nakalagay, they will share equally. Pero ang sagot mo, A, 50,000, B, 25,000. Paano naman naging equally yan, di ba? Kaya dapat ang figures mo consistent with the principles. Yun ang taga-check mo doon sa principles. Okay? Now, so 2011, Joanne married James, a person with no known relatives. Through James' hard work, he and his wife Joanne prospered. When James died, his estate alone amounted to 100 million. Okay? If in his will, James designates Joanne as his only heir, what will be the free portion of his estate? Ang nakalagay, Joanne gets all, estate has no free portion left. Take note, focus on the question. Okay? What will be the free portion? Sabi, no free portion. Letter B, Joanne gets 1/2, the other half is free portion. Letter C, Joanne gets 1/3, the remaining 2/3 is free portion. Joanne gets 1/4. This one, yung dalawang ito automatically mali. As I told you, basic legitim. If only one compulsory heir survived, ang kanyang legitim ay 1/2. It can never be less than 1/2. Ang share niya can be more than 1/2. Kasi ang legitim niya, 1/2 na eh. But, alin dito ang tamang sagot? Sabi ni Din Pineda, ang sagot ay letter B. I agree to that to this answer dahil ang tanong, what will be the free portion? The other half is the free portion. But actually, if you will read the will, in his will, James designated as his only heir. Ang dapat na sagot dyan, kung ang naging tanong, how much would Joanne be entitled? Ang sagot, Joanne gets all. Okay? Kaya lang hindi yun ang tanong eh. Okay? Ang tanong ay, what will be the free portion? Actually, itong gets one half, mali yan. Okay? Strictly speaking. Because he will get all kung gusto niyang kunin lahat. Binigay sa kanya lahat, wala nang ibang compulsory heir. But, follow lang yung lead ko. Ano ang tanong? Focus on the question. Okay? The other half is the free portion. Now, bago tayo tumuloy, break muna tayo. 10:30. And Juanito. A wife named Adet, parents named Pepe and Pilar, illegitimate child Roman, brother Mark, sister Nanette. Since his wife Adet is well off, he wants to give to his illegitimate child as much of his estate as he can legally do. His estate has an aggregate net amount of 1.2 million, and all the above-named relatives are still living. Emil now comes to you for advice in making a will. How will you distribute his estate according to his wishes without violating the law on testamentary succession? The will can be as simple as, I hereby give the entire freely disposable portion of my estate to my illegitimate child, Roman. Diba? As simple as that. In other words, all the compulsory heirs would have their legitimes, but yung illegitimate child, Ramon, is a compulsory heir also, who would have his legitim, but the freely disposable portion can be added to his legitim. Okay? And there will be no violation of any rule in succession. Okay? Thus, for example, in this scenario, you consider who are the compulsory heirs. Okay? Ang drawing si Emil, asawa niya, 3 legitimate, 1 illegitimate, brother, sister, parents. Again, the brother, sister, need not be given any share in that will. Okay? Total, hindi naman sila compulsory heirs. Pepe and Pilar, hindi rin, because they will be excluded by these legitimate children. So, ang matitira would be the wife, the 3 legitimate, and the illegitimate. Okay? Again, you give half as legitims ng legitimate children. They will be entitled to at least their legitim. Minimum yan. So, 1/2 ng 1.2, that would be 600. Divided by 3, 200 each. And the spouse would be entitled to the same share as legitimate child. Therefore, another 200. 800 na yan. Ang illegitimate child's legitim is 1/2 the legitim of a legitimate child. So, 100. Ang total na niyan ay 900. Therefore, there is a freely disposable portion of 300. So, idagdag mo ang 300 na yan sa illegitimate child, that will be his ultimate share. Okay? Kaya, ang sharing ay, yung illegitimate child ay 400. Okay? But even if you check the others, mali ito kaagad. Like, wife cannot have nothing. Okay? Because compulsory heir siya. Okay lang itong parents wala, brother, sister wala. But also, this one is wrong. Okay? 100 lang, that would impair the legitims ng legitimate children. Dahil ang legitim nila, bawat isa 200,000. Diba? Ang letter B, ang mali dyan ay brother-sister. Pagbibigyan mo ang brother-sister, you will not be giving the maximum amount to the illegitimate child. Okay? They are not compulsory heirs. They need not be given anything. Okay? In that will. Kaya, ang tamang sagot ay letter D. Okay? Again, this is half of the estate divided by 3, 200,000 each. The spouse legitimate is the same as one legitimate child, 0 sa parent, 0 sa brother, sister. Kaya sa 400 is because 100 dyan ang legitimate niya, the 300 is the freely disposable portion. Now, this one is, kung ito 2005 ang tanong na ito, this one, okay? But this is similar, kapareho, parang kinopya lang ng examiner yung tanong na ito noong 1982, okay? But it is more than 20 years, okay? But almost the same, pati ang figures, okay? 1.2 million, basically the same. Yun nga lang, father lang, tapos 3 legitimate and 2 illegitimate, okay? Which means again, this time, ang gusto niya, maximum ibigay kay A kasi handicap, di ba? Again, sa facts, he wants to leave to him yung A is handicapped child as much of his estate. So again, ang gawin mo lang, freely disposable, idagdag mo kay A, okay? But ang legitimate ni A dito ay 1.2 divided by 2, 600. 600 divided by 3, 200 each. Therefore, the wife, 200, and each illegitimate child, 100. So that is 6, 7, 8, 9, 10, 1 million. Ang freely disposable is only 200,000. So, idagdag mo kay A, 200 ang legitimate niya, plus 200 na freely disposable, that should be 400. Okay? So, ang sagot dyan ay 400. This time, in relation to adoption. Okay? A Filipino couple, Mr. and Mrs. B.M. Jr., decided to adopt YV, an orphan from St. Clair's Orphanage in New York. They loved and treated her like a legitimate child, for they have none of their very own. However, B.M. died in an accident at sea, followed to the grave a year later by his sick father, B.M. Sr. Each left a sizable estate consisting of bank deposits, lands, and building in Manila. May the adopted child, YV, inherit from BM Jr., may she also inherit from BM Sr. Is there a difference? Okay, why explain? Take note, this is bar exam question number 8. Letter A, may letter B. Ang usual na question, ang letter A related ang letter B, di ba? Kaya nga nag-A and B. Pero take note, in this bar examination question, the second has nothing to do with the first. Wala lang. Basta treat lang niya mag-letter B. Okay? Mr. X and Mr. Whitey have been married for 20 years. Suppose the wife Whitey died childless, survived only by her husband XT. What would be the share of XT from her estate as inheritance? In a problem where the examiner did not mention that there was a will which was executed, you can presume that the person died intestate. Kaya intestate succession ang succession na ito. But into the first, okay? May the adopted child inherit from BM Jr., okay? Letter A, YB can inherit from BM Jr. and BM Sr. because he will also inherit from BM Sr. by right of representation because the junior died ahead of the senior. Di ba? Is that correct? Or YB can inherit from BM Jr. but not from BM Sr. because adoption creates a legal relationship only between the child adopted and the adopter. Or YB cannot inherit from BM Jr. and BM Sr. because adopted child is not an heir of the adopter nor of the latter parents. It will depend on the law of New York where BM Jr. adopted YB. Letter D is really wrong because the decedents are Filipinos. So as to who will inherit from them, it will be Philippine law. Okay? But this one is not an heir is also wrong. Under Philippine law, an adopted child would have the same rights as a legitimate child of the adopter. Okay? Ang mali palagi na kiniklaim ay the adopted child would have the same hereditary rights as the legitimate child of the decedent. Hindi totoo yan. Only as far as the adopter is concerned. Because as in this problem, do you think the adopted would inherit from the father of her adopter by right of representation? Kung yung anak, legitimate child of the adopter, can inherit, not this one, not the adopted child, because in letter B, adoption creates a legal relationship only between the adopted and the adopter. Hanggang doon lang, okay? So it's not accurate to say na ang isang legitimate child ng adopter at saka yung adopted would have the same hereditary rights, okay? They would have the same as far as the adopter only is concerned, okay? Now, then into the second question, suppose the wife died childless, survived only by her husband, what would be the share of XT? Natural, there appears to be no other heir in the world, okay? Kaya, ang sagot, the entire estate, okay? As long as he is an heir, okay, whether a compulsory or even only a legal heir who is not a compulsory heir, like pamangkin, the nephew by a first cousin, he may get everything, lahat, okay? Kung wala siyang ibang heirs to survive the decedent, okay? Again, this is by antecedent succession. Pero actually, if ang namatay dito ay YT, if YT died with a will, okay? Anong minimum na share ng husband, ng widower? Minimum ay 1/2, okay? In that will, the testatrix can give 1/2 of her estate to somebody else, okay? Unless, of course, yung 1/3 na applicable, yung articulo mortis, okay? Now, then into the kinds of heirs, therefore, there are 3 kinds, okay? Compulsory heirs are those who are entitled to a specific portion of the estate known as legitim, okay? And they cannot be deprived of such except through a valid disinheritance. In other words, these heirs compulsory may inherit despite a will. Even if in that will, the decedent, the testator gave the entire estate to somebody else, they will inherit, okay? As compulsory heirs. Yung voluntary or testamentary may only inherit because of the will, okay? So if there is no will or the will is void, they cannot inherit, okay? But I already mentioned that even compulsory heirs can be voluntary heirs, okay? But other legal or intestate heirs, okay, may inherit. These are the heirs who may inherit if the testator died without a will or with a void will, or even if there's a valid will, because there are many reasons like not all the properties were disposed of in that will. So those which have not been disposed of will have to be distributed to the legal heirs, okay? Now, but there are kinds of compulsory heirs, okay? Like primary, secondary, and concurring, okay? This is, as the Supreme Court also would tell us, because one author would claim primary and secondary lang. Ang category niya ng spouse, for example, ay secondary. Mali yun, okay? Because secondary will only inherit in the absence of. But ang concurring, they will inherit in the presence of. Whether may primary, whether may secondary, they may inherit together with. Kaya nga ang tawag sa kanila concurring. It doesn't matter kung primary or secondary ang heir who would inherit. Okay? But let's start with the primary. These are heirs who take precedence, okay, and would exclude secondary heirs, hindi concurring, okay? They would only exclude the secondary heirs, and sino-sino sila? Legitimate children and descendants, okay? Again, the legitimate also would describe the descendants, okay? So legitimate dapat ang grandchildren, great-grandchildren, to be called primary compulsory heirs and therefore exclude parents. Okay? Now, but in this category, papasok ang adopted children, okay? Because they would have the rights of, okay, legitimate children as to the adopter. Also dito papasok ang children by artificial insemination, assuming all the requisites prescribed ng family code are present, then they would have the rights of a legitimate child, okay? So primary compulsory heir. Now, secondary compulsory heir would be the legitimate parents and ascendants, okay? So kung pababa, okay, primary, dapat legitimate. Paakyat, okay, ascending line, secondary compulsory heirs, okay? When the law says in the absence, meaning hindi magmamana, it doesn't mean patay, okay? Because there can be children, but if they would renounce, ay swerte ng tatay, ng nanay, they may inherit, okay? Because the children renounce or incapacitated, so the ascendants may inherit. Now, concurring, okay, would only include the spouse and the illegitimate children, okay? They are the only concurring compulsory heirs, okay? Sinabi ko na, ang share nila nasa free portion. Doon sa free portion kukunin. Okay? Now, voluntary testamentary, in a way we have discussed this. But sino ang mga legal or intestate heirs? Okay? Legal or intestate are compulsory heirs, legal heirs. Lahat sila? The answer is yes. Imagine, the legal heirs are the closest relatives ng decedent. Okay? Sila ang compulsory heirs. If you notice, except one, all the compulsory heirs are in the direct line. Kaya maganda mag-drawing. Okay? Kung nasa direct line siya, compulsory heir siya. In other words, walang compulsory heir in the collateral line. Okay? Ang hindi lang nasa direct line ay ang spouse. In fiction of law, parang direct line siya because he or she is one with the other spouse, di ba? Nagiging isa, pero hindi totoo yan. Even in the law, they are not really considered as one, okay? Halimbawa, so hindi siya in the direct line pagdating sa preterition, okay? So, the spouse cannot claim, I am in the direct line. Mali. Okay? Hindi siya treated as in the direct line. Okay? But nonetheless, a compulsory heir. Now, and take note, lahat sila related by blood. Okay? Except, again, the spouse. Okay? But sometimes, pwede bang related by blood ang spouse? Of course, as long as beyond the 4th civil degree. In other words, pwede mong asawahin ang anak ng pinsan mo. Okay? You can marry the child of your first cousin. And sina Arroyo, di ba? Mikey Arroyo, ang asawa niya ay second cousin. Okay? So 6 degrees. So pwede nang ikasal. Okay? Now, but after the compulsory heirs, sino pa ang ibang legal heirs? Those in the collateral line, again, within the 5th. So, hanggang 5th. So, mula sa brothers, sisters, uncles, aunties, cousins, hanggang children of cousins are within the 5th. Dati sa old civil code, hanggang 6th. Ngayon, wala na. Hanggang 5th na lang. Okay? But, kung wala pa rin sa 5th, walang compulsory heirs, walang heirs na legal heirs or not compulsory heirs, sino ang susunod? The state. Okay? Practically, ang state lang ang heir, legal or compulsory na walang dugo. Okay? Hindi related, may dugo. Maski asawa naman may dugo. Okay? Although may not be related by blood. Di ba? Kaya, ang nag-appear again the other year pertains to the state. In the order of intestate succession, where the decedent is legitimate, who is the last intestate heirs, okay, or heir who will inherit if all heirs in the higher level are disqualified or unable to inherit. Nephews, nieces, hindi. 3 degrees lang yan. Brothers and sisters, lalo na. 2 degrees lang. State is the correct answer. Okay? Other collateral up to the 5th. Yung mga 4th ay hindi. Ang pinakadulo nasa state. Okay? If there is no relative, even in the collateral line within the 5th, then the state will inherit. Okay? Now, so this is the basically the legitimes depending on who survived. Ito yung mga usual na mga ala permutations. Okay? And legitim and the shares in intestate succession. Okay? If you know the legitims, 99.9% you will know the share in intestate succession. Naka-premise sa legitim. Kaya I would encourage you to know the legitims. Okay? Like, legitimate children muna ang descendants, as I mentioned, palaging 1/2. Okay? That's basic legitim. Okay? Or descendants like lahat 10 grandchildren, 1/2 din. 1/2 ang legitim. There is no such legitim na isang tao ay 3/4 or 2/3. Okay? The maximum legitim of one person ay 1/2 or 2 or more persons of the same kind, 1/2 din. Okay? Puro sila illegitimate children, 1/2 din. Okay? Thus, kung legitim 1/2, ang freely disposable portion ay 1/2. Pero if he died intestate, everything goes to this heir, the entire estate. Halimbawa, ang nag-survive, isang illegitimate child lang, ang kanyang legitim 1/2. And pag intestate succession, the entire estate goes to him. Actually, maski isang child by a first cousin, wala siyang legitim, di ba? But if he survived alone, walang heir na nag-survive, he gets everything. Di ba? But this time, kung may two or more heirs of different kinds, yun ang medyo mahirap-hirap. But one child, legitimate and surviving spouse, which is unusual, di ba, sa Pilipinas. Dahil normally pag nasimulan, dumadami yan. Okay? 12, 14 na anak. Okay? 1/2, 1/4. The surviving spouse legitim is only 1/4. Sabi nga ng isang justice in his decision, bakit ganito ang shares? Because love first descends. Okay? Pababa, bago umakyat. Okay? So, ang una ay ang anak. Okay? 1/2 and then 1/4. Pero, take note, rule ito. As to 2 persons, both compulsory heirs, the legitim, the heir, the compulsory whose legitim is less than the other, in case of intestate succession, he will be entitled to the freely disposable portion. So, mayroong 1/2, 1/4, ang freely disposable portion ay 1/4. Yung 1/4 lang siya makakakuha ng freely disposable portion. In other words, yung 1/2, pag talagang figure na 1/2, it will never be 3/4. It will never be 2/3. It will remain as 1/2. So, ang freely disposable portion, idagdag mo sa 1/4, kaya 1/2, 1/2. Pero in partial intestacy, like may ibinigay na kotse sa isang kaibigan, dito sa 1/2, 1/2, who will suffer a reduction? The spouse. Okay? But not to impair her legitim na 1/4. Okay? Otherwise, inofficious ang magiging disposition na yan. Okay? Now, legitimate children and the surviving spouse is the more common scenario. Okay? Even sa bar exams, although meron din sa bar exam na isang child lang. Okay? Legitimate children and surviving spouse, the children again 1/2. And the surviving spouse legitim is equal to the legitim of one legitimate child. In other words, mas maraming anak, mas kawawa ang asawa. Okay? Paliit ng paliit ang legitim niya. Di ba? But pagdating sa intestate succession, in this, in this scenario, they will still have the same ratio, 1:1. In other words, madali lang ang scenario na yan. If there are 3 children, legitimate plus spouse, 4 sila, just divide the estate into 4 pagdating sa intestate succession. Okay? Dahil it will be the same share. Okay? Kung ano ang share ng isang anak, yun din ang share ng asawa. Okay? Yun nga lang, ang lamang ng asawa, like pag conjugal properties or community, meron muna siyang kalahati, di ba? So kalahati muna sa kanya, and then doon sa kalahati magmamana pa siya o di lamang din siya. Okay? So yan ang scenario. Dito legitimate children and natural children. Ito legitimate children and other illegitimate children. Kaya ko ginawa ito because of the civil code. Okay? Pero again, in a way, para tingnan nyo lang, more often than not, for more than 10 years, walang tanong na namatay during the effectivity of the civil code. Okay? Sa bar exam. Kaya, it doesn't matter kung natural or spurious ang child under the civil code. In other words, 1/2 ang legitimate ng mga illegitimate children, but each illegitimate child, ang legitimate niya ay half the legitimate of one legitimate child. Again, mas maraming legitimate children, mas maliit ang legitimate ng illegitimate child. Diba? Kasi kalahati lang siya ng legitimate ng isang legitimate child. Ang common na mali, binubuo ang legitimate at kalahati binibigay sa illegitimate. Mali. Okay? It should be each, bawat isa. Okay? Each illegitimate child's legitimate is half the legitimate of one legitimate child. Now, so wala nang mga 4/5, 2/5, wala na yan. Pagdating sa intestate succession, ganun pa rin. Okay? 2:1 ang dating. The share of the illegitimate should be half the share of the legitimate. In other words, kung mayroon kang 3 legitimate at 2 illegitimate, anong gagawin mo? Divide by 4 lang. Di ba? So each legitimate, 1/4, 1/4, 1/4. Ang natitirang 1/4, 1/8, 1/8. Okay? Dahil 2 illegitimate equivalent to 1 legitimate. Huwag nyo lang gagawin yan pag there are many illegitimate. Mamaya may example ako dyan. Okay? Now, ito muna. The decedent died intestate, leaving an estate of 10 million. He left the following heirs. Okay? Marlon, a legitimate child. Cecilia, the legal spouse. Divide the estate. Madali lang. Okay? Intestate. So, intestate succession. Okay? In other words, kung legitimate sana ito, si Marlon, 1/2. Si spouse, 1/4. Pag legitimate. Kaso intestate, ang 1/4 ng asawa magiging 1/2 din. Kaya ang sagot, 1/2, 1/2. Okay? This will never happen na nagiging 2/3, nagiging 3/4. Okay? Kung 1/2 na siya dati, it will remain 1/2. Okay? Kung by figures, okay? In relation to the fraction of the other heir, okay? Kung fractional share, yung mas maliit ang nadadagdagan, okay? Like 1/4 nagiging 1/2, 1/3 nagiging 1/2, etc. Now, then into the other heirs, legitimate children, illegitimate children, at saka surviving spouse. Again, ang legitimate sila, nakabase sa legitimate children, ibigay mo ang kalahati sa kanila, and each illegitimate child's legitimate is half the legitimate of one child. The legitimate of the spouse will be equal to the legitimate of one child. Okay? So, ganyan yan. Tapos, pagdating sa intestate succession, ganun din. 2:2:1. Okay? Bawat legitimate child in a way 2 points. Bawat yung spouse 2 points. Pero ang illegitimate child 1 point. Okay? That is on the premise na konti lang ang illegitimate children. Ang aking parang warning sign. If there are twice the number of legitimate ang illegitimate, you should focus on the legitimes. You should start with legitimes. If you will go by the 2:2:1 ratio, you may impair the legitime of the legitimate children. Okay? Basta in a while, we will have the computation. Okay? Legitimate parents or ascendants, as I said, they are compulsory heirs. If they survive alone, ang legitimate nila kalahati, they may get everything. Okay? As compulsory heirs. In other words, even in a will, the testator cannot deprive them of their legitimes. Kaya compulsory heirs sila. Okay? That is kung walang legitimate children and descendants. Okay? But parents and illegitimate children, in other words, walang asawa, pero may mga anak, hindi legitimate, may parents, take note because the parents are secondary compulsory heirs, they will take the place of the primary compulsory heirs. Kung ano ang share dati ng primary, sa kanila mapupunta. Ano ang share ng primary? 1/2. So, ang share ng parents ang magiging 1/2. Ang illegitimate children will just be 1/4. The same fractional share sa legitimate parents and spouse, 1/2, 1/4. You can just imagine, ang illegitimate children and spouse, in a way, pareho lang ang status, in a way. Ang tawag sa kanila, concurring compulsory heirs. Kaya kung 1/4 ang legitimate ng illegitimate, 1/4 din ang legitimate ng surviving spouse. Yun nga lang, pag total intestacy, as I told you, the 1/4 becomes 1/2. Okay? So, equal na sila sa total intestacy in an intestate succession. And tinanong yan sa par exam. Okay? Now, legitimate parents, illegitimate children, surviving spouse, this one is unique. At tinanong yan last year. Okay? 1/2 ang legitimate parents kasi nga secondary compulsory heirs. 1/4 ang illegitimate children. 1/8 in a way lang ang spouse. 1/2, 1/4, 1/8. Ang illegitimate at saka spouse, parehong concurring. But the law would not give them equal 1/4, 1/4 kasi wala na magiging freely disposable portion. So, ang spouse ang binigyan lang ng 1/8. So, 1/2, 1/4, 1/8, parang lamang ang illegitimate. Pero, in real life, hindi yan lamang. Because pag ang illegitimate, nagkaroon na ng isang illegitimate, susundan niya na marami pa. Kaya lang, sila ang maghahati-hati ng 1/4. Whereas ang wife, mag-isa lang. Ang surviving spouse, mag-isa lang. So, maski 1/8 lang siya, yung share niya may be much greater than one illegitimate child. Okay? Kaya ang free portion dito ay freely disposable ay 1/8. Pagdating sa total intestacy, it's 1/2, 1/4, 1/4. Again, yung pinakamaliit na legitime, siya ang mag-benefit sa total intestacy. Okay? Now, illegitimate children, lahat sila. Puro illegitimate, 1/2. Okay? And they may get everything. But illegitimate children and surviving spouse, dalawang klase lang. As I said, pareho silang concurring compulsory heir, kaya ang treatment sa kanila may pagka-equal. Kaya 1/3, 1/3. Okay? Pero in total intestacy, ang 1/3 pareho nagiging 1/2. Okay? 1/2, 1/2. Pareho sila nagbe-benefit. Wala namang mas maliit sa kanila. Di ba? So 1/3, 1/3 nagiging 1/2, 1/2. I already mentioned yung mag-isa lang na if he or she survive alone, 1/2 ang legitimate unless yung articulo mortis. Okay? Or the surviving spouse may get everything, just like yung bar exam kanina. Okay? Now, illegitimate parents, ako lang naglagay, or some authors would say illegitimate parents, because the law 887 would call them actually the parents of the illegitimate child. Pero sa tingin ko, mas magandang pangalan sa kanila, illegitimate parents. Instead of the child being illegitimate, it should be the parents. Okay? Kasi sino ba may kasalanan? Yung anak o ang gumawa ng anak? Di ba? Mukhang walang kasalanan ng mga bata. Sila ay iniluwal sa mundo na inosente. Okay? But the law, unti-unti nare-recognize yan. unti-unti tumataas ang status ng illegitimate children. The latest sa family code, aside from wala ng mga 2/5, lahat 1/2 na, ang grandparent is already obliged to support an illegitimate child of their legitimate child. Sa succession, barred pa yan, Iron Curtain Rule. Pero sa support, required na sila to support, maski illegitimate ang bata. Okay? The child cannot inherit, but he is entitled to support. Parang merong sa batas. Okay? But unti-unting nadidevelop lang yan. Illegitimate parents, 1/2, and they may get everything. Kaya lang, if concurred by another heir, like a child of any class, halimbawa, ang illegitimate parent dito ay may anak siya. Illegitimate child. Okay? Ito, A is the illegitimate child of A. So, itong parent na ito, as I would say, illegitimate parent. Okay? Now, concurred, kung may anak si A na illegitimate child din, okay? Would the parent who is an illegitimate child of A inherit from A? No. This child will exclude the parent. Lalo na if the child is legitimate. Lalong mai-exclude ang parent. Ang parent, even if legitimate, can be excluded by a legitimate child. Di ba? Pero pag illegitimate ang parent, even an illegitimate child can exclude the parent. Okay? Kaya, 0. Okay? Wala siyang legitimate. The child, 1/2, the child may get everything in interstate succession. Illegitimate parents and surviving spouse, ito ang unique din because ang binigay lang na legitimate sa dalawang ito ay 1/4, 1/4. This is the only scenario na 1/4, 1/4. Two heirs na magkaiba, the smallest fractional shares, 1/4, 1/4. But again, in total intestacy, the 1/4 becomes 1/2. Silang dalawa magbe-benefit. Okay? Surviving spouse, brothers and sisters, this is the most unique. Okay? And kaya favorite sa bar exam. Diba ang spouse is a compulsory heir who may be, yung legitimate niya is 1/2 or 1/3. And brothers, sisters, nephews, nieces are not compulsory heirs. Walang legitimate. Pero, in total intestacy, in intestate succession, the spouse will not exclude the brothers and sisters. Okay? In other words, kung ang namatay may asawa, pero may mga kapatid. Okay? The kapatid are in the collateral line, di ba? But they are not excluded by this compulsory heir. Ito lang ang compulsory heir who does not exclude collateral relatives. Asawa lang. In a way, unique siya. Kasi hindi naman siya related by blood, normally. Kaya he doesn't exclude. She doesn't exclude brothers, sisters, nephews, nieces. Okay? Kaya, pagdating sa total intestacy, hati sila. 1/2 lang ang asawa, 1/2 kapatid. Mga kapatid or brothers and sisters. Okay? Now, brothers, sisters, nephews, nieces, walang legitimes, pero they are legal heirs, kaya they may inherit the entire estate. Okay? Ang buhay ng isang kapatid o kaya isang pamangkin, swerte niya. Okay? Gets everything. Actually, yung kay Doña Chito, muntik-muntik na dyan. Because ang nag-survive lang sa kanya, asawa niya. Nandun pa si dating foreign minister. Sino nga ito? From Batangas. Okay? Plus, wala naman silang anak, so mga pamangkin. Okay? Ang nag-survive. Okay? But, may will siya. So, sorry na lang ang mga pamangkin. Okay? Now, children are the first cousins. I emphasize this to show you na in the collateral up to the 5th. Okay? Sila ay within the 5th. Though wala silang legitimate, they may get the entire estate. Okay? As legal heirs. Okay? In intestate succession. Ang last nga ay state. Pag wala ito lahat, the state may get everything. Okay? So, ito ang ibang bar exam questions. Okay? Ramon Mayaman died intestate, leaving a net estate of 10 million. Determine how much each heir will receive from the estate. Ang first scenario is, if Ramon is survived by his wife, 3 full-blood brothers, 2 half-brothers, and 1 nephew, the son of a deceased full-blood brother. Okay? Ang lalabas dito ay si Ramon, okay, may asawa, pero he has 3 full-blood brothers, maybe A, B, and C. Tapos 2 half-blood, okay? Half-blood, D, E. Half-blood again doesn't mean illegitimate. Pag hindi niya sinabing illegitimate, pwedeng magmana yan. Okay? And finally, nephew, who is the son of a deceased full-blood. Baka may isa pang kapatid na full-blood, probably si D. Gawin nating E and F ito. Okay? So, 4 sila, pero nag-predecease, kaya si Y ito. Okay? Effectively, ang gagawin mo ay take note, intestate succession, yung spouse, ang legitimate niya na 1/2 will remain 1/2. Okay? So, therefore, ang wife dito would be entitled to 5 million. Okay? Pero, marami ang iba pa. 3 full-blood, 2 half-blood, and 1 nephew from a full-blood. The nephew from the full-blood will get the share of the full-blood brother by right of representation. Ang right of representation extends to the children of brothers and sisters. Okay? Kaya effectively, 4 sila na full-blood, pero ito half-blood. Ang rule again is the share of a half-blood in intestate succession is half the share of a full-blood. Since dalawa sila, parang equivalent sa isa. Diba? So, kung 5 million pa ang natitira, effectively, you divide the 5 million into 5. 1 million kay A, 1 million kay B, 1 million kay C, 1 million kay Y by right of representation, 500,000 kay E, 500,000 kay F. That would be their shares. Okay? Pero, ito yon. It cannot be 10 million. Okay? Because the surviving spouse does not exclude collateral relatives, brothers and sisters. So, mali ka agad yan. Itong 3 million, mali ka agad. Dahil legitimate niya ay 5 million. Okay? But, sa dalawa, 5,320,000, mali ito. Kasi ang nephew will inherit by right of representation. Kaya ang tamang sagot ay letter D. Okay? Again, you can tell already na mali yung iba, even if you don't compute. Okay? Now, but sa pangalawang tanong, if Ramon is survived by his wife, a half-sister, and 3 nephews, sons of a deceased full-blood brother, again, ang lalabas, the wife, 5 million. Okay? So, mali ka agad ang 6 million, mali ang 10 million, but ang nag-survive, half-sister and 3 nephews, itong 3 nephews will only inherit by right of representation. In other words, they will only inherit what their father would have inherited had he survived. Okay? Kaya, since half-sister ito full-blood brother, the full-blood gets twice the share of the half-blood, which means 2/3 of 5 million. Ang half-sister will only be 1/3 of 5 million. Okay? Pero ang 2/3 of 5 million, paghahatian ng 3. Diba? 3 ang nephews. Okay? Kaya, between these 2, ito ang tamang sagot. Okay? The nephews cannot be excluded. Okay? They will inherit by right of representation. Kaya, itong half-blood sister, 1/3, which is 1.67, ang 3 nephews, 2/3, kasi yun share ng tatay nila, being a full blood. Pero 3 sila maghahati-hati. Okay? Now, then, this one is a good problem. Ernesto, an overseas Filipino worker, was coming home to the Philippines after working for so many years in the Middle East. He had saved 100,000 in his savings account in Manila. Napakalaking savings, ano. Pero actually, I have realized, because of what happens sa ating mga OFW sa Saudi, marami talaga umuwi ni kusing wala, di ba? Kaya okay na rin itong 100,000 na ito, okay? Na savings niya. Which he intended to use to start a business in his home country. Pwede na ito, pang banana queue, okay? On his flight home, Ernesto had a fatal heart attack. He left behind widowed mother, his common law wife, and their twin sons. Okay? Widowed mother, mukhang nanay niya, mukhang legitimate. Okay? Do not presume illegitimacy. Okay? Now, he left no will, no debts, no other relatives, no other properties except the money in his savings account. Who are the heirs entitled to inherit from him, and how much should each receive? Technically, may problem dito, okay? Kasi ang 100,000 na ito, hindi ito need not be his entire estate. Kasi may asawa at mayroon siyang common law wife who may have a share. Yung unions without marriage, di ba? Kung walang impediment to marry, baka hati sila. Wage ito salary ito 50. But assuming lang, estate niya ito, baka naman, 148 ito, hindi 147, okay? Baka may impediment to marry ang kanilang union, okay? So kung 100 ang buong estate, who will inherit this estate and how much, okay? Who are the heirs entitled to how much? Pag tinanong kayo talaga ng how much, by all means, ilagay nyo figures. Kasi how much ang kanyang gustong tingnan, gustong makita sa sagot. Okay? Dito, the mother gets everything. Common law wife, 0. Common law spouse, wife, 0. Two sons, 0. Okay? Mother, 0. Common law wife, 50, 25. On its face, the common law wife should get nothing. Okay? Kasi common law lang, hindi naman talaga kasal. Okay? So, out na itong letter B. Okay? Kaya lang, dapat ba the mother 100? Mali din. Kasi may mga children may anak naman siya. Kung common law spouse lang, ibig sabihin they are not married, therefore the children are illegitimate. But they are compulsory heirs. Yun lang, because walang legitimate child, who will get 1/2 of the estate? The mother. Because the mother is a secondary compulsory heir. Kaya automatic ang sagot dyan ay 50. Okay? Kaya alam nyo na ito ang tamang sagot. 50, the wife 0, the children as illegitimate children. Ang kanilang legitimate actually is only 1/4, which is only 25,000. Pero dahil total intestacy ito, they will get the entire 1/2, the 50%, 50,000. Paghahatian nila, 25,000 each, dalawang illegitimate. Again, in some problems, the examiner may not tell you na illegitimate ang bata. But from the facts, you can deduce, okay? There is basis under the facts na illegitimate ang bata. Dahil common law, wife lang siya. So, walang kasal, okay? Now, then, this is a classic. Magandang-maganda ang tanong na ito. September 1088, okay? Take note yung date. Pag nagbigay ng dates ang mga examiners, more often than not, may relevance yan. Rare yung wala lang, trip lang niyang manggulo lang, okay? But may relevance yan. A 26-year-old businessman married Carla, a winsome lass of 18. Without the knowledge of their parents or legal guardians, Kevin and Carla entered into an antenuptial contract the day before their marriage, stipulating that conjugal partnership of kin shall govern their marriage. At the time of their marriage, Kevin's estate was worth 50 million, while Carla's was valued at 2 million. Okay? A month after their marriage, Kevin died in a freak helicopter accident. He left no will, no debts, no obligations. Surviving Kevin, aside from Carla, are his only relatives, his brother Luis and first cousin Lilia. Okay? Aside from Carla, kapatid lang niya at saka pinsan niya, Lilia. Okay? So, who are Kevin's heirs? How much is each of Kevin's heirs entitled to inherit? Okay? Sino ang heirs niya? Una, si Carla. Okay? Mukhang walang question sa validity ng marriage. Okay? Pero pangalawa, mayroon siyang kapatid. The brother will not be excluded by the wife in intestate succession. And the first cousin, however, will be excluded, okay, by the brother, okay, under the proximity rule, okay. Now, kaya ang lalabas lang nito si Carla lang at saka ang brother. But how much, okay? How much is each of Kevin's heirs entitled to inherit will depend on the validity of this antinuptial contract, okay? Kung valid yan, then ang estate ni Kevin will be 50 million. Di ba? 50 million, ang 50 million na yan, paghahatian ni Carla at saka ni Luis. Di ba? 25-25, equal. Okay? Brother at saka asawa in intestate succession. Pero valid, kung valid yan. Okay? Pero valid ba yan? Okay? The answer is no. Okay? September 10, 1988, ang law reducing the age of majority to 18 took effect 1989. In 1988, in order for a marriage settlement to be valid, entered into by a minor. Okay? Ang tawag sa kanya minor kasi 18 pa lang siya. Okay? At that time, in 1988. The parents of the minor must be made parties. Hindi lang should be present. Hindi lang should be witnesses. They should be made parties to the antinuptial agreement. If not, that marriage settlement is void. So kung void ang marriage settlement, ano ang labas? Absolute community of property. In other words, in an instant, nanalo sa loto si Carla. Okay? Mula sa 2 million lang ang kanyang property, ang 50 plus 2 naging 52 divided by 2, 26. So, nang namatay si Kevin, ang estate na lang niya 26. Si Carla may 52 na at may 26 na. But out of the 26 ni Kevin, sino ang magmamana? Silang dalawa pa. Si Carla at saka si Luis. Okay? So, ang 26 plus 13, about 39. Mula sa 2 million, nanalo siya ng 37 million. Okay? Ganun ang absolute community of property regime. Kaya ang sagot, this one. Okay? Yung estate ni Kevin, 26 na lang, 13. Okay? Ang matitira. This one, 25-25 would have been kung valid ang marriage settlement. Okay? Kung naging absolute community, naging conjugal partnership of gains ito. Ito yung sagot. Okay? Now, I will discuss with you just a few problems. Okay? In relation to legitimates and intestate succession. Ito ang scenario basically. X died intestate August 4, 88, leaving an estate value 120. Ang August 4, already in effect na ang family code. Okay? Dahil August 3 nga ang family code. So, compute the legitimates of the following and distribute the estate to the following heirs who survive. Ito, intestate succession. Okay? Ito ang mga scenarios. A and B, legitimate children, surviving spouse, and the mother. Okay? Isa-isahin natin, okay? Legitimate children, surviving spouse, the mother will already be excluded by the children, legitimate. Kaya dapat 0 yan. Wala ito. The 30,000 is wrong, okay? But, take note that ang legitimate ng surviving spouse is equal to the legitimate of one legitimate child, there being at least 2 legitimate children. Okay? Kaya kung 120 divided by 2 is 60, kalahati ng estate, 60, yun ang sa legitimate children, kaya lang dalawa sila, edi 30 each. Kaya ang legitimate ng bawat isa ay 30, mali itong 40, kaya lang, alin sa dalawa, si A or C, ang tamang sagot ay letter C. In other words, si D, walang legitimate, okay? Letter A is the correct answer, okay? Ang 30,000 na ito ay freely disposable portion. Pero, pagdating sa end-estate succession, paano sila magmamana? Still, 1:1, okay? In other words, 2 plus 1, tatlo na sila, 120 divided by 3, 40,000 each. Yun ang sagot, okay? In total, intestacy is 40, 40, 40. Okay? Now, yung pangalawa, illegitimate children, surviving spouse, and the grandmother. Okay? Anong legitimate sila? Take note, illegitimate, they cannot exclude the grandmother. The grandmother will take the place of the legitimate children and descendants dahil walang legitimate children. Okay? Kaya ang legitimate ng grandmother is 1/2. Okay? Kaya itong dalawa, mali. Itong tatlo, mali kaagad. Okay? The answer is letter D, 60,000. Dahil secondary compulsory heir siya. Ang legitimate ng illegitimate child dito is only 1/4 of the estate. Ang legitimate ng spouse is only 1/8. Okay? Kaya 60, 15,000 each, that's 1/4, and this is 1/8, 15,000. 1/8 of 120,000. Okay? Now, then letter C. 3 legitimate children, 5 illegitimate children, surviving spouse. Ito ang scenario na sinasabi ko that there are more illegitimate children kaysa legitimate children. If you will give yung shares nila or computer shares on a 2:1, 2 legitimate, 2 ang surviving spouse, 1 share ang illegitimate, mali ang sagot. That would impair the legitimate of the compulsory heirs. Tingnan nyo. Okay? Ang lalabas niyan ay yung 3, 5 at saka 3 legitimate, 5 illegitimate, surviving spouse. Kung ita-times mo yan, that's 6. Ita-times mo ang spouse is 2. Ita-times 1 mo is 5. That would be 13. Okay? 11, 13. In other words, kung 13 siya, i-divide mo ang 120, the legitimate of the compulsory heirs na legitimate may impair. In the problem, kung 120 ang kanilang, ang buong estate, ang legitimate ng mga legitimate children is 60, 1/2, divided by 3, 20 each. Mali itong 30. 20 each. So, pero pag i-divide mo ang 120 divided by 13, even if i-times mo pa yan, hindi yan aabot ng 20. Okay? It would be less than 20, which means you are impairing the legitimate of the legitimate children. In other words, sa tatlong heirs na ito, if someone has to suffer a reduction, it will have to be the illegitimate children. Do not impair the legitimate of the legitimate children. Do not impair the legitimate of the spouse. Kaya, ang unahin mo legitimes. Okay? Pag i-compute mo ang legitimes, ang lalabas ay 60 divided by 3, 20 each. Each legitimate child. So, 60 na yon. Plus 20 ang surviving spouse. Ang matitira, this is 80, ang matitira na lang 40. Sa 40, 5 pa sila na magsishare. Ang dapat na legitimate ng isang illegitimate child is half the legitimate of the legitimate. So dapat 10, di ba? 10,000 each. But you cannot give the 10 kasi kulang na ang estate. Ang 40 na natitira, divide mo by 5 illegitimate, 8 na lang ang matitira. At yun na lang ang pwede mong ibigay sa kanila. Okay? 8,000 each. Okay? Kaya ang tamang sagot ay letter A. Okay? 20,000 each, legitimate children, 8,000 each sa illegitimate child, 20,000 sa surviving spouse. As I said, safe ka pag nag-compute ka by legitimes. Okay? Hindi ka mawawala dyan. Again, this one is wrong kasi kalahati lang. But this one is really wrong. Pag ikaw ang executor at ito ang ibibigay mo, lugi ka. Mula sa bulsa mo ang ipapamigay mo dahil kulang ang estate, di ba? But this one, again, 10,000 is also wrong. Okay? Then, the next, okay? Illegitimate parent and illegitimate child, okay? As I mentioned, an illegitimate child excludes an illegitimate parent, okay? Kaya ang lalabas dito ay 060, legitimate, okay? 060. Pagdating sa antecedent succession, 0120. The illegitimate child gets everything, okay? Excluded ang illegitimate parent, okay? Now, yan. And then last, illegitimate parent and surviving spouse. As I told you, ang legitimes ang dalawa, 1/4, 1/4. So 1/4 of 120 is 30, okay? So that would be 30-30. Pero, pag total intestacy, ang 1/4, 1/4 magiging 1/2, 1/2. Kaya in total intestacy, ang sagot for 60-60. Okay? 1/2, 1/2. Okay? Yung iba na scenarios ng mga exercises pag may panahon tayo bukas. Okay? If there will be an extra time. Pero kaya nyo na yan i-compute on your own. Okay? Thus, ito na lang. For numbers 89 to 91, consider the following. X died with a net estate value 120. He was survived by A, the father, B, spouse, C, D, legitimate children, E, F, G, H, I, illegitimate children. How much is the legitime of B? B is the spouse, kaya you cannot compute the legitime of the spouse if you don't know the legitime of the child, of the children, legitimate children. So you start with that. Bigay mo ang kalahati sa legitimate children, so 1/2 of 120 is 60, but there are 2 legitimate children, so 30,000 each, and the spouse will be entitled to 30,000 also. So the answer is 30, okay? But, how much is the legitime of C? Then, nauna lang, 30,000, okay? But how much is the legitime of H, one of the illegitimate children? Ang major reaction ay, kasi 30,000, kaya 15,000, di ba? But, dahil nga marami ang legitimate children, hindi yan 15,000, okay? Ang ibigay mo nga sa legitimate children, that would be 60,000. Ang spouse, 30,000. So, 90 na yan. Ang natitira na lang ay 30. 30 divided by 5 na illegitimate, 5 na lang ang natitira. Ang sagot ay 6, sorry. 30 divided by 5 is 6. Okay? Kaya 6 million na lang ang bawat isang illegitimate child. Do not, okay? Do not immediately conclude, kalahati ng legitimate kasi maraming illegitimate children. Okay? Now, thus, ito. Just mga dalawang tanong lang. What do you understand by presumptive legitim? In what case or cases must the parent deliver such legitim to the children? What are the legal effects? Effectively, tatlo ang tanong dyan. What do you understand presumptive? In what case or cases? What are the legal effects? Okay? As to the first, ito ang pwedeng options. It is the equivalent of the legitimate children's legitims, assuming that the spouses had died immediately after the dissolution of the given property. Yung letter B, parang pareho lang. It is the equivalent of the children's legitim, assuming that the spouse had died. The difference only is walang legitimate. Okay? In other words, lahat-lahat ng children pwede. It is, letter C, equivalent of the legitimate children, assuming the spouse died immediately after the death. Okay? It's not about the death. It's about the dissolution of the community property, like annulment, declaration of nullity. Okay? Ang letter D, it is the equivalent children, assuming that the spouse died immediately after the legal separation. Ito issue ito, okay, among authors. But I would take the position na hindi applicable yan sa legal separation because the marital bond is not dissolved and therefore hindi siya pwede makapag-asawa sa iba. So, anong problema sa mga children? Wala. Okay? These properties will still be the properties or may still be inherited by the children. Ang problem kasi ng annulment or declaration of nullity, the parent or one of the parents or both may marry other persons. Kaya pwede maapektuhan ang presumptive legitimes. Okay? Ang tamang sagot ay legitimate. Dapat. Legitimate children's legitimes. So kung mga illegitimate, okay, yung mga anak ay doesn't matter. Okay? Walang obligation. Okay? As far as this presumptive legitime is concerned. In what cases must the parent deliver? When the marriage is annulled, even if the spouse had no common children, hindi totoo yan. Dapat common children. When the marriage is declared ab initio with common legitimate children, when the marriage is declared ab initio, void ab initio dapat. Okay? Each spouse having legitimate children of his or her own, hindi rin. Kasi nga common legitimate children. Pang-apat, when the marriage is annulled and each spouse has illegitimate children, lalo na. Okay? Dapat nga common, legitimate pa. Okay? Therefore, the answer is letter B. Okay? Declared void ab initio with common legitimate children. Okay? Pwede bang ganun? Yes. Like psychological incapacity. Okay? Now, what are the legal effects if the parent fails to deliver the presumptive legitim to the children? This is without prejudice to what they may actually inherit upon the death. Malay mo, pag namatay na ang tatay talaga o nanay, baka mas mayaman na. Diba? Mas marami na siyang mamanahin. Okay? Criminal, wala naman. Subsequent marriage the spouse will be void, forfeiture of the shares, hindi yan. Decree of dissolutions will be rescinded, hindi rin. It will be marriage of the spouse will be void. Pag wala, this is Article 54 in relation to 52 and 53 of the Family Code. Okay? Now, then, similar lang. Is there any law which allows delivery of the presumptive legitim during the lifetime? Okay? So, nakadalawang tanong. Now, we can go into the restrictions, okay, as far as legitims are concerned, okay, imposed by law. John and Paula, British citizens at birth, acquired Philippine citizenship by naturalization. Parang hindi makatotohanan ito, di ba? Imagine mo, Briton na sila, magiging Pinoy pa. Parang walang ganun sa tunay na buhay. Ang mga Pinoy nagiging Briton, okay? Pero Briton nagiging Pinoy, guni-guni lang niya ito, okay? During their marriage, the couple acquired substantial land holdings in London and in Makati. Pero, ang totoo, may Chinese na nagiging gusto maging Pilipino. Naniniwala kayo? Actually, I handled the case. Okay? Ang petitioner, ang aming kliyente ay Chinese, full-blooded Chinese, and Chinese citizen na gusto maging Pilipino. Di ba parang nakakatuwang maging Pinoy pag may mga taong ganun? Anyway, doon sa petition, so nag-present ako ng mga ebidensya, etc. Ang hindi ko in-expect, okay, I never thought of this. Nung last day ng hearing, sa presentation ng evidence ng petitioner, okay, sabi ng judge doon sa aming kliyente, yung petitioner, babae, Chinese, okay, you sing the national anthem. Naku, sabi ko, patay, baka hindi alam ng kliyente ko. Ako nga pakantay, hindi ko alam. Hindi ko memorize ang national anthem. Siya pa kaya. Nako, iba talaga ang buhay. Yung aking kliyente kumanta ng national anthem na buong-buo, kumpletong-kumpleto at ang boses niya napakaganda. Lahat ng tao doon sa kore, tuwang-tuwa, palakpakan talaga, granted kaagad ang petition, di ba? Kaya ang buhay minsan lang yung mga unexpected, hopefully for the better, okay? Kasi kung hindi alam ng kliyente, patay, baka denied ang petition, okay? Anyway, siya ay Briton, okay? In one acquired substance, Paula bore 3 children, okay? And John 3 children, Peter, Paula, and Mary. In one of their trips to London, the couple executed a joint will, appointing each other as their heirs and providing that upon the death of the survivor between them, the entire estate would go to Peter and Paula only. Mukhang wala si Mary. But the two could not dispose of nor divide the London estate as long as they lived. John and Paula died tragically in the London subway terrorist attack in 2005. Peter and Paula filed a petition for probate of their parents' will before a McCarthy Regional Trial Court. Are the testamentary dispositions valid? Dito, pag ang sagot mo sa testamentary dispositions, should first consider the entire will. Because if the entire will is void, I thought the dispositions can never be valid. Di ba? But, in the first place, is the will valid? Should the will be probated? The answer is no. This is a joint will executed by Filipinos. Okay? And even if they executed the will abroad, okay, and in that country, that will is valid, that will not be a valid will in this country. Kaya, to answer this question, are the testamentary dispositions valid? No. Because the will is void, being a joint will. Okay? Pero, is the testamentary prohibition against the division of the London estate valid? Okay? On the premise that the will is valid. Ganun na lang. Because pwede mo rin sagutin, hindi, kasi the will is void. Ganun pa rin. Consistent ka. No, because the prohibition is indefinite. Because even if the will is valid, a prohibition for indivision, for division, prohibition not to divide, so in division of more than 20 years is void. Kaya, that would be, even if the will is valid, this prohibition is void because it is indefinite. It is beyond 20 years. Okay? But actually, tama ba ito? Yes, because the prohibition pertains yes, because can impose any burden, hindi totoo yan. There are limitations provided by law as far as legitimes are concerned. Pertains only to the London estate. Okay? It doesn't matter. Okay? Maski anong property. Okay? Maximum period ng indivision ay 20 years. Cannot impose any burden, hindi naman. Okay? Although ang claim dito, merong, anyway, next. Okay? 2012. The following cannot ask for the reduction of inofficious donation, except creditors of the deceased, devices or legatees, compulsory heirs of the donor, the surviving spouse of the donee. I would presume that this donation is a donation inter vivos, not a donation mortis causa, pag hindi ni-specify ng examiner. Okay? And thus, the answer, therefore, he can ask for the reduction would be the compulsory heirs of the donor. Yung donee, this is the worst option. Why would she want? Okay? Parang ayaw niya ng property. Ganun ang dating dito sa letter D. But ang devices and legatees cannot ask for the reduction kasi yung rights nila will only depend on the validity of the legacy or device. Okay? Kung mayroon lang sumobra, hindi naman sila compulsory heirs. Okay? Kaya they cannot question the validity or whether the donation is officious. Ang creditors also cannot do that, but what they can do is to question the validity of the donation because it may have been in fraud of creditors, not because it is inofficious. Okay? Now, then we will now go into the question of who may succeed. Okay? As I told you, just because a person is an heir, or even if he's a compulsory heir, even if he's a legatee or devicee, he may not succeed. He may not inherit. Okay? For one reason or another, and one of them is incapacity, okay? Because that heir may be incapacitated, okay? So example, X who died in 2005 had 5 children, A, B, C, D, and E, who will not inherit from X, okay? Letter A, because he was already a citizen of France at the time of the death of X. Even if you know only the Constitution, alam nyo ang sagot dyan, okay? Because as far as the Constitution is concerned, yung prohibition that aliens cannot acquire private lands is not applicable sa succession. In other words, if the heir is a citizen of France, pero ang tatay niya ay Pinoy na Pinoy, he may inherit parcels of land. Okay? Kaya hindi totoo ito. Letter B because he was already a permanent resident of Canada, hindi citizen, resident lang. Okay? Or letter C, because he was suffering civil interdiction at the time of the death. Or letter D because he predeceased X. Or letter E, because he died before the filing of the petition for the settlement of the estate of X, even if he died after the death of X. Or all of the above or none of the above, who will not inherit. Okay? Ang tamang sagot ay what is the rule in relation to this as to who may succeed, who may inherit. The law is in Article 10:24. The persons not incapacitated, okay, or not disqualified by law may succeed either by will or by operation of law. So in other words, sa formulation ng batas, if a person is an heir, ordinarily he should succeed unless there is a law which incapacitates him. Kaya isipin mo palagi, anak sila heirs ba sila? Yes. But is there a law which incapacitates a son or a child because he's already a citizen of another country? Wala. Is there a law which incapacitates an heir because he's already a resident of another country? Wala din. Is there a law which incapacitates a person, an heir, because he's suffering civil interdiction? Wala. In fact, if you have read the provisions, ang tanong susunod, pwede ba siyang tumanggap ng mana? Because he's suffering civil interdiction, hindi pwede. He cannot accept by himself because the law requires for an heir to be able to accept, he must have free disposal of his properties. And since he's suffering civil interdiction, then he doesn't have free disposal of his properties, at least by act inter vivos. Okay? Pero, pwedeng guardian niya ang mag-accept. Okay? Kaya, hindi totoo na because he's suffering civil interdiction, he cannot inherit. Itong letter E, because he died before the filing of the petition, mali din. Because the law 777, successional rights are transmitted upon death. So even if before the filing, saka lang siya namatay, still at the time of the death, nandun pa siya. He was still alive. He can still inherit. Okay? Although malas-malas niya, hindi na siya masyadong sa Tagalog, nagpasasa sa kanyang mamanahin. Okay? Because namatay siya. But nonetheless, he already inherited. Okay? So, ang tamang sagot is letter D. Because he predeceased. Why? Because of 1025. The law requires the heir that he must be living at the time of the opening of succession, which is at the point of death, upon death. Okay? In other words, kung isang heir na unang namatay kaysa doon sa taong ito ay wala, he cannot inherit at all. May exception ba nakalagay sa batas in cases where right of representation is proper? I would agree with Tolentino, hindi totoo yan. There is no such proper right of representation if he predeceased. What is meant by the law ay hindi siya ang magmamana, rather yung anak niya pwede magmana. Ito ang scenario. Si X, may anak si A, pero si A may anak si B. If A predeceased X, I will not inherit from X. Never. 100%. Inauna pa siyang namatay Obviously, he was not living. But will he inherit by right of representation? Never. Okay? Not even by right of representation. But yung anak niya, pwede magmana by right of representation. Okay? In other words, like kung may kapatid si A, si C, ang nag-survive, si B at saka si C, si B may inherit by right of representation. Not A, not the one who predeceased. Okay? Under that article. Now, so ang hahanapin natin ay, what are these laws which would incapacitate a certain heir from succeeding, from inheriting? Yung incapacity basically dalawa. May absolute, may relative incapacity. From the names, makikita nyo, absolute, this person, this heir, cannot inherit from anyone in whatever capacity involving anything, okay? Under the circumstances. Halimbawa, because he predeceased, he will never inherit from anyone who was still alive at the time of his death. Okay? That is an absolute incapacity. Okay? Pero ang madalas din ang scenario na yan, nag-predecease. Pero another scenario is, who may be this heir who was not living at the time of the opening of succession? Ang issue dyan, conceived children. Okay? Kasi nung namatay itong taong ito, si X, okay? Buntis na ang asawa. Okay? Kaya, magmamana na ba ang batang yan? Pwede. Depending on the circumstances, as will be shown in a while. Okay? Pero, pagdating sa relative incapacity, an heir may be incapacitated relative lang because he may not inherit only from this person or persons, but he can inherit from all other persons in the world. Or he may not inherit from this decedent or from this testator only as a voluntary heir. Kung binigyan siya ng kotse, hindi niya pwedeng manahin ang kotse. Pero he may inherit as a compulsory heir. Okay? Or, okay? So, as to certain persons, in a certain capacity, but he may inherit depending on the incapacity, like ang pinatay niya ay kapatid, okay lang, wag lang yung mamanahan niya, di ba? Marunong ka dapat, pumili ka, di ba? Kung saan, okay? O sino, okay? Anyway, ito ang isang magandang tanong. This is a good question, which is a combination of persons and succession, which is almost always the case, okay? Combination. Parang kanina, yung Kevin, di ba? Combination yan. Isidro and Irma Filipinos, both 18 years old, 18 years of age, were passengers of Flight 317 or Oriental Airlines or UP. The plane they boarded was of the Philippine registry. While en route from Manila to Greece, some passengers hijacked the plane, held the chief pilot hostage at the cockpit, and ordered him to fly instead to Libya. During the hijacking, Isidro suffered a heart attack and was on the verge of death. Since Irma was already 8 months pregnant by Isidro, she pleaded to the hijackers to allow the assistant pilot to solemnize her marriage with Isidro. Soon after the marriage, Isidro expired. As the plane landed in Libya, Irma gave birth. However, the baby died a few minutes after complete delivery. Back in the Philippines, Irma immediately filed a claim for inheritance. Siyempre sa asawa niya. Okay? The parents of Isidro opposed her claim, contending that the marriage between her and Isidro was void ab initio on the following grounds. A. They had not given their consent to the marriage of their son. B. There was no marriage license. C. The solemnizing officer had no authority to perform the marriage. And D. The solemnizing officer did not file an affidavit of marriage with the proper civil registrar. Does Irma have successional rights at all? On its face, ang sagot yes. Okay? Ang sagot yes is because even if the claim of the parents is true, na void ang marriage, that child is an illegitimate child. And therefore, that child will inherit from the father. Why? because the child was already 8 months old. Okay? In other words, even if the child died a few minutes after birth, buhay siya, it already acquired a juridical personality. Okay? Ang hindi lang makaka-acquire are those less than 7 months. And they did not survive for a minimum of 24 hours. Wala, hindi magmamana yon. Since nagmana ang batang ito, even if illegitimate child, when he himself died, the mother inherits from him. Although, take note, ang nanay magmamana as a reservista, if you still remember, okay? There will be a reserva troncal in this scenario, okay? But we will discuss in detail sa reserva troncal. Pero magmamana nonetheless, okay? But, lalong magmamana siya if the marriage is valid because she will inherit as the spouse, not just as the not just the mother of the child, okay? But is the marriage here valid? I would readily take the position the marriage is valid, okay? Una, they had not given their consent to the marriage. Does that really result in a void marriage? Wrong. That will only make the marriage voidable. But when one of them died without the marriage having been annulled, it will forever be valid. It can no longer be questioned or can be annulled. Wala na dissolved na ang marriage. Pangalawa, there was no marriage license. Wala din. In articulo mortis ito And this is one of the exceptions to the rule na dapat may marriage license. Pangatlo, yung solemnizing office did not file an affidavit of marriage, that is just an irregularity. And that person may be held administratively liable, but that will not affect the validity of the marriage. Ang issue dito yung letter C, alleged issue. The solemnizing officer had no authority. Pero, even under the family code, it can even be argued that there are 2 articles sa family code. Well, yung isa nakalagay, airplane chief. So, mukha kang nag-solemnize, hindi airplane chief. In another article, pilot lang ang nakalagay. Hindi naman sinabing chief pilot. Okay? So, maski sinong pilot, baka pwede na. But there is another argument. Okay? Because the chief pilot is incapacitated, he may have delegated the power to the assistant pilot. But the best argument here is, I am 100% Irma would claim that she believed in good faith that the solemnizing officer has the authority to solemnize marriage. Interesado ka nga na ma-declare na valid ang marriage. You will always tell the court, okay, na I believed in good faith. Maski nga, what if law student si Irma? Imalay natin, good faith pa rin yun, di ba? Kasi difficult question of law. Tayo nga, na ang mga experts na didibati So, pwede pa rin si Irma, okay? Kaya the answer is very much yes. She will inherit both from Isidro and her child, okay? Dito only from her child, no, because the marriage is void. The child died a few minutes after complete delivery, it doesn't matter. The child was already 8 months old, okay? Now, this one is also a good question. Imagine nyo, 10%. This is a rare year. There were 30% of the questions nasa succession, which is unusual. Ito ang pinaka-heavy na weight in recent years, okay? For purpose of this question, assume all formalities and procedural requirements have been complied with, okay? In 1970, Ramon and Desa got married, okay? Prior to their marriage, Ramon had a child, Ana. In 1971, Senator Ramon and Desa legally adopted Quirie and Michelle respectively. In 1973, Desa died while giving birth to Larry. Ana had a child, Leah. Ana never married. Quirie and the other legally adopted Shelly. Larry had twins, Hans and Gretel, with his girlfriend, Fiona. 2005, Ana, Larry, Quirie, and Caracel. 2007, Ramon died. Who may inherit from Ramon? Who may not? Give your... Komplikado ang buhay. Talaga. Kaya, at this time, pag hindi ka nag-drawing, I don't think you can answer this question correctly. Di ba? At pag nag-drawing kayo, maayos ang sino ang namatay na una, sino ang sumunod namatay. But I will tell you again, the most important is whose property is under consideration. Sa dinami-dami ng namatay, okay, ang importante ay ang kay Ramon. Okay? So, who may inherit from Ramon, who may not. Actually, pag ang tanong ng examiner, who may inherit, pati yung iba na will not inherit, you should explain why they will not inherit. In real life, pag abogado ka at hindi mo in-explain doon sa tao bakit hindi siya magmamana, baka saksakin ka paglabas mo doon sa meeting room. Okay? Bakit ako walang mana, wala akong share? Okay? Now, so ito ang medyo komplikadong facts. Okay? Si Ramon may asawa si Desa. Namatay sa 2007, si Desa 73. Si Ramon had a child, Ana, who also died 2005. Pero si Ana, may anak na si Leah. Pero malinaw sa facts, Leah is an illegitimate child. Kasi Ana never married, di ba? Kaya ang anak niya clearly is an illegitimate child. Pero silang dalawa had children, okay? Had a child, Larry, okay? Pero nag-adapt sila kay Cherry and Michelle. Actually, there appears to be a problem of prior to the marriage, sa mga child, 71%, Ramon Desa legally adopted Cherry and Michelle respectively. Respectively meaning, si Ramon nag-adopt kay Cherry, si Desa kay Michelle, hindi. Okay? The better interpretation, respectively, 71 and 72. Okay? Kasi ang adoption normally ay joint. Di ba? Kaya si Cherry in-adopt 71, si Michelle in-adopt 72. Okay? By the spouses. So, kaya lang si Larry had children. Pero ang nanay ay si Fiona, who is his girlfriend. Mukhang hindi rin kasal. Kaya ang mga anak, Hans and Gretel, are illegitimate children. Pero itong si Cherry and Michelle were adopted. Pero itong si Shelley, adopted child ni Sherry, who is also an adopted child. Pero naunang namatay si Ana, si Larry, si Cherry. Yung tatlong yan. Okay? Pang-apat si Desa. So, who may not inherit to this portion, who may not? Clearly, ang unang sagot, Desa, Ana, Larry, and Cherry may not inherit because they were no longer living at the time of the opening of succession. Out na kaagad sila. So, ang susunod mo na lang ay, simulan natin kay Fiona. Fiona cannot inherit kay Ramon kasi she is just the girlfriend of the child of Ramon. Okay? So, she is not an heir. Okay? Hans and Gretel, can they inherit from Ramon? The answer is no. Because of the Iron Curtain Rule. In the problem, intestate succession ito. And therefore, an illegitimate child like Hans cannot inherit from the legitimate relatives of his parents. Okay? Kaya itong dalawa are barred from inheriting from Ramon under the Iron Curtain Rule 992. So out na ito, si Michelle can inherit kasi adopted child. Wala namang sinabing namatay siya o pinatay, kaya buhay pa siya. Pero si Shelley is just the adopted child of Sherry, therefore she cannot inherit from Ramon by right of representation. Because again, adoption creates only a legal relationship between adopter and the adopted. Ang pinaka-problema lang dyan ay si Leah. Okay? Because illegitimate child siya ng child of Ramon before the marriage, di ba? Prior to the marriage, Ramon had a child, okay? And therefore, because child siya before the marriage, automatically illegitimate? Not necessarily, because Ramon may had a prior marriage. And therefore, the answer could be, it depends on whether Ana is an illegitimate child or a legitimate child. Because if Ana is a legitimate child, Leah cannot inherit from her lolo under the Iron Curtain Rule. But if Ana is also an illegitimate child of Ramon, and since Leah is also an illegitimate child, 992 for the Iron Curtain Rule is not applicable. What is applicable is 990. Okay? And thus, an illegitimate child may inherit from the illegitimate parent of his illegitimate parent. Okay? Kumbaga sa mathematics, negative a physics pala yun. negative ang labas, positive pagdating sa succession. Parang sa batas natin, bad faith ang effect, good faith, di ba? Pero hindi palaging ganon, okay? But dito, ito yung, even Justice J.B. Reyes would criticize 992, the Iron Curtain Rule. Kasi, of course, aside from nag-discriminate ito sa illegitimate children, hindi consistent ang batas. Kung ang illegitimate child, si Leah, ay illegitimate child of an illegitimate child, pwede siyang magmana. Di ba parang mas worse ang scenario? Parehong mga illegitimate children. Pero pwede siya magmana. Pero nagkataon si Anna, legitimate child, hindi siya pwede magmana. Something is wrong with the law. Okay? Tingin ko rin. Okay? That is also I agree with Justice J.B. Alvarez. In other words, 10 points yan, by all means, explain mo lahat. Okay? Kung kailangan 2 pages ang explanation mo, 2 pages dapat. 10 points. And that happened in 2010. Okay? There were only about 10 questions. Supposedly, 2 examiners ang naging chismis, isa na lang ang naging examiner. Kaya ang konting-konti ang tanong, kaya matatapos mo exam in 2 hours or even less. Pag ganun, explain mo lahat-lahat, talagang detailed ang pag-explain. Lahat ng reasons nakasulat, di ba? Why this heir will not inherit, why this heir may inherit. Okay? Now, so ang sagot, Michelle and Leah, if Anna is an illegitimate child, as to Leah. And then, this one would go already into the next questions or MCQs specifically would pertain to relative incapacity. Okay? Who are considered incapacitated pero relative lang na incapacity. This problem pertains to anong article ito, okay? Kung acts of unworthiness nasa 1032, tama no? 1032, okay? Ito 1027 in relation to priests, ministers of gospel, okay? Suppose that the beneficiary in a will is the wife of the minister of the gospel who rendered aid to the testator during the latter's last illness. Would she be disqualified from inheriting from the testator? So, asawa ng minister of gospel who rendered aid. Okay? Ito ang possible options. Yes. Because the law expressly incapacitates the spouse of the minister, hindi totoo ito, okay? If you read the provision, the article, there is nothing in that law which would tell us na the wives are also incapacitated, okay? Ang nakalagay ay within the 4th civil degree. Strictly speaking, ang wife ay hindi within the 4th civil degree, okay? But pangalawa, yes, because even relatives within the 4th degree are incapacitated as long as it was spiritual aid. Letter C, no, because she's not one of the considered incapacitated by law, and no, because she cannot be the legal wife of the minister. Tama ba yun? Yung last naman ay hindi totoo, okay? Because ang mga ministers of gospel, not just in this country, but in other countries, are very much married. O pwede silang mag-asawa at least, okay? You should have watched, I don't know kung meron pa, Seventh Heaven, diba? May pamilya siya, may asawa, may mga anak. In fact, ang mga anak nila, mga sikat na ngayon, diba? Si Biel, si Jessica Biel, okay? Now, dati, bata-bata pa nun, parang 5 years old, 6, 7 years old. Now, thus, this is not true, but hindi rin ito tama, alin dito? This appears to be correct. No, because she's not one of those considered incapacitated. As I told you, ang rule is, persons not incapacitated may succeed. She is not one of those included. Therefore, she may succeed. Parang there is no law incapacitating her. If you will read the provision literally. Okay? Dahil hindi kasama ang wife ng minister ng pare. Pero I think the law did not include the wife ng pare kasi wala dapat asawa ang pare. although in real life, they are married, okay? Or some of them are very much married. And there is an association of married priests in the Philippines, okay? Yung marriage nila, valid ba? I think so. As long as the requisites are present, sa mata ng batas, valid yan. Sa mata ng Katoliko, ng Catholic Church, syempre, void. Kasal na siya sa isa bigamos na yan, di ba? Kung mag-asawa sila ng iba. Now, but, I fully agree with this position that the answer is letter B. By considering the intention of the law. Kung second cousin nga, bawal, asawa pa kaya, di ba walang sense kung i-interpret mo literally ang batas? Sabi ng batas, even yung relatives within the fourth degree, bawal, incapacitated yan. In other words, pag nagbigay doon sa pinsan ng pari na ito or minister of gospel, ay that will be he will not be capacitated to inherit. Lalo na asawa. Okay? I think it should be the better interpretation. Kaya lang mayroong requirement as long as it was spiritual aid because malinaw sa facts, rendered aid. Ang sabi lang naman ng batas, the incapacity will arise if he rendered spiritual aid. Pero kung financial aid lang siguro, wala naman siguro masama. Di ba may sakit nga kailangan ng tulong. Pero iba kasi ang spiritual aid. Parang ang batas would presume na mayroong undue influence dyan. Okay? Kasi ikaw ang tulong spiritually during his last illness. Lalo na ang pari was the one who heard the confession during the last illness. Okay? So, iyon ang sagot. But this one, absolute incapacity. X died January 15, 2005, survived by his wife Y and the paramour Z. A legitimate child of X, died on December 31, 2004. Y gave birth to B on December 30, 2005. Z gave birth to C 5 months after the death of X. However, C died 5 hours after birth. Who may inherit from X? CA, legitimate child who died December 31, he cannot inherit because he predeceased. He was no longer living at the time of the opening of succession, which is January 15, 2005. Si B, Y gave birth to B on December 30, 2005. Si Y, asawa ni X. Therefore, B may inherit, hindi rin. Dating asawa ni X si Y. Kasal namatay si X. Nung pinanganak siya December 30, 2005, namatay si X January, B cannot be the son of X. Anak ito ng kapitbahay ni X. Okay? Pwede yung driver ni X, nang buhay pa siya. So, sa tao, 9 months lang ang gestation period. Okay? Hindi 11 months or 12 months. Okay? Now, letter C, ang problem kay letter C, pwedeng sabihin, Y gave birth to, Z gave birth, si Z paramour, di ba? But, she gave birth to C 5 months after the death of X. If 5 months lang, C died 5 hours, mukhang wala pang 24 hours. But, gave birth 5 months after the death, but C may have been 4 months old at the time of the death. Kaya nung pinanganak siya 5 months after the death, full 9 months na siya. Kaya does it matter kung mamatay siya 5 hours after death? It doesn't matter. Ang question lang ay, who may inherit? C may inherit if at the time of his birth, okay, he had an intrauterine life of at least 7 months. Okay? Baka nung namatay si X, 2 months pregnant ang kanyang nanay. Okay? So, nung pinanganak niya, 7 months na, it doesn't matter if he died 5 hours after birth. So, the answer is C. Now, parang similar lang yan. Okay? Kaya, break muna tayo. Ito na yung mga priests, mga A, B, C, and D was given. Okay? A was the priest who heard the confession of the testator 5 years before his death. B was the guardian of X. C is one of the attesting witnesses to the execution of the will of X. D was convicted of adultery. Who may inherit from X as a voluntary heir? Out of these four, who may inherit? The answer is all of the above, okay? May inherit, okay? Why? Because the priest may have heard the confession of the testator, but it was 5 years before his death, and therefore it may not be during his last illness, okay? But the other reason is because this will may have been executed before the confession. In order for the priest to be incapacitated, the execution must be after the confession, because the reason behind this incapacity is undue influence was employed by the priest upon this testator, okay? Yung pangalawa, B was the guardian of X. He may inherit even if he was the guardian of X. Many reasons, like one of them, the priest could be the person, si B could be the spouse, could be the parent of the testator. Thus, the incapacity will not apply, okay? Now, C is one of the attesting witnesses to the execution. There is an exception to this. Which is not clear in 1027. If you will just read 1027, it would appear that all witnesses to the execution of the will would be incapacitated to inherit by testamentary succession, but not true. By way of exception under 823, if this witness is maybe the fourth, okay? In other words, there are at least 4 witnesses, and this witness is a legatee or devisee, he may inherit because there are 3 other competent witnesses, okay? Although if he is one of the 3, he can still be considered as a competent witness, therefore the will may still be valid. It is only the disposition in his favor which is void, okay? But again, if there are at least 3 other competent witnesses, itong si C may inherit, okay? Finally, D was convicted of adultery. Not everyone who is convicted of adultery would be incapacitated. He must be convicted of adultery with the spouse of the testator, which would make it an act of unworthiness, or convicted of adultery or guilty of adultery with the testator himself, because that would be an immoral, okay, disposition. So otherwise, if the conviction is with any other person, then there would be no such incapacity. Thus the answer is all of the above. Now, A was the priest who heard the confession. Jaizhi's illness in the will of X, a parcel of land was given to B. B may inherit. Again, before anything else, ang 1027 would pertain to testamentary succession, okay? In other words, itong mga priests, itong guardians, even if they are incapacitated to inherit as a voluntary heir, they may nonetheless inherit as a compulsory or legal heir. But they cannot inherit what was given to them in the will. Actually, halimbawa, what was given to them in the will to an heir is a car, a specific car. He may not inherit that car as a voluntary heir, but he may inherit that car as a compulsory heir if he is a compulsory heir of the decedent, not because it was given to him in the will, but because it might be considered as part of his share in the inheritance. Okay? Now, dito sa priest, in the will of X was given to B, and B may inherit if he is, okay? The first cousin of A, the grandson of A, father of A, brother of A, all of the above may inherit. The answer is none of the above, okay? Because the prohibition or the incapacity as far as priests are concerned would include those who are within the 4th civil degree. lahat ng mga ito ay within the fourth, including the first cousins. Now, this X died leaving a last will and testament wherein it is stated that he was legally married to W, by whom he had two legitimate children, A and B. He devised to his said forced heirs the entire estate except the free portion, okay, which he gave to X, who was living with him at the time of his death, okay. In the said will, explained that he had been estranged from his wife for more than 20 years and has been living with X's man and wife since his separation from his legitimate family. In the probate proceedings, X asked for the issuance of letters testamentary in accordance with the will, wherein she is named sole executor. This was opposed by W, the wife, and her children. Itong case na ito, this is similar to the case of Nepomuceno versus Court of Appeals. Now, is the device to X valid? Okay? Ito, maling word yan. Okay? Device. What was given to her was the free portion, and that is not a device. A device pertains to a specific real property, like a parcel of land. At any rate, is this disposition valid? The answer is clearly no, because the prohibition in donations inter vivos were made applicable to testamentary provisions. Okay? I think this is Article 1028. So those who are prohibited from giving, okay, by way of donation also cannot give through a will. Okay? Now, this is good, okay? The husband was granted a decree of legal separation, the grant of adultery on the part of the wife. May the wife inherit from the husband by intestate succession, by will? As far as intestate succession, the answer is no, okay? Because whatever was given to the wife, to the guilty spouse, if there is legal separation by operation of law, it is deemed revoked, okay? But by will, the answer is yes. Okay? If the will was executed after the decree of legal separation, which is a form of condonation. Okay? Pinapatawad na niya ang asawa niya. Okay? So the answer is yes, through a will executed after decree of legal separation. Okay? This is really wrong. That she is no longer the legal wife. She is still the wife despite the decree of legal separation. Okay? Hindi naman absolute yung incapacity. Okay? Now, Abraham died intestate January 7, 1994, survived by his son Braulio. Abraham's older son Carlos died February 14, okay? Which means the son predeceased the father. Okay? Danilo claims to be an adulterous child of Carlos, intervenes in the proceedings for the settlement of the estate of Abraham in representation of Carlos. Danilo was legally adopted on 17 March 1970 by Carlos with the consent of the latter's wife. Can Danilo inherit from Abraham in representation of his father Carlos? This bar exam question, I am 99.9 sure, is based on Tutico versus Del Val. Okay? Similar facts except that itong Danilo, Ana ito doon sa case. Okay? A girl. Okay? Ana Del Val. Now, can Danilo inherit in representation? The option. Ito ang scenarios. Okay? Si Abraham is the father of these two, but Carlos predeceased Abraham. And Carlos had an illegitimate child, Danilo, who was also legally adopted by Carlos with the consent of the wife. So namatay si Abraham, can Danilo inherit from Abraham by right of representation? Take note, merong isang anak pa si Abraham. Okay? The options, yes, because a child can inherit from the relatives of his parents by right of representation. That is not obviously the rule. Okay? Yes, because as an adopted child, he has all the rights of a legitimate child as to the relatives of the adopting parent. Again, mali. Okay? It is only between the adopter and the adopted. Letter D, no, because their father predeceased his grandfather. Letter C is really wrong because ang right of representation presupposes that one predeceases the other. Okay? Dahil nag-predecease, wala ng right of representation. Precisely, it should give rise under certain circumstances to the right of representation. The answer is letter D, because of the Iron Curtain rule, and adoption only creates a legal relationship between the adopter and the adopted. What's wrong with this? Is this not the Iron Curtain rule that a child can inherit from relatives? Ang Iron Curtain rule, an illegitimate child cannot inherit ab intestato from the legitimate relatives of his parents. Okay? So the child, parang si Danilo, is an illegitimate child, cannot inherit from the legitimate relatives of his parents ab intestato by operation of law. Pwede naman siya magmana through a will, but not by operation of law. Okay? Kaya this is the correct answer. Again, yung adoption creates a legal relationship only between the two, will not extend to the relatives of the adopter. Okay? Now, this one. A is the acknowledged natural child of B who died when A was already 22 years old. So si B ang namatay when A was already 20 years old. And A is the acknowledged natural child, which means illegitimate child. When B's full-blood brother C died, okay, kapatid ni B, ng tatay ni A, was survived by his widow and 4 children of his other brother D. So meron pa isang kapatid. Claiming that he is entitled to inherit from his father's brother C, A bought suit to obtain his share in the estate of C. So this is the estate na pinag-aawayan. Will his action prosper? Okay? Ang scenario is here, si A is an acknowledged natural child of B who predeceased C. Okay? 22 years old na si A nung namatay si B. Pero when C died, he was survived by the spouse and the children of D. Okay? So meron ding mga anak si D. I think ito yun. Okay? Was survived by his widow and 4 children of D. In other words, pati si D nag-predecease. Okay? Would A have the right to inherit from C? Clearly, the answer is no. Okay? Again, 992, Iron Curtain Rule. He cannot inherit ab intestato from the legitimate relatives of his parents. Pero, those relatives also cannot inherit from him. Okay? Baliktaran lang. Okay? Now, the answer is no. Being a legitimate child, he cannot inherit ab intestato from the legitimate relatives of his parents. Okay? Now, then, this one. A had 2 sons, one legitimate B and the other illegitimate C, who both died in a car accident. At the time of the accident, B was not married but had an illegitimate son. At least sinabi niyang illegitimate pa. Okay? C also had an illegitimate son, E. Upon learning of the death of his sons, A suffered a heart attack and died. Can D and E inherit from A? So again, if you will consider this, mag-drawing kayo, dalawang anak niya, B and C, B is legitimate, C is illegitimate. These two predeceased A. Nauna silang namatay, thereafter namatay si A. Survived by D and E, who are both illegitimate children. Can D and E inherit from A? Ang sagot dito ay only E can inherit from A. Because B is a legitimate child, an illegitimate child of B cannot inherit from the legitimate relatives of B. Pero, this is 992, under 991, yung rights ng illegitimate child will be transmitted to his children, whether legitimate or illegitimate. Ito yung sinasabi kong negative, positive ang dating. Okay? Ang Iron Curtain bars only the illegitimate from the legitimate relatives. not from the illegitimate relatives, okay, of the parents. Now, E, okay? And then A, a spurious child, died intestate, survived by B, the brother of his deceased mother, and C, his mother's legitimate granddaughter, okay? Kaya dapat alamin nyo ang mga relationships sila, okay? Parang magulo, okay? Survived by B, the brother of his deceased mother. Kung brother ng mother niya, meaning uncle niya. Di ba simple lang sana ang buhay kung sinabing uncle, okay? Pinahirapan pa. And his mother's legitimate granddaughter, actually, ito ay pamangkin niya. Di ba? Kung siya anak, ito granddaughter ng nanay niya must be the nephew or niece, okay? Daughter pala, niece niya. So effectively, may B and C inherit from A, yung uncle at saka ang niece. Ang dito si A, illegitimate child siya, di ba? So, may uncle siya, si B, kapatid ng mother niya, pero meron siyang, may granddaughter si M, apparently hindi niya anak, di ba? Hindi naman sinabing anak ni M, ni A. Therefore, would C and B inherit from A? Hindi rin. Ito yung baliktaran. While A cannot inherit from the legitimate relatives of his mother, like B and C, C and B also cannot inherit from him, okay? Under the Iron Curtain Rule. Now, the answer is neither B nor C under the Iron Curtain Rule. This is one of the best. Medyo natanong, pero maganda ang pagkaka-formulate, okay? Eugenio died without issue, leaving several parcels of land, okay, in Bataan. He was survived by Antonio, his legitimate brother, Martina, the only daughter of his predecessor sister, Mercedes, and 5 legitimate children of Joaquin, another predecessor brother. From that, mukhang 4 sila magkakapatid, di ba? Now, shortly after Eugenio's death, Antonio also died, leaving 3 legitimate children. Subsequently, Martina, the children of Joaquin, and the children of Antonio, executed an extrajudicial settlement of the estate of Eugenio, dividing it among themselves. Okay? Mukhang si Eugenio wala talagang anak. Okay? The succeeding year, a petition to annul the extrajudicial settlement was filed by Antero, an illegitimate son of Antonio, who claims he is entitled to share in the estate of Eugenio. So it would appear si Antonio hindi lang 3 ang anak, okay? Antonio died leaving 3 legitimate. Meron pa pala siyang illegitimate son, okay? Si Antero. So, ito ang tanong, okay? The defendants filed a motion to dismiss on the ground that Antero is barred by 992, yung Iron Curtain Rule, kasi illegitimate child siya, from inheriting from the legitimate brother of his father. How will you resolve the motion? Ito ang scenario. Si Joaquin actually may mga anak. 4 yata ang anak niya, 5. Si Eugenio ang walang anak. Si Antero may 3 legitimate and si Antero. Ito yung file ng action. Si Mercedes may 1 anak, si Martina. Okay? Now, itong children, Joaquin and Mercedes, predeceased. Pero when Eugenio died, he was survived by Antonio. Di ba? But when Antero is claimed that he has a share in the estate of Eugenio, the others would claim that he cannot have a share because he is barred by the Iron Curtain Rule. Di ba illegitimate child siya ng legitimate relative ni Eugenio? Eugenio and Antero are of legitimate relations. Kaya tama ba that Antero is barred as claimed? Barred by Iron Curtain Rule 992 from inheriting from the legitimate brother of his father. Parang tama pero mali. Okay? Because dito papasok ang time ng transmission of successional rights, the opening. If you remember from the facts, when Eugenio died, Antonio was still alive. Therefore, upon the death of Eugenio, Antonio inherited. But when Antonio died, nagmana sa kanya ang tatlong legitimate plus yung illegitimate. In other words, Antero is claiming a share from the estate of Eugenio, not because he directly inherited from Eugenio, but because he inherited from his father what his father inherited from Eugenio. Di ba? So sa drawing nga na yan, dahil namatay muna si Antonio bago si Antero, nagmana na si Antonio, nagmana si Antonio kay Eugenio, whatever he inherited from Eugenio, may share si Antero. So it's not about the Iron Curtain Rule. Sa Iron Curtain Rule, barred talaga siya. But because heir siya nung isang heir, yung minana ng heir na yon, minana din niya. And he is not barred from the Iron Curtain Rule in that scenario. Okay? Ang sagot, I will deny the motion. Okay? Because Antero will have a share from the estate of his father who inherited from Eugenio. Okay? Now, this one. Sa opening of succession. Again, this is 777. Successional rights will be transmitted upon death. Ang sabi ng, actually, one of my best professors, okay, Professor Balano, okay, he would disagree with this provision na successional rights are transmitted upon death. Ang tingin niya, successional rights shall be vested upon death. Okay? Pero mali yun. Tingin ko tama ang batas. Okay? Transmitted upon death, hindi lang vested. Because even if subject halimbawa to a condition, o kaya it was accepted only after several years, the effect of the acceptance retroacts to the date of the death. Kaya as if successional rights are transmitted upon death. E paano pag nag-refuse itong mga heirs? Tama pa rin ba ang transmitted? Tama pa rin. Somehow, somebody will accept. Okay? Ultimately, the state. Kaya tama yung not merely vested but transmitted. Okay? Although tama naman ang vested, pero effectively lalabas, transmitted pa rin on the very date of the death. Okay? Now, so this one, on A's death last year, his nearest of kin, take note, nearest of kin were a legitimate daughter born in 1945 and a spurious son born unrecognized by A in 1949. May the daughter oppose her brother's claim to their father's estate on the ground that it would impair her right under the old civil code to succeed to the exclusion of the spurious children. Take note, ang mga spurious children under the old civil code were not compulsory heirs, so they will be excluded by compulsory heirs. Okay? Pero tama ba itong daughter na ito? You have to consider the facts. Sabi ng examiner, on A's death last year. Last year, ibinigay ang exam 1983. So you should consider kung 2013 itong exam, that last year he meant 2012. Diba? But dito, even considering na 83, so 1982, tama ba ang claim ng daughter? The answer is no. Dahil ito ba? Yes, because under the old civil code, illegitimate children were not considered as compulsory heirs. Parang tama siya. Okay? But yes, under the old civil code will apply as both children were born before the effectivity of the civil code, which is really wrong. Okay? Because what law should apply would not depend on the birth of the heir, but on the death of the person whose succession is under consideration. Kung kailan siya namatay, yung law at that time ang applicable. Okay? Kaya kung namatay siya 1982, Civil Code of the Philippines na yan. Does it matter if the heir was born 1935? It doesn't matter. Okay? What matters is the point of death, the date of the death. No, because the law that shall apply is the law at the time of the probate. Mali-mali naman ito. But it is letter D. No, because the law that shall apply is the law at the time of the death of A, and under the facts, A died in 1982, and in 1982, even illegitimate children are compulsory heirs. Okay? Now, then this one. H and W are husband and wife. They have neither descendants should be nor ascendants. H died, and while the conjugal partnership was under judicial administration and pending liquidation, W donated all her share in her husband's estate to a friend, F. But thereafter, W died while the proceeding for the settlement of the conjugal partnership was pending. The collateral heirs of W and the administrator of the estate brought an action against the donee to set aside the donation on the ground that it is void, as it is a donation of future property. On its face, mali talagang argument. Okay? How could it be a future property when the donation was made after the death of the person? Okay? Ang future property is the person whose succession is supposed to be considered is still alive. That is future property. Okay? Pero dito, when the donation was made, donated all his husband asset to a friend F, that was after the death. Patay na. Ang successional rights again are vested upon the death. Kaya upon the death, he or she, the heir, would already have rights which he can assign, which he can sell. Gusto niyang ibenta ang hereditary rights. As I told you, gusto niya ipambayad sa utang by way of dasyon, he can do that. Okay? Kaya, the answer is decide. I will decide in favor of the donee. Okay? Because the rights of the succession are transmitted from the moment of the death of the decedent under 777. Ito isa sa pinakamadaling ma-memorize. 777. Okay? Now, then true or false. Okay? If the statement is false, explain your answer. A person can dispose of his corpse through acts inter vivos. Buhay pa siya, may corpse na siya, sarili niya. Parang mali-mali naman. Talagang really wrong. Okay? Ang pwede ay he can dispose of his corpse through an act mortis causa. Yung donation, okay? He can do that. If you are driving, okay, may license ka, driver's license, tingnan nyo sa likod, okay? You can donate some of your organs, okay? I-check nyo lang, okay? Kung anong organs ang i-check nyo, pwede, okay? Pero ako hindi ko chini-check, okay? Kasi may theory lang, may movie ako napanood na a person died. Parang accident ang on its face ang nangyari. Pero it turned out intentional palang pinatay. Kasi kamatch niya yung isang tao, kailangan yung mga organs niya. Kaya siya pinatay, o di ba? Kung doon sa card mo donor ka, ay nako, medyo tamang-tama ka for the harvest. Okay? Ina-harvest daw yung mga parang maganda yung mga ganyan, di ba? Yung patay na, nagagamit pa yung mga organs nila. Okay? One of my friends, actually my roommate for several years in a dormitory, had a problem with kidneys. Okay? Napakahirap palang magkaroon ng transplant with kidneys. Kailangan magmamatch ang kidney ng donor at saka ng yung sa donee para may 4 na dapat pwede mag-match. Pero makamatch ka lang ng 2, parang pwede na. Pero pag 4 talagang match na match talaga. Anyway, sa namatay, somebody died in an accident. Yung nag-a-apply sa National Kidney Institute, nirarank sila. Depende sa kung match ka doon sa namatay. Okay? It turned out, somebody was mas kamatch. Kung siya 2 ang nakamatch niya, yung isa parang 3 or 4, match na match talaga. Pero nag-benefit pa siya? Yes. Kasi namatay ang bata, okay, idalawang kidney, litig isa sila, di ba? Yung number 1, number 2, nakuha ng kidney. Very efficient ang kidney. Within minutes, hours after the operation, talagang nalinis na kagad ang kidney niya. Because the child who died was barely a teenager. Mukhang wala pang mga yosi, wala pang mga bisyo. Okay, so napaka-efficient. Okay, yun nga lang, napakamahal mag-maintain ng may transplant. Grabe. Parang for the first 6 months, parang 60,000 a month ang kailangan mong medicines. Okay? Pero later on, mga 30,000 a month, more than 20,000. Mahal, ano? Mahal mabuhay sa mundong ito. Okay? Kaya tayong mga healthy, ako, we should preserve. Okay? Now, this one, ang tanong the other year, can future inheritance be the subject of a contract of sale? There is an express provision sa Oblicon, I think this is 1347, that a future inheritance cannot be the subject matter of valid contract. Yun nga lang, dalawa nga ang option, and I think we have discussed this already. The answer is no, since the seller owns no inheritance while his predecessor lives. In other words, inchoate ang right ng heir until the death of the person. Maraming tanong dito in real life, okay? Where a child or the children of these parents would question the sale by their parents of properties, okay? Kasi claiming that the parents are impairing their legitimes ay maling-mali, okay? The rights of the heirs are only inchoate. Kung gusto ng parents na ibenta lahat ng properties nila, they can do that, okay? Without impairing any legitime. Ang legitime will be vested upon death only, kung may matira, di ba? Kung ayaw nilang bigyan kayo, they can always sell their properties. Sa kanila yon, okay? Now, then into the transmission of successional rights. These are the requisites, okay? Express will of the testator or provision of the law. In other words, even if there is no will, there can be transmission of successional rights, okay? Death of a person whose property is the subject of succession and acceptance of the inheritance. Sa bar exams, ito lang ang favorite, yung death, okay? Of course, doon sa will, pagdating sa formalities, etc. Okay? But yung acceptance, if I remember it correctly, isa lang ang tanong dito recently. Okay? So, into the death of the person whose property is death, kailangan ba ng may, is it physical death? Okay? The answer is no, pwede namang presumptive death. Which had not been asked about, ito muna, last year. The requisites of succession are as follows, okay? Death, transmissible estate, existence and capacity of successor designated by decedent or law, payment of taxes. Obviously, ang wala dito ay payment of taxes, okay? Yun lang, the property cannot be transferred in your name as an heir if you don't pay the taxes, okay? Now, ito, a matter of fact, okay? For purposes of succession, when is death deemed to occur or take place? Okay? When it is declared by the doctor, di ba, nagsasabi sila, time of death, okay? Pero meron din sila mga DOA, dead on arrival, di ba? Yung dead on arrival, therefore they died upon arrival, mukhang hindi. Pero pagdating nila sa hospital, patay na. But they could have been dead hours before or minutes before. Okay? Death as a fact is deemed to occur when it is declared by the court. Absolutely wrong. Okay? By the time dineclare na patay ng court, naagnas na yon. Okay? Ilang taon nang patay ang tao. Issuance of the death certificate, lalong hindi. Okay? Again, anong araw na ngayon? Last Thursday ba? When my cousin died, medyo matagal pala ang processing ng death certificate. Sabi ng tita ko, diba, andyan na yung lahat-lahat ng mga information, bakit it would take them hours, okay? Sabi ko, baka yung pipirma, wala pa, kaya hindi nila mag-process. But it's not the issue once, it is the fact of death. Bakit ganito ka-importante ito? Minutes may matter, di ba? Kung dalawang tao who are to succeed each other, ang isa namatay 5 minutes ahead of the other, yung isang nag-survive will inherit. Kaya importante up to the last second, up to the last minute, who died first. Okay? Sa ganung scenarios. The last one is the correct. Presumed death of an absentee under extraordinary circumstances is deemed to occur at the moment of disappearance. Okay? In other words, a good problem involving a will executed by X probably in 1985, okay? Wherein A is the device involving a condo unit, okay? Which is being rented, okay? So may rentals. Tapos, si A, in the first scenario, left the house, just told the housemates, I'll just go to Robinson's, mag-window shopping lang ako, but he never reappeared, okay? He disappeared na after 85. Let's say 1990, okay? Ito yung execution of the will. Ito yung disappearance, okay? Tapos, let's say 2005 ang petition for the probate of that will, declaration of presumptive death at the same time probate of the will, okay? And then the court may have issued the decree, okay? The declaration of presumptive death 2009, okay? In this scenario, when would X be presumed to have died, okay? In other words, when would A be entitled to the rentals, okay? From the time of execution, hindi naman, buhay pa si testator niyan, okay? But from the time of disappearance, this is walang danger of death. Ang requirement ng batas, 10 years. Okay? 10 years unless si X was already 75, which would require na lang 5 years. Now, kung 10 years, that would be 2,000. Okay? Kung nag-file ng petition lang 2005, okay? At ang korte nag-declare 2009, when would X be deemed to have died? Hindi 2009, hindi rin sa filing ng petition. It is from the mere expiration of the period required by law. In other words, by 2000, okay, X will be considered to have died upon the expiration of this period. In other words, A will be entitled to rentals from 2000 hanggang ngayon, okay? Because A will be deemed to have inherited by the year 2000. However, in another scenario, execution 85 pa rin. However, in 1990, he was one of the passengers ng isang barko which capsized, maybe ala Doña Marilyn, okay? And his body was never recovered, okay? Now, but again, kailan pwede mag-file ng petition? Can a petition be filed 1992? Hindi pa pwede. Because the body had not been found. Di siguradong patay. The law requires a period of 4 years. So 1994 ang pinaka-earliest na time for the filing of the petition for declaration of presumptive death. And again, dahil 1994, it could be year 2000 nung nag-declare ang korte, oo nga, okay? Mukhang patay na siya, okay? Pero pag 2000 ang declaration, ang decision ng korte, when would X be considered to have died? Would it be, siyempre hindi 85, hindi rin 2000. Would it be 1994 at the time of the expiration? Hindi. It will be at the time of the disappearance, when there is danger of death. In other words, dahil pasahero siya ng barko na nag-capsize, it cannot be reasonably presumed na lumangoy muna siya ng 4 na taon bago siya namatay, di ba? He must be presumed to have died on the date the event happened, nung nag-capsize ang ship. Kaya lang, anong purpose ng 4 years? Bakit kailangan maghintay? Baka buhay pa. Okay? Baka nandun lang sa isang isla at nawalan ng memory. Diba? Nagka-amnesia lang siya. Kaya, maghintay tayo ng 4 years. Pero, hanggang yung pagiging owner ni A will start in 1990. He will be entitled to the rentals from the time nag-capsize yung ship na yon. Okay? Now, but hindi yan masyado ang paborito, okay? Ang paborito would pertain to scenarios where 2 persons died in a certain incident. Like, aeroplano, barko, namatay sila pareho, okay? Thus, ito, Christy and her late husband, Luis, had 2 children, Rose and Patrick. One summer, her mother-in-law, aged 70, took the 2 children, then aged 10 and 12, with her on a boat trip to Cebu. Unfortunately, the vessel sank en route, and the bodies of the 3 were never found. None of the survivors ever saw them on the water. Okay? On the settlement of her mother-in-law's estate, Christy files a claim for a share of her estate on the ground that the same was inherited by her children from their grandmother in representation of the father, and she inherited the same from them. Will her action prosper? Ito ang drawing. Mother, yung son niya predeceased her, na unang namatay, okay? Married to Christy, so the widow of Luis. Anak nila 2, so the grandchildren of this mother. 10 years old lang ito, 12, ito 70. Okay? Now, again, will her action prosper? The options. Yes, because Christy inherited from her children what her children inherited from their grandmother in representation of their father, which is the claim of Christy. Tama ba ang claim na ito ni Christy? Or, yes, because under the survivorship rule, her mother-in-law is presumed to have died ahead of her children. In other words, her children survived the mother-in-law. Why? Because the children, ang age, less than 15. Yung lola, more than 65, more than 60. Okay? And therefore, under the survivorship rule, those below 15 are deemed to survive those who are above 60. Okay? Pero tama ba yan? Let her say no because she is not an heir of her mother-in-law. Or let her be no because they are deemed to have died at the same time and therefore her children did not inherit from their grandmother. She is not an heir of her mother-in-law. Totoo ba yan? Of course it is true. Okay? Dahil mag-in-laws sila, so they are not heirs of each other. The law will not consider them heirs of each other kasi magkaaway sila. Di ba? Pero hindi naman palagi, okay? Minsan magkaibigan yan, okay? I think my parents, paborito nila ang sister-in-law ko kaysa sa brother ko, okay? But this is wrong. She is not claiming to be an heir of her mother-in-law. She is claiming to have a share as to what her children inherited from their grandmother. By right of representation kasi yung asawa niya, who is the father of the children, predeceased the grandmother. Okay? Kung totoong ganon, kung ano, ito yon, okay? But letter B is really wrong, okay? The survivorship rule does not apply to succession, okay? Do not ever apply the survivorship rule. What is applicable sa succession is Article 43, okay? As to two persons who are to succeed each other, as to who died first, okay? Whoever would claim that one died ahead of the other has to prove the same, okay? Kaya lang dito, meron bang proof? Wala. Ang nakalagay, none of the survivors ever saw them on the water. Mukhang walang proof that one died or that children died ahead of the lola or vice versa. Therefore, under Article 43, if there is no proof, they will be deemed to have died at the same time. And therefore, there will be no transmission of successional rights because ang requirement ng 1025, the heir must be living at the time of the opening of succession. Kung sabay sila, walang magmamana sa kanila. Okay? The answer therefore here is letter D. No, because they are deemed to have died at the same time, therefore children did not inherit from their grandmother under Article 43, not under the survivorship rule. Okay? We'll go into the survivorship rule in a while. Okay? Now, this is similar, okay? Kaya lang meron ng relevant na dito ang survivorship rule, okay? Jaime, who is 65, and his son Willie, who is 25, died in a plane crash, okay? There is no proof as to who died first. Ito mas malinaw ang facts, okay? Jaime's only surviving heir is his wife, Julia, who is also Willie's mother, okay? Willie's surviving heirs are his mother, Julia, and his wife, Wilma. First question, in the settlement of Jaime's estate, can Wilma successfully claim that her late husband Willie had a hereditary share since he was much younger, 25 lang, than his father who is 65 and therefore should be presumed to have survived longer? Take note, settlement of the estate. Second, suppose Jaime had a life insurance policy with his wife, okay? Julia and his son Willie as the beneficiaries. Can Wilma successfully claim that one half of the proceeds should belong to Willie's estate? As to the first, should be presumed to have survived longer, that is wrong. Okay? Because again, the survivorship rule does not apply, and because there is no proof as to who died first, under Article 43, they shall be presumed to have died at the same time for purposes of succession. Okay? Therefore, no one will inherit from each other. Therefore, Wilma cannot successfully claim that her husband inherited from his father. Okay? Kaya walang mamanahin si Wilma sa kanyang asawa, which allegedly the husband inherit from the... She will inherit from her husband, not from the estate of the father. Okay? Pero kaya ang una dito, should the have survived longer? The answer is no. Okay? They are deemed to have died at the same time. The survivorship rule is not applicable. Okay? Itong yes, because those in the descending are preferred than those in the collateral, nothing to do with the problem. Okay? But sa pangalawang tanong, ito insurance policy. This time, if there is no proof as to who died first, kung ang insured survived doon sa tatay niya, okay? Doon sa beneficiary, okay? The survivorship rule is very much relevant. You can invoke the presumptions provided by this rule, okay? And under this rule, survivorship rule, ang importante niyong isipin ay ages ng 15 and 60. Pag both below 15, the older. Both above 60, the younger. One in between 15 and 60, the other one below or above 60, yung nasa gitna. Kasi kumbaga prime time yun di ba? Yun ang pinaka niya, kung medyo above, medyo ang tawag sa kanila mga senior citizen na, di ba? But Dito malinaw. Yung isa between 15 and 60 kasi 25. Yung isa is 65, therefore above 60. Okay? Therefore, the son is presumed to have survived the father. Okay? And therefore, he will benefit from the policy. Okay? Ang beneficiary hindi lang magbe-benefit if he died ahead, di ba? Dapat buhay siya. Okay? If buhay naman siya under the survivorship rule, therefore, sa pangalawang tanong, the answer is yes. Okay? Under the survivorship rule, one who is between 15 and 60 is presumed to have survived another who is more than 60. Yun lang ang last question dito. What if both of them are between 15 and 60? Who will be presumed to have survived? Ang sagot, the male. Pero, if they are of the same sex, the younger, okay, will be deemed to have survived. The older is deemed to have survived, okay? Now, then, ganun din itong problem na ito. May usapin ng succession, may usapin dito ng life insurance. So, sa succession, apply Article 43. Pagdating sa insurance policy, apply the survivorship rule, okay? Now, ito magandang tanong, okay? Dr. Lopez, 70-year-old widower, and his son Roberto both died in a fire that gutted their family while they were sleeping in their air-conditioned rooms. Roberto's wife, Marilyn, and their 2 children were spared because they were in the province at that time. Dr. Lopez left an estate worth 20 million, life policy in the amount of 1 million, with his 3 children, one of whom Roberto, as beneficiaries, okay? Marilyn is now claiming for herself and her children her husband's share in the estate left by Dr. Lopez and her husband's share in the proceeds of Dr. Lopez's life insurance policy. Rule on the validity of Marilyn's claims. Again, into the share in the estate, okay? Marilyn should be able to prove that her husband survived, okay? His father, okay? That is the requirement in Article 43. If there is no proof, lalo na kung opposite ang proof, the two will be deemed to have died at the same time, okay? Now, kaya hindi magmamana ang asawa niya, okay? And her children's share. Now, on the other hand, doon sa life insurance policy, ganun din. You apply the survivorship rule if there is no proof. Okay? Dito lumalabas, 70 years old na ang Lopez, ang tatay. Yung anak niya, sa tingin nyo, would be above 60? Di naman siguro. Alam naman, 8 years old pa lang ang tao nung nakabuntis. Di ba? So from the facts, you can deduce that the child, Roberto, must be between 60 and 15. Kaya pag survivorship rule, he will be presumed to have survived. Okay? Now, her claim will unless the proceeds of the insurance policy. Okay? 2011, ML inherited from his father 5 million in legitim, but he waived it in a public instrument in favor of his sister Quirie, who accepted the waiver in writing. But as it happened, ML borrowed 6 million from PF before the waiver. PF objected to the waiver and filed an action for its rescission, okay? On the ground that he had the right to ML's 5 million legitim as partial settlement of what ML owed him since ML had proved to be insolvent. Does PF as creditor have the right to rescind the waiver? The waiver has the same effect as repudiation, hindi tinanggap ng heir. Okay? Would the creditor have the right in a way to rescind the waiver and therefore accept the share in the inheritance? The answer is yes, by express provision of the law. Okay? In other words, in a way parang dinidefraud ng heir ang creditor niya, ang rights ng heir vested na. Okay? Kaya nung nagmana, if he only accepted, then the creditor could have levied upon such properties inherited by the debtor. Pero dahil ni-repudiate niya, aba baka mawalan ang creditor. So the law would give the creditor the right to accept, but only to the extent of his credit. In other words, kung ang property is worth 20 million, ang utang naman sa kanya 5 million lang, ang pwede lang niyang i-accept up to 5 million. Okay? The rest valid ang repudiation. Okay? Now, kaya ang sagot dito ay does have the right answer is yes. Okay? Because the waiver expresses the interest of third person whose interest is recognized by law. Okay? Now, into just a few minutes on acceptance, okay? While repudiation has to be in a public instrument, okay? Either doon sa proceeding or just in a public instrument, okay? Although nakalagay authentic or no, hindi pala. Authentic or public, okay? Now, what doon sa acceptance ay already required yung requisite that the person accepting must have free disposal of his properties. Okay? Kaya yung mga person suffering civil interdiction cannot validly accept, or yung mga minors cannot, but the share may be accepted by their guardians. Okay? Now, ang magandang itanong dito is, what if the heir repudiated, okay? Repudiated his share, will he be deemed to have accepted even if he repudiated? Okay? Parang, ang tanong parang malabo. How could he be considered to have accepted if he already repudiated? Okay? Although, una, tingnan natin ang relevance. Okay? Kung nag-repudiate ang heir, will he inherit? Siyempre hindi, because repudiated. So what's the relevance? Ang relevance could pertain to taxation. Because if he is deemed to have accepted, meron ng tax liability as to him, yung estate tax, but because he also conveyed his rights to another, it could be in a form of a sale or it could be in a form of donation. Okay? Kaya, dadalawa ang tax liabilities. Okay? Pero if he repudiated but he was not deemed to have accepted, kung sino lang ang tumanggap, isang tax liability lang. Di ba? Pangalawa dyan, aspect ng possession. Because if he already accepted, although he has repudiated, may interrupt ang period ng possession ng kabilang heir. Because dadaan muna sa kanya before it goes to the other heir. Okay? So, if the heir repudiated, may he be deemed to have accepted. Relevant ang question na yun also in the sense that pwede palang mag-deemed accepted even if he repudiated because of the fact na upon the death, vested na ang rights ng heir. Nandyan na. It's up to him whether he will accept or repudiate. Kasi it may be argued, he cannot repudiate what he doesn't have. Di ba? But he already has a vested right. Parang pagkain lang ito. Nandyan na ang pagkain, it's up to him kung ayaw niyang kainin or kakainin niya. But kung nirepudiate niya, but onerous repudiation, he will be deemed to have accepted. Parang may kapalit ang pag-repudiate niya. Okay? But also, even if gratuitous ang renunciation, but in favor of one or some, but not all those who would have inherited by way of accretion, he will be deemed to have accepted. In other words, namimili lang siya. Okay? Kung nirepudiate niya indiscriminately, gratuitous, and what he would have inherited were inherited by those who would have inherited by accretion, walang problema. He will not be deemed to have accepted. Pero naman, kung nag-renounce siya, gratuitous nga, but in favor only of one, samantalang dapat 5 ang dapat nagmana, ay he is deemed to have accepted. Okay? Kaya, yung implication sa taxation, prescription, would apply. Okay? Kaya, we can proceed to this. Okay? Into the kinds of succession. Okay? May succession be conferred by contracts or acts inter vivos? In a way, there was a bar exam. The first bar exam question which I presented to you, which was last year, succession is not by contract, di ba? This is because of those who are claiming that there is a kind of succession known as contractual succession. The law mentions only testamentary, legal or intestate, at saka mixed. Walang nakalagay na contractual. Despite that, there are some who would claim that there is contractual succession. Even before the family code, I already took the position that there is no such kind of contractual succession, meaning just following the requirements of contracts, as long as may signature ng mga parties, he may already inherit. Hindi totoo. Okay? Kasi kung ordinary will ito, there has to be 3 witnesses, there has to be an attestation clause, etc. Thus, to answer this question, may success be conferred by contracts? The answer is no. Okay? Especially under the family code. Okay? It is so clear under Article 84, second paragraph, future property, disposition of such property shall be in compliance with the requirements of the law as to wills. Okay? So, dadaan talaga sa formalities ng wills. Now, lalo na by acts inter vivos. Okay? Yung will is an act mortis causa. Okay? Even if there's a will. But kung walang will, obviously, the transmission of rights will only be by upon death. Okay? So, it cannot be inter vivos. What may be done inter vivos ay partition ng property. Okay? And as long as the partition of the properties to the heirs would not impair the legitimacy of the compulsory heirs, that can be recognized as a valid partition of the estate. Okay? Now, thus, ito nga, testamentary, legal, or intestate, or mixed, if a will was executed, then there will be testamentary succession. The answer is not necessarily. Okay? Because una, the will should be a valid will. Okay? If it is void, then walang testamentary succession. Pangalawa, it's a valid will, but it was revoked. Okay? So walang testamentary succession. Okay? It subsequently lost its effectivity or efficacy. Okay? So walang testamentary. Now, legal or intestate under 960, okay, would include no will, okay, he died intestate, or the will is void, or not all the properties of this testator were disposed of. So as to those properties not disposed of, those properties will be distributed by legal or intestate succession. I have already emphasized that we should call the succession intestate succession only if the person died intestate. Okay? If there is a will but the will is void, call it legal succession. Okay? Professor Balani is also would also emphasize that. Okay? Now, but also, even if all the properties were disposed of, pero the heirs renounced, and there will be legal succession. Or one of them renounced, but there will be accretion, okay? Then there can be legal succession, etc. Mix is just a combination. So, there would be properties that would be disposed of through a will, but some of the properties would be distributed by operation, by law. That would be a mixed succession. Now, this one. The testator executed a will following the formalities required by law on succession without designating any heir. The only testamentary disposition in the will is the recognition of the testator's illegitimate child with a popular actress. Is the will valid? This is Dean Pineda's question, and the answer given is yes. Okay, the recognition of an illegitimate heir is an ample reason for a will. Okay, In a way, it may be considered as a will because if an illegitimate child is recognized, that would affect the shares of the heirs. Okay? Kung dati ito lang ang heirs na dagdagan, about the shares of the others will be reduced. Okay? Because this illegitimate child, having been recognized, will clearly have a share in the inheritance. Okay? Kaya may pagka-disposition of an estate. Take note, in our law, if the document only appointed an executor, would that document be called a will? Will it be considered as a will? Ano naman kung will or hindi? Because if it is a will, the disposition can only be given effect if it would be probated. It has to comply with the formalities prescribed by law as to wills. But, yung tanong na yan, it is not considered as a will. Unlike in the United States na ang appointment of an executor is through a will, tayo, to be a will, there has to be a disposition of the property. Kaya kung walang disposition ng property, that is not a will, it is not required to be probated. Okay? Now, what are the characteristics of a will? Okay? Ito ang mga characteristics. Okay? It is an act of liberality, statutory right, purely or strictly personal act, voluntary act, solemn or formal act, ambulatory act, unitary act, act mortis causa, individual act. Some authors would include that it should comply, that it should dispose of properties, it should, etc. Hindi characteristics yun. Requirements yun for the will to be valid. These are the characteristics. Okay? Act of liberality, okay? Although the testator may impose burdens, okay, upon the on the heir. For example, the heir may be required to give a sum of money to another heir. Okay? Take note, legacies may be burdened by legacies. Okay? Like binigyan kita ng 10 million in my will, pero in the same will, I ask you to give, paano po if I ask the heir to give 15 million to another? 10 lang binigay ko, 15 million ang pinapabigay, hindi naman tama yon. Okay? But like 10 million, that heir may be required to give like 5 million to another heir. Okay? But nonetheless, it is an act of liberality. A purely statutory right, I fully support this position of justice imputed. Okay? That is a purely statutory right. My professor, who is now the dean of the UP College of Law, would also, Professor Cusarnego, would also agree to this. Okay? It is a purely statutory right, meaning the right of a person to dispose of his property through a will is only supported by a statute. It has no foundation under the Constitution. It is not a constitutionally protected right. Nasa civil code lang yan. In other words, if Congress would deem it proper na tanggalin ang provisions on testamentary succession, that will not violate the Constitution. Okay? I fully agree to that. Yun lang, we all know that hindi naman pwede bigyan ng retroactive effect ang law na yan. Okay? As to those who are already dead, ay hindi na pwede. Okay? Laws generally should be given prospective application. Okay? Now, purely statutory, purely or strictly personal, because the law, for example, provides that the testator cannot provide in the will that these dispositions will take effect depending on the decision of a third person. Okay? It would violate this characteristic of being a purely or strictly personal act. The fact that the will was was drafted by a lawyer, does that violate this characteristic? Hindi. Okay? Because ultimately, the lawyer will just have to follow his instructions. Di ba? Kung nung pinirmahan niya, it means that he agreed with those dispositions as drafted by the lawyer. Okay? Now, but also, for example, if another person would be authorized to determine whether a disposition will be valid or void, that would violate this characteristic, being purely personal act. Free and voluntary because it should be free from violence, intimidation, etc. Okay? Otherwise, the will cannot be probated. Now, solemn or formal because there are solemnities prescribed by law for the validity of wills, and pupunta tayo dyan sa mga solemnities in a while dahil favorite ang topic na yan. Okay? Now, ambulatory because until the death of this person, the rights of the heirs will not be vested. In other words, the dispositions in that will take effect only upon the death. Ambulatory, may pagka-ambulance, hindi stable. Okay? Parang takbo ng takbo. Okay? So, until the death, pwede pa niyang i-revoke yan. Pwede pa niyang baguhin yan. So, ambulatory. Now, which is, itong ambulatory is consistent with an act mortis causa that it will only take effect upon death. Kaya, pwede niyang i-baguhin, i-revoke, i-change. Okay? Unlike, for example, donations inter vivos na absolute, walang kondisyon, pag tinanggap na ng doni, ay hindi na pwedeng revoke, di ba? Kaya ito, opposite, it is merely an act mortis causa. Now, unilateral, okay, because only one of the parties would be obliged, yung heir normally wala namang obligation. But, ang favorite dito, aside from solemnities, ay that this is an individual act. In fact, last year, nag-appear din uli ito. Okay? Individual act because the law prohibits joint wills. Okay? Kaya it is an individual act. Kaya, halimbawa, this one, if you remember these facts, John, Paula, etc., na acquired Philippine citizenship, dating British citizens. Ang tanong, should the will be probated? I told you, ang sagot dito is no, because it is a joint will. And a joint will executed by Filipinos, even if they executed the will abroad, that cannot be given effect in this country. Even if the law where the will was executed allows joint wills, it doesn't matter. Okay? Ang premise, pareho silang Filipinos. Okay? Thus, the will is void. Take note, should the will be admitted probate? No, because a will is an individual act in the sense that Philippine law prohibits joint wills. Other countries actually do not prohibit joint wills. Sa Philippines, sa ibang countries, generally joint wills are prohibited except between spouses. So kung spouses, pwede sa kanila. Sa atin, it doesn't matter. Lahat, absolute ang prohibition. There are reasons given here like that would encourage parricide or attempting to kill the other spouse, okay, in joint wills. That argument is not necessarily true, okay? Because the premise of that argument is that joint wills are reciprocal wills. But just because a will is a joint will doesn't mean reciprocal. In other words, they may not have instituted each other as the heir, sole heir of the other. Maybe yung isa, ang kanyang heir ay si A. Yung pangalawa, ang heir niya ay si B. Magkaiba, okay? So, joint wills are not necessarily reciprocal wills. Joint will lang siya because the dispositions of two persons are contained in one instrument. Okay? In fact, just because the dispositions are contained in one piece of paper doesn't mean na joint will. Okay? Because pwede naman si X, ang kanyang dispositions nasa front page, yung si Y, ang kanyang dispositions nasa back page. So, hindi joint will, okay? Or, yung disposition ni X nasa taas, yung first half, yung bottom half, yung dispositions ni Y. So magkaiba, putulin mo na lang ang papel, di ba? So hindi talaga sa joint will. Now, so pag isang instrument lang where the dispositions of the two testators would be written, that would be a joint will, ang isang reason why prohibited daw ito is because this would diminish yung right ng testator to revoke their wills. Okay? That would affect the revocability of wills. Mali din ang premise nito. Because ang scenario dito is, dahil this is just one piece of paper, and one of them wanted to revoke, ayaw ng isa. So, hindi niya marirevoke. He wanted to burn, but the other party doesn't want to burn. So, he cannot burn the document. Kaya ang conclusion, that would affect daw the revocability. Mali. Because revocation is not only by destruction. Revocation may also be done by the execution of another instrument. Kung ayaw ipasunog, hindi mag-execute ka ng panibagong will in order to revoke that will which you executed with another person. If I would have to agree to this provision, yung wisdom, it goes into undue influence. Okay? Dahil isang papel lang ang susulatan nyo, more often than not, yung isa would employ undue influence upon the other. Parang kapareho lang ito ng mga priest who would hear the confession of the testator during his last illness. May undue influence, kaya ayaw ng batas. Okay? Now, but this one, Manuel, a Filipino, and his American wife Eleanor executed a joint will in Boston, okay, Massachusetts, when they were residing in said city. The law of Massachusetts allows the execution of joint wills. Shortly thereafter, Eleanor died. Can the said will be probated in the Philippines? Ang sagot dito ay yes, okay? Because the prohibition applies only to Filipinos, okay? Si Eleanor is an American citizen under the facts. Pagdating sa formalities, it can be the law of the national law of the testator, which can be applied. Okay? From 1818, 819, malinaw na Filipinos ang mga testators. Okay? For this prohibition to apply. Now, and ito ang 2011, Rick and Jaizhi, Filipinos, have been sweethearts for 5 years while working in a European country where the execution of joint wills are allowed. The two of them executed a joint holographic will where they named each other as sole heir of the other in case either of them dies. Ito yung joint will na reciprocal at the same time. Okay? Unfortunately, Rick died a year later. Can Jaizhi have the joint will successfully probated in the Philippines? The answer is definitely no. Okay? Again, even if it was executed in a country where joint wills are allowed, that would still not be probated in this country. That will still be a void will because the testators are Filipinos. Okay? No, since Philippine law prohibits the execution of joint wills and such law is binding on Rick and Jaizhi even abroad. Okay? Now, into the solemnities. Okay? Busalsal, okay? Napakaganda ng pangalan, okay? Executed a will in his handwriting, signed by him at the end of each page on the left marginal space of every page except the last page. The document bore no date. However, below Busalsal's signature were the signatures of two witnesses who later testified that the will was executed in their presence on this date and that Busalsal was in full possession of his faculties at the time and even explained to them the details of the will he was writing down. Is the will formally valid? Executed a will in his handwriting. So, pwede itong holographic will. But is it a valid holographic will? The answer is no. Because one of the requisites for A holographic will to be valid is date. It must be dated. Sabi the document bore no date, it is a void holographic will. Okay? But, because it is in his handwriting, may it be considered as an ordinary will, also known as notarial will, also known as attested will. Okay? Signed by him naman, each page, may marginal space, etc. Still, it cannot be a valid ordinary will because there are only 2 witnesses. Okay? As to ordinary wills, there should be at least 3 witnesses. Kaya ang sagot dito, the answer is no, whether treated as an ordinary or holographic will. My point here is, if you are asked as to the validity of a will, extrinsic validity, okay? The first thing that you should consider ay what kind of will. Is it notarial or is it holographic? Kasi magkaiba ang requisites, okay? If a will is entirely in the handwriting, pwede bang holographic, pwede notarial? Yes. But if it is only partially in the handwriting, partially printed, it may only be a valid ordinary will. It can never be a valid holographic will because the requirement is it must be entirely written by the hand of the testator as one of the requisites. Okay? Now, so into the requisites. Okay? 805 or 804. Let's start with 804. Okay? Yung mga non-cutative wills, are they valid in our jurisdiction? The answer is no. Okay? Non-cutative wills are orally declared wills. Okay? Not in this country or not yet. Okay? Nakikita natin sa mga sine, a person would face a camera, di ba? Tapos he would be talking about his dispositions. It may be valid in this country but not in our country because 804 requires that every will must be in writing. Okay? But, okay, if the will is not in a language, now, if the testator cannot read, okay, what is written on the will, is it a void will? Because the law requires that it must be in a language known to the testator. Because he cannot read, therefore it is not known to him, mali. Okay? A person may know the language, can communicate in a language, but he may not know how to read in that language. Okay? Maraming magaling mag-Tagalog, pero hindi marunong magbasa in Tagalog. Parang mga Amerikano lang yun, ang galing-galing mag-Ingles, pero marami sa kanila hindi marunong magbasa in English, lalo na hindi marunong magsulat. Okay? So what is only required by law is the language must be one known to the testator. Okay? Now, kaya lang, okay? If the testator signed, okay, does it mean that he knew the language in which the will was written? The answer is no. Ang galing-galing pumirma eh, di ba? Maski mga illiterate, I suppose nakakapirma sila. Okay? But is there at least a presumption that he knew the language? Wala din. Presumptions are not lightly inferred. They are provided by law at walang batas na nagsasabi that when a person signs, he is presumed to know the language in which the will is written. Okay? Pero pag holographic will ito at karmado niya, will that now at least raise a presumption that he knew the language in which the will was written? Holographic will eh. In his own handwriting. Therefore, he knew the language. Wala ding batas na ganon na nagsasabi that it would raise a presumption that he knew the language. And in fact, that would really be dangerous. Okay? Because dahil in your own handwriting, alam mo, aba hindi. Okay? I can copy a manuscript in Italian, kukopyahin ko lang, pero hindi ko alam pinagsasabi doon. Diba? Ganun din, if somebody has a shotgun and the person will be asked to copy what was written in another doc. Kopyahin mo in your own handwriting. He can do that, but he may not understand the language in which the will was written. Okay? But one last, okay? Into that requirement. If, as in one case, okay, the testatrix, okay, had lived in that place for so long a time, mga 30 years na siya nakatira sa Baguio, okay? And she executed the will in Baguio. Would that now raise the presumption that the language used is a language known to the testatrix? Mali pa rin, okay? Because the presumption will only arise if the language used in the will is the language used in the locality. Oo nga, 30 years na siya sa Baguio, she executed the will in Baguio, naman ang kanyang will is in English. So there will be no presumption that she knew the language in which the will was written. Pero, kung nakatira siya sa Tacloban, tagal-tagal niya sa Tacloban, 25 years na, okay? At ang will niya ay an inwaray, that will raise a presumption that he knew the language. Ang tagal niya. But the presumption, what kind? Disputable lang, because he may not actually know the language. Sabi ng iba, pag hindi mo alam ang language, ang tagal-tagal mo na, parang may pagka-snub ang dating mo, di ba? 20 years ka na sa lugar, hindi mo pa rin alam ang language nila. I don't know, maybe hindi siguro snub. Baka wala lang siyang capacity to understand the language of the place. Okay? Kasi may mga language talaga in some localities, napakahirap, parang mga ibon ang dating, di ba? Ganyan. Mahirap kung maintindihan yan, maski 20 years siguro. Pero actually, necessity really is the mother of invention. Okay? Ang ating mga kababayan, ang Japanese, mahirap, di ba? Yung Nihongo. Pero wag ka, ang ating mga kababayan, 2 weeks pa lang sa Japan, ang galing na mag-Nihongo. Dahil kailangan para kumita, di ba? Paano magkakaroon ng lapad kung walang di marunong mag-Nihongo? So in 2 weeks, ako alam na nila ang language. Okay? Now, actually, even yung language, nasa practice lang yan. Okay? Pa-practice mo na ipa-practice, naku, magiging magaling ka yan. So, language. Now, that's 804. Ito, one last very important. Magaling ang kaso na ito. Ano bang title ng case na ito? If you have been reading the actual wills, okay, I would ask my students to submit copies of wills. So nakapagbasa ko ng sangkatutak na wills. It is common in these wills, if not the first paragraph, the second paragraph of the will, that this will is in a language known to the testator. Therefore, the will is in a language known to the testator dahil nakasulat, hindi. Okay? But is it required by law that the will is in a language known to the testator? Is it required to be stated in the will? Hindi. Not even in the attestation clause. This is not one of the facts required to be stated. It is only a fact which has to be proven by the petitioner that it is in a language known to the testator. Okay? Pero medyo may pagkamahina ang isang gumawa ng kababalaghan, okay, in relation to a will. Nilagay niya doon sa will na yun that this will is in a language known to the testatrix. Pero pagdating sa attestation clause, nilagay din niya that the will was translated to the testatrix. O di ba may pagkamahina ang dating? Parang hindi marunong masyado magaling magsinungaling. Okay? Kung alam na niya talaga ang language, bakit pa kailangan translate o interpret sa kanya? Hindi na kailangan, di ba? Kaya mukhang mayroon talagang hindi tama. Okay? Now, but this is only something which has to be proven. Pero hindi kailangang oral testimony to the fact that the language is in a language known. In one case, this may be proven by letters, okay? Sent by the deceased, by the testator. Halimbawa, mga sulat-sulat in Spanish, okay? But there was no question as to the fact that the letters were sent by the testatrix. Spanish yun. Sabi ng Supreme Court, she knew Spanish and the will was in Spanish. Okay? Now, but Ang paborito sa bar exam sa formalities nasa 805. Okay? Basically. But I'll start with signature. Okay? That it should be signed. Okay? At the end thereof. Okay? At the end thereof, ang ibig sabihin ng batas is at the end of the testamentary dispositions. Okay? Ito ang sinatawag na logical end, hindi yung physical end. Kasi pwede namang, there are 10 paragraphs. Okay? Aba, ang signature niya nasa after the 7th paragraph. Meron pang 8, 9, 10. May that be a valid will? Yes. Kung ang mga 8, 9, 10 paragraphs are not dispositions. Okay? Ang mga dispositions nasa first 7. In other words, baka sa 8 paragraph ang nakasulat, sana ang apo ko na si Juan ay mag-aral na sa law school. Mukhang matagal na siya, 8 years na siya, mga ganun lang. So, hindi naman testamentary disposition, hindi kailangan ng signature dyan. Okay? Or nakalagay lang, gusto ko pag namatay ko, mga kalatsutsi ang mga bulaklak. Okay? Wala, hindi kailangan ng signature ang ganun. Okay? So, the logical end, yun ang importante. But, ano ang signature? Kailangan ba ng full signature? Okay? Aba, hindi. Ang full signature, buong pangalan mo. Crisostomo Uribe. Okay? Rarely, in a class of 40, rarely na may isang taong nagpo-full signature pag pumirma. Di ba? Tayo, usually may mga initials or mga shorter na version ng signature. Now, but yung full signature will be relevant sa holographic wills in a while. Okay? But would a cross be sufficient? Above the name, cross ang nakalagay. May it be a sufficient signature? If you remember the case of Garcia versus La Cuesta, the will was denied probate. Kasi cross lang nakalagay? No. Okay? It was because, sabi ng Supreme Court, the petitioner failed to prove that the cross is the usual way of signing by the testator. In other words, if it was proven na ganyan talaga siya pumirma, ay that could have been a sufficient signature, yung cross na yon. Pero thumb mark, would that be a sufficient signature? Aba, definitely. As the court would consistently rule, a thumb mark is more reliable or credible signature. Kasi, hindi mo mafo-forge ang thumb mark. Okay? Yun lang, pwede may shotgun. Diba? May shotgun sa ulo mo, kaya thumb mark ka. Ang possibility ay vitiation of consent. Okay? Unless may pagka-James Bond ang dating. Okay? Kinukuha ang thumb mark sa mga glass, di ba? Hahawak ka sa glass, mayroong print yan. So, kukunin nila yon, tapos makukuha na ang thumb mark mo. Okay? I think that's part of technology. Okay? Somebody told me, yung mga those who perished in nag-capsize na mga barko, pag ilang days na patay, di ba, medyo nag-decompose na, to identify the person, pahirapan na. Ang kinagawa daw ng mga nag-identify, tinatanggal ito, yung nasa thumb mark, nilalagay sa whatever, nalalagyan, parang yung globes, tapos yun ang pinang-thumb mark. So, makikita pa rin kung sino siya, okay, with that thumb mark. At any rate, it is considered as a credible signature. Okay? Now, if the testator did not sign, ay wala, the will is void. But somebody signed for him. Sorry. Dapat ang statement ko, if there was no signature, ang will, ay that is void. But if the testator did not sign, but somebody else signed for him, may it be a valid will? Yes. Okay? Kaya lang may requirements ang batas. Okay? That the testator must have expressly directed the other person to sign for him. It's not sufficient that he was aware that somebody was signing for him. Okay? Alam niya, dapat express ang direction sa third person for him to sign. Although hindi namang sinabi na the instruction must be in writing. Okay? Hindi rin sinabing verbal ang instruction. Baka by hand. Okay? Uy, perma ka, or whatever. Okay? That may suffice. Okay? But take note, it should be done, the signing should also be done in the presence of the testator. And finally, ito ang sa isang kaso, okay? Abellana, okay? Where the person who was asked to sign, ang ipinirma niya above the name ng testator was his name, was his signature, mali, okay? He's supposed to sign the name of the testator, okay? Instead of his name. In other words, kung ang pangalan ng testator, Pedro Santos, siya ay Juan de la Cruz, hindi dapat Juan de la Cruz ang nakasulat. It should be Pedro Santos. Okay? Kung gusto niya, nakalagay ang pangalan niya by Juan de la Cruz. Okay? But the signature must be the name of the testator. Okay? Otherwise, the will would be void. Now, signing. Okay? I think ang susunod na ay this one. This is really the most favorite. In relation to the requirement that the testator must sign in the presence of the witnesses, okay? And the witnesses, a witness must sign in the presence of the testator and the other witnesses. Yung requirement na in the presence of, yun palagi ang paborito sa bar exam, okay? Like this. Clara, thinking of her mortality, drafted a will and asked Roberta, Hannah, Luisa, and Benjamin to be witnesses. Take note, apat sila. 1, 2, 3, 4. During the day of the signing of her will, Clara fell down the stairs and broke both her arms. Coming from the hospital, Clara insisted on signing her will by thumb mark and said that she can sign her full name later. While the will was being signed, Roberta experienced a stomach ache and kept going to the restroom for long periods of time. Hannah, while waiting for her turn to sign the will, was reading the 7th Harry Potter book on the couch, beside the table on which everyone was signing. Benjamin, aside from witnessing the will, also offered to notarize it. A week after, Clara was run over by a drunk driver while crossing the street in Greenbelt. May the will of Clara be admitted to probate? Give your reasons briefly. I fully support this type of questions. Okay? Take note, ang tanong lang, may the will of Clara be admitted to probate, but nothing was mentioned. Anong depekto? Di ba? Because clearly, ang kliyente mo sa tunay na buhay, pag pumunta sa'yo, hindi sasabihin, attorney, ito ang depekto. Okay? Ikaw ang maghahanap ng depekto kung may depekto man. But if there is any defect, you should be able to argue na that's not fatal if you want the will to be probated. Di ba? Ang tanong lang naman ay, pwede ba? May the will of Clara be admitted to probate? If there would be a problem in relation to the will, I would say, dalawa. Okay? Basically. Una, mark. Okay? Hindi talagang yung initial or full signature, may that be a valid will even if only a thumb mark was affixed. But ang mas seryoso na issue dito is the fact na Roberta experienced stomach ache, kept going to the restroom. In other words, she may not have been present, okay, when the other signed. Okay? Lalo na itong si Hannah, okay? Because she was reading the Harry Potter book, okay? Also, ang pangatlo dito na possible issue would go into Benjamin because he offered to notarize the document, okay? Would that affect the validity of the will? Una, pagdating sa thumb mark, definitely no, okay? As mentioned earlier. But into the requirement of the law that the signing must be done in the presence of walang problema apparently sa testator. Ang problema nasa witnesses. Okay? If when the testator signed, was it in the presence of all the witnesses? Kaya lang apat ang witnesses. Okay? What is only required by law is 3. Pero walang problema kay Luisa. There is no problem with Luisa. Diba? So, ang problema na lang dalawa. Okay? Kung if 2 others, if the signing was done in the presence of at least 2 other witnesses aside from Luisa, then there should be no problem. Then the will was executed in accordance with the requirement of the law. But let's start with Luisa. Ang requirement, signing in the presence. What is meant by the law by signing in presence? Does the law require that the other witnesses must have seen the witness sign in order for the signing to be considered to have been done in their presence? Hindi. Okay? So it is not required that they actually saw the signing. But is it required, is it sufficient that they were aware that someone was signing? Hindi nila nakita, pero mukhang alam nila, mukhang nararamdaman nila, feel nila ang pagpirma ng isa. Hindi rin, okay? Because if you remember the ruling of the Supreme Court, okay? Nera versus Rimando, for this requirement to be complied with, okay? The witness, okay, must be in a position to see if he chose to, okay? In other words, while he may not actually see, he should be in a position to see. Thus, dapat walang obstruction to his line of sight, okay, to the person who was signing. In other words, sa actual cases, if the one signing was inside a room, but one of the 3 witnesses was outside the room, would the signing be considered to be in the presence of? Again, it depends. Outside na sa room siya, but if he can actually see the other, he could have seen had he chosen to, then that would be considered to be signed in the presence of this witness. Okay? So, hindi kailangan makita, pero hindi rin sufficient na alam lang, because he should be in a position to see. Okay? If he wanted to. Now, dito, si Anna, while waiting for her turn to sign, was reading the Harry Potter book. Was she in a position to see, applying the Nera Rimando ruling? Yes. Katabi lang niya ang table where the others would sign. Kaya dalawa na, Luisa and Hannah. So, isa na lang. Okay? Una, tingnan natin si Benjamin. Okay? Sabi ni Benjamin, aside from witnessing, he also offered to notarize. Does that mean na incompetent na siya? Not necessarily. Because he just offered to notarize, there is nothing in the problem which would tell us na he actually did notarize. Because if he did notarize, Cruz versus Villasor would apply. That witness who was the notary public before whom the will was acknowledged cannot be considered as a competent witness. Because he cannot acknowledge before himself. Uy, ako ang pumirma, I acknowledge sa akin na he signed freely and voluntarily. Kaya, from the facts, Benjamin may be considered to be a competent witness. So, tatlo na, so the will may be probated. But, even assuming for the sake of argument, that Benjamin was the notary public before whom the will was acknowledged, may this will nonetheless be probated? I would still say yes, pwede. Because, itong si Roberta experienced stomach ache and kept going to the restroom for long periods of time. There is nothing mentioned that the other signed while she was locked inside the restroom. Baka naman every time she would enter the restroom, okay, stop muna, hold muna kayo, mamaya na kayo pumirma, pasok muna ako sa restroom, o diba? But also another scenario, even if walang ceasefire, ang restroom naman, yung ibang restroom, if you don't close the restroom, you can see everyone in the room. Kaya wala din, di ba? You are in a position to see if you wanted to. Ganyan lang naman ang requirement ng batas. Kaya, you can even argue that there are 4 witnesses here, and the signing was not in the presence of the other witnesses. Okay? Now, kaya, Ang sagot dyan ay yes. Because the law only requires the witness to be in a position to see the signing if they wanted to. Okay? Now, ito, Hunt did not see. It's not required. Because a notary public is not considered. It's not that he is not considered as a competent witness because he's a notary public. He will only not be considered as a competent witness if he was also the notary public before whom the will was acknowledged. Okay? A common mistake is to say is the testator and the witnesses acknowledge the will. The notary public acknowledge the will. Mali yun. Okay? It's not the notary public who acknowledges. It is the testator and the witnesses who acknowledges before a notary public that this document is the will of the testator, that they sign freely and voluntarily, basically. Okay? Now, this one, on his deathbed, Vicente was executing a will in the room where Carissa, Carmela, Cornelia, Totisimpo, a notary public. Suddenly, there was a street brawl which caught Cornelius' attention, prompting him to look out the window. Cornelio did not see Vicente sign a will. Is the will valid? The answer is, it may be valid, ang mas magandang formulation. Okay? Because the law only requires to see na present to see the signing of the others they wanted to, meaning, una, there are 3 other witnesses. Okay? Ang problem lang with Attorney Simpo is he is a notary public and the will may have been acknowledged before him. Okay? Kaya pwedeng consider siya na incompetent. But even if Attorney Simpo is the notary public before whom the will was acknowledged, if the dalawa pa ang natitira, di ba? Carissa, Carmela, if Cornelio, although outside the room, okay, was in a position to see if he wanted to, then the signing will still be considered to be in the presence of each other. Okay? Now, this one is a classic Cruz versus Villasor case. Okay? The probate of the will of Nicandro is contested on the ground that notary public before whom the will was acknowledged was also one of the 3 instrumental witnesses. If you were the probate judge, would you decide the contest? Una, with all due respect to the examiner, the word contest is wrong. Okay? Contest in the law on succession has a technical meaning. This would happen only in holographic wills. The will would be contested in the sense that the handwriting would be questioned because ang allegation, the handwriting is not the handwriting of the testator. Then the will is contested. Mamaya or bukas, mamaya siguro, we will discuss what are the requirements if the will is contested. In other words, if the ground to oppose the probate is for other reasons like the 3 witness requirement was not complied with, hindi siya contested. Opposed yan. May opposition to the probate. Okay? At any rate, what the examiner wanted to say is opposed. Okay? The probate was opposed. Okay? If you were the judge, how would you decide the opposition? The answer is, I will grant. Okay? I will decide in favor of the oppositor. Okay? Because of the failure to comply with the 3-witness rule. This is really the ruling of the Supreme Court in Cruz versus Villasor because there were only 3 witnesses and the 2 witnesses and the testator acknowledged the will before one of the 3 witnesses. Kaya sabi ng Supreme Court, the 3-witness requirement was not complied with because this 3rd witness cannot acknowledge before himself. Okay? So, incompetent witness siya. 2 na lang natira. Okay? Now, then, break muna tayo. Okay? Before the other defects.
Kasi pambili. Okay lang yun.
In this bar exam question, there are different questions. May question on declaration, may question on disinheritance, question on solemnities, distribution in one set of facts. Okay? In other words, again, focus on the question. Okay? Kasi if you know the question, madali mo ma-determine ang relevant facts. Okay? Example, was Erica preterited? Nakita mo, si Erica is the wife. Wala na, out ka agad, di ba? Because a wife is not in the direct line, not a compulsion. Walang preparation. Pero as to the defects of the will, marami-rami ang pwede mong i-address. Okay? Like, this would be the relevant facts. Contained only. Very brief and straightforward about, were contained in one page, contained in page 1, which Arthur and his instrumental witness signed at the bottom. Tapos page 2, attestation clause, signatures at the bottom also. Instrumental witnesses included Lambert, the driver of Arthur, Yoli, the family cook, attorney Sorba, the lawyer, prepared the will, and there was a third page, but this only contained the third acknowledgement. Attestation clause stated the will was signed on the same occasion by Arthur and his instrumental witnesses, so also signed in the presence, notary public who notarized the will. There are no marginal signatures or pagination on any of the 3 pages. What are the defects, if any, can cause denial of the probate? Meron ba? Pero may defects ba in the first place? Baka meron. Okay? This one. The will was not signed in each and every page of the left margin. Is that required? That is required. Okay? Except the last. The testator and the witnesses are supposed to sign in each and every page at the left margin except the last. Except the last because the testator is supposed to sign at the end, not at the left margin. Okay? But would that be fatal, which can cause denial? The answer is no. As the Supreme Court would rule, it doesn't matter maski nasa right, maski nasa top, maski nasa bottom, okay? As long as they sign in each and every page, okay? In a way, there's substantial compliance. Tapos, the fact that the witnesses are driver, family cook, would that affect the competency of these people? Hindi. This already was ruled by the Supreme Court in the Gonzales case, okay? That it doesn't matter whether the witness is a driver, a family cook, okay? That will not affect their competence as a witness, okay? The law only would disqualify certain persons from being competent witnesses. Nakalagay kung sino-sino, di ba? Aside from less than 18, not of sound mind, yung mga blind persons, not able to read and write, illiterate, not domiciled, and obviously found guilty of a crime, okay? Specific crimes. Kaya hindi rin. Attorney Sorba cannot also be considered competent because he was the one who prepared, which is really wrong, okay? Unless it was notarized before him, then that would disqualify him from being a competent witness. In other words, kung may defect man dito sa will, they are not fatal to cause the denial. The answer is none. Okay? Now, last year, the attestation clause contains the following, except, okay, caudal, the number of pages that the testator signed or caused another to sign the will, and every page thereof, the presence, notary public, instrumental witnesses, witnessed and signed the will and all the pages. Although medyo defective, the attestation clause contains what the examiner means the attestation clause should contain. Okay? Obviously, ang except dito ay notary public. Okay? The notary public pertains not to the attestation but to the acknowledgement. Okay? Now, but this one, Pipito executed a will that he and 3 attesting witnesses signed following the formalities of law, except that the notary public failed to come. 2 days later, the notary public notarized the will in his law office, where all signatories of the will acknowledged that the testator signed the will in the presence of the testator, that the latter themselves signed the will in the presence of the testator. Was the will validly notarized? Okay? No, since it was notarized on the occasion when the signatories affixed their signatures on the will. If you read 806, that is not required, okay? The only requirement is the will must be acknowledged. But there's nothing mentioned that it should be acknowledged on the same occasion as the execution of the will or the signing by the testator and the witnesses. Letter B, yes, the notary public has to be present only when the signatories acknowledge the acts required of them in relation to the will, and this is the correct answer, okay? Dito, yes, but the defect in the mere notarization is not fatal. In the first place, there is no defect. Kaya hindi maganda ang option na yan. Letter D, no, since the notary public did not require the signatories to sign the respective attestations again. They are not required. Pero ang ibang mga notary public na sigurista, once a person would want his document to be notarized at siya ang signatory, he would be asked to sign again. Dahil sigurista ang notary public to make sure na ang nakapirma doon siya talaga. Okay? But hindi required ng batas yan. Now, again, last year, the following are the formalities required in the execution of holographic will except caudal. Okay? 810. Entirely written, dated, signed by the testator himself, notarized by a notary public. Obviously, it is D. Okay? Kasi nga, holographic. Although it is not entirely written, it should be entirely written by the hand of the testator. Okay? Now, into this, okay, which also appeared sa bar exam last year. Vanessa died on April 14, 1980, leaving behind a holographic will, which is entirely written, dated, and signed in her own handwriting. However, it contains insertions and cancellations which are not authenticated by her signature. For this reason, the probate of Vanessa's will was opposed by her relatives who stood to inherit by her intestacy. Okay? May Vanessa's holographic will be probated? Since may lang naman, the answer dyan is yes. Okay? It may be probated. Okay? Because the insertions, there was no authentication by her signature as to the insertions. And as long as the cancellations were not made by Vanessa, then the will may be probated. The answer dapat dito yes, okay? Kasi may lang naman. If the were made by pero if the insertions were made by another before she signed the will, then no. May Vanessa will be probated? No, if the insertions were made by another before she signed the will. In order actually for that will not to be probated, the insertions were made by a third person before the signing, and it was before the signing by Vanessa. Pero if the insertions were made by a third person after the signing of the will by the testator, for that will to be void, the insertion must have been authenticated by the full signature of the testator. Ang effect nun, the insertion would be considered part of the will, and therefore the will would no longer be entirely written by the hand. Therefore, it will not comply with the requirement of the law, therefore void. Otherwise, if the insertion was made by a third person, even after the signing of the will, but without the full signature, walang effect sa validity ang insertion na yan. Not even that insertion also cannot be given effect. Okay? Because walang full signature. As I mentioned, this will have relevance sa holographic wills. Okay? Even if the insertion was made by the testator himself, okay, that insertion cannot be given effect if not authenticated by the full signature. But it will not affect the validity of the will. It's just that the insertion cannot be given effect. Ang problem, pertains to mamaya. If you remember the case of Kalo versus Rilova, as in the bar exam last year, the only disposition was in favor of a sister, okay? Like Rosa. Tapos thereafter, the name Rosa was cancelled. Dalawang Rosa na name actually were both cancelled, and both changed to, or my insertion na Gregorio. Pero ang first Gregorio was not authenticated. The second Gregorio was authenticated by an initial. Therefore, can Gregorio claim that she is now the instituted heir? The answer is no. Because the insertion can only be given effect if it was authenticated by the full signature. Yung isa nga walang authentication eh. Yung isa mayroon pero hindi sufficient kasi initial lang. But ang effect nito would be this one. Can Rosa now claim, the originally instituted heir, that since the insertion cannot be given effect, the will as originally written should be given effect? So dapat siya ang magmana. Mali din because of the cancellation. With the cancellation, the Supreme Court ruled that the disposition was revoked. Okay? Ito yun lang practically ang disposition sa will. So effectively, the entire will was revoked. So, sino nagmana under the will? Wala. But actually, sino magmamana doon? Silang dalawa. Okay? Because mga kapatid sila eh. Okay? So assuming sila lang ang kapatid na nag-survive, then happy sila, 50-50. Nag-away pa sila. Di ba? Pero actually gusto kasi ng isa akin lang. Gusto ng isa sa kanya lang. Okay? But ultimately 50-50. Okay? This one, special requirements. Stevie was born blind. He went to school for the blind and learned to read in Braille language. He speaks fluent English fluently. Can he make a will? Can he act as a witness to a will? Can he, in either of the above, is a must the will be read to him in either of the above? Ito yung mga formulation na minsan namamali. Diba? Can he in either of the above? Mali ano? Pero maski ako, I would commit the same mistake. Okay? Sa pagmamadali or what? Okay? Can he make a will? Of course he can make a will. Okay? Precisely, there is a specific provision as to the formalities that should be complied with in case the testator is a blind person, that the will should be read to him twice. Okay? Pero, mamaya dito, in relation to letter A, can he act as a witness to a will? Malinaw ang batas. He cannot, okay, be a competent witness because he is blind. Okay? So how can he be a witness? Can he witness the execution if he is blind? But in either of the above, must the will be read to him? The answer is, it depends on whether the will is an ordinary or a holographic will. In the first place, can a blind person execute a valid holographic will? Yung marami nagkiklaim, hindi, kasi blind siya, holographic yon. Aba, pwede. Because some, if not most blind persons, were not blind at birth. Okay? They would be blind only nung medyo may edad na sila, na bulag sila dahil sa aksidente sa kotse, o nabulag sila dahil sa diving. Kaya they know how to write. So they can write their will, holographic will, and thus they know the dispositions in that will need not be read to him twice. Pero pag notarial will, more often than not, hindi siya nag-draft ng notarial will, it has to be read to him twice. Okay? Dito sa letter C. Now, then, this one. Ito yung hindi magkasundo ang mga nasa committee. A French national revokes his will in Japan, where he is domiciled. He then changed his domicile to the Philippines, where he died. The revocation of his will in Japan is valid under Japanese law, but invalid under Philippine law. The affected heir is a Malaysian national residing in the Philippines. What law shall apply? Hindi namin maintindihan ang tanong. Okay? What law will apply saan? Sa pagmana ng heir, sa revocation, sa what law will apply? Because hindi malinaw kung anong tanong, may reprobate ba sa Pilipinas? Kaya kung na-revoke na sa Japan, baka hindi na pwedeng i-probate. Mga ganon, okay? Well, baka pwedeng Japanese law because under the law of Japan, the revocation in Japan is valid under Japanese law, okay? But actually, ultimately, it is Philippine law which will determine. Ibatas natin ito, country natin ito, if our law allows the revocation to be valid because it was consistent with the law of another country, it is because our law allows, di ba? So valid pa rin under Philippine law, okay? But some would say Japanese law kasi valid ang revocation under Japanese law, okay? Which of the following is absolutely true? So we are now into modes of revocation. Revocation is an act of the testator, or revocation is by operation of law. Revocation presupposes a valid will. Revocation takes place only during the lifetime of the testator, none of the above. Okay? What is absolutely true is revocation as a concept presupposes that there is a valid will. Okay? It would be futile discussing revocation if there's nothing to be revoked. Okay? If the will is void. But, anong mali sa an act of the testator? Because there is a mode of revocation which is by implication of law. So, it need not be by the act of the testator. But also by operation of law, hindi naman necessary. Kasi pwedeng execution of a subsequent instrument o pwede rin by distraction, kaya hindi by operation. Absolutely true. Revocation takes place only during the lifetime, hindi. Okay? It can happen even after the death of the testator. Okay? Example, yung by operation of law. Okay? But we'll go into this manner of revocation or modes of revocation by implication of law in a while. Okay? Now, this one. With the intention of revoking his will, X asked his son A to get the envelope containing the will from his bag, knowing that he, meaning A, is heavily favored in the will. A replaced the will with a deed of sale and gave the envelope to his father. X immediately burned the envelope without looking at its contents. There is revocation by implication of law, execution of subsequent instrument, distraction. There was no revocation. As I said, dahil mali ang grammar, hindi ito ang sagot. There is revocation by there was no revocation. No, di ba? Kaya mali yan, hindi yan ang tamang sagot. So there is revocation. The next worst na sagot ay execution of a subsequent instrument. Wala namang subsequent instrument Di ba? But there is revocation by distraction, which is a common answer wrong. Okay? Because in order that there can be a revocation by distraction, the will must be destroyed. Kaya nga ang tawag distraction Okay? In the problem, was the will destroyed? Wala. Kasi naitago ng air. Ang na-destroy ay ang deed of sale, not the will itself. In other words, intention per se does not suffice, will not suffice. It should be intention to revoke coupled with revocation. Pero halimbawa, burning, hindi naman kailangan na ashes na siya para masabihing revoke. Maski may discoloration lang, naging brownish na ang papel, pwede na yan. Bakit hindi naging ash? Bakit brownish lang? Baka somebody tried to get the paper from the fire, so hindi totally na burn. Intention coupled with distraction already result in revocation. Okay? Now, but ang tamang sagot is implication of law. Why? One of the grounds where there would be revocation by implication of law is because the heir committed an act of ingratitude. Okay? Act of unworthiness, under 1032. Under 1032, when an heir prevents the revocation of the will, okay? That would be an act of ingratitude, and therefore he will be incapacitated to inherit. Take note, the revocation here will be only as to those dispositions in favor of that heir. Hindi naman necessarily total revocation ito, because there can be other provisions in favor of other heirs. Those provisions will not be affected by this incapacity by implication of law. Okay? Now, this one, again, you should always bear in mind that there are three modes of revocation. By implication of law, by some will, codicil or other writing, and by burning, tearing, cancelling or obliterating the will. Una, instead of writing dito, pwede lang, by the execution of subsequent instrument, okay na yan. Pero dito, instead na ganyan, burning, tearing, cancelling, pwede na yung revocation by distraction. Okay? Alam na examiner yan. Okay? The point here is, a scenario may not fall under this one, but it may fall under this one. Diba? Just like in the problem. Kaya huwag lang mag-isip na dahil merong subsequent will, dapat it should fall under this. Malay mo, it would fall under the last. Okay? So read always the facts. Okay? I think may magandang bar exam question maya-maya. A disposition in favor of an heir is revoked by implication of law if he was convicted of a crime, he is guilty of adultery or concubinage, he accused the testator of a crime, he prevented the decedent from revoking the will. As mentioned earlier, letter D is the correct answer. This is an act of unworthiness. Bakit if he was convicted of a crime? Would that not result in revocation by implication of law? Not necessarily. Okay? Because 1032 would result in incapacity only if there is an attempt against the life of testator, spouse, ascendants, descendants. So kung ang crime, nothing to do with that, baka wala naman, wala incapacity. Pangalawa, guilty of adultery or concubinage. I already told you, for that to be a ground, it should be adultery with the spouse of the testator, okay? Or with the testator himself. Kung guilty of adultery with any other person, that will not result in revocation by implication of law. You accuse the testator of a crime, in order that there would be revocation, ang requirement dito sa acts of unworthiness ay that it was found to be groundless. Baka naman totoo naman ang accusation. So it will not be an act of unworthiness. Okay? Now, in other words, yung act of unworthiness under 1032 need not be committed during the lifetime of the testator, of the decedent. Okay? Kasi parang may notion na how could an act be an act of unworthiness if the person is already dead? Di ba? parang it is an act of unworthiness kasi buhay pa siya. Pero pwede, even if the decedent is already dead, or the testator is already dead, because pwedeng he concealed the will. Okay? Concealing the will is an act of unworthiness. Or he forged a will, or he altered the will, which would be done normally after the death. So that would still be an act of unworthiness, which would result in revocation by implication of law if there is such a will. Okay? Now, here, in relation to a credit, okay? In the will of X, he gave to A credit in the amount of 1 million. The legacy is deemed revoked, okay? Take note, if the credit na binigay niya sa heir is a credit which a third person owes, okay, to the testator, ang tawag sa legacy na ito ay legacy of credit. Okay? Pero kung ang may utang sa kanya is the heir himself, at in a way, kinukundon ang utang ng heir, okay? Hindi na siya papabayarin, ang tawag dyan ay legacy of waiver of credit. Okay? Dito mukhang legacy of credit ito. He gave to A credit in the amount of... The legacy is deemed revoked if X sent a demand letter to the debtor, if X filed an action against the debtor for the collection, if the court ordered the debtor to pay X before the death, or if the debtor paid X before the death. This is really the worst. Kasi kung may paid na, iba't pa merong revocation, di ba? But the correct answer here is letter B. Okay? Ang requirement for a revocation of a legacy of credit is an action must be filed. Kung nag-demand lang for payment doon sa debtor, magbayad ka, maski in writing pa yan, there will be no revocation by implication of law. Okay? Now, then, this one. A specific car was given to A in the will of X. This one, again, is a legacy. Okay? This legacy is not deemed revoked. Not deemed revoked if the car was destroyed before the death of the testator due to the fault of another heir. Or the car was destroyed before the death of the testator due to a fortuitous event. Or the car was destroyed after the death due to the fault of the executor. Or the car was destroyed after the death due to a fortuitous event. Not deemed revoked, okay, if it was destroyed after the death due to the fault of the executor. In other words, if the destruction happened before the death, deemed revoked ba? Yes, wala nang ibibigay eh. Again, the right of the heir will be vested only upon death. So kung upon death wala na ang kotse, ay walang effect na ang legacy. Okay? Deemed revoked. Pero this one, after the death, pero fortuitous event naman, ay deemed revoked by operation of law. Okay? By implication of law. Ito lang ang hindi. Okay? Now, again, last year, Ramon, a Filipino, executed a will in Manila where he left his house and located in BP Homes, Parañaque, in favor of his Filipino son Ramjen. Ramon's other children, RJ and Ramona, both Turkish nationals, are disputing the bequest to Ramjen. They plotted to kill Ramjen. Medyo libelous ito ng konti. Diba? Ongoing ang kaso dito. Ramon learned of the plot, so he tore his will in 2 pieces out of anger. Okay? Which statement is most accurate? Actually, kung babasahin niyo yung options, walang kinalaman ito. Okay? Which statement is most accurate? The mere act of Ramon Sr. is immaterial because the will is still readable. In other words, even if it was torn into pieces, ang effect parang there is no revocation because readable pa naman. If you tear a paper, mababasa mo pa yun eh, di ba? Pag patong-patong mo lang or connect mo lang. But the mere act of tearing the will amounts to revocation. Tama ba yun? Or the tearing of the will may amount to revocation if coupled with intent of revoking, or the act of tearing the will is material. Obviously, in a way I already mentioned, kung by destruction, there should not only be intent, there should be actual destruction, okay, for revocation to take place. The tearing of the will may amount to revocation if coupled with intent of revoking, even if readable pa ang papel na yan, okay? That should result in revocation by destruction. Now, this one, revocation by the execution of a subsequent instrument. X executed a will in 1990. In 1995, he executed another will, dapat dito, resulting in the revocation of the 1990 will. Yun ang ibig sabihin yan. In 1999, X executed another will expressly revoking the 1995 will. The dispositions in the 1990 will can be given effect if, in other words, the 1990 will be revived. Okay? When? If the 1990 will is denied probate because it is void as to form, this one is really wrong. If the 1999 will is denied probate, then its revocatory clause as to the 1995 will has no effect. So, ang 1995 will would still be effective, which already revoked the first will. Therefore, the first will cannot be revived. Di ba? Ganon din sa letter B. The 99 will is denied probate by reason of age. But, letter C, the 1999 will is probated and the 1995 will expressly revoke the 1990 will. Or, the 1990 will is probated and the 1995 will impliedly revoke the 1990 will. Just to complete yung reason or the basis ng why these options are wrong, molo versus molo. Okay? For a will containing a revocatory clause, for that clause to be given effect, the will itself must be probated. If it is denied probate, walang saysay ang revocatory clause. Okay? Now, but the answer here, the first will can only be given effect if the revocation of the first is only an implied revocation. Because if the revocation of the first was an express revocation, the first will can only be revived if the second will is revoked, if the third will expressly requires the reinstatement of the first. Okay? The effectivity of the first. Again, yung automatic revival of the first with the revocation of the second will only happen if the second will only impliedly revoke the first. Okay? Impliedly revoke, halimbawa, in the first will, I hereby give my house and lot to Maria. Aba, ang second will, I hereby give my house and lot to Christina. Ay mukhang may revocation. Ayaw na niya kay Maria, kay Christina na, pero walang express. Di ba? So if the second will is revoked, tapos implied na ang revocation sa first, the first will can be given effect. Okay? Kaya letter D. Yun lang, take note, if the first will, the will was revoked. Okay? However, the testamentary dispositions in the second will, which expressly revoke the first will, cannot be given effect, ang tawag inoperative, because the heirs instituted in the second will renounce, are incapacitated, they predeceased. Would that revive the first will? The answer is no. Okay? Effective pa rin ang revocatory clause unless, okay, the doctrine of implied revocation. Okay, what is this complete name? Okay, meaning that if in the will it can be shown that the testator would not have revoked the first will had he known that the second will cannot be given effect. then the first will can be considered revived, if that was the intention of the testator, despite the provision of the law na kung incapacity lang, predeceased, the revocatory clause will still be effective. Okay? The doctrine of relative dependent revocation. Okay? In other words, pag dependent sa'yo, i-revoke mo na. Joke lang. Again, under the doctrine, if the testator would not have executed the second will, had he known that those dispositions cannot be given effect, okay, he would not have revoked the first will. Okay, had he known that the dispositions the second would not be given effect or would be void, then the first will can be given effect. Okay, the doctrine of dependent relative revocation. Now this one goes into the manner of revocation, okay? Express or implied. A testator, a bachelor of 60, executed a will bequeathing a rice field to the church worth 100,000. 60 years old na siya. The will further provided that all other assets owned by me after death shall be equally divided among my brothers A and B. Okay? All other assets owned by me after death. The testator subsequently married a young woman, begat a son, and left another will, designating his wife and son as his heirs in equal shares. The second will did not expressly revoke the first will. He left an estate worth 300,000, including the rice field. Who is entitled to the rice field? Who acquires the rest of the assets? In other words, can this, despite the new will, okay, another will, designating his wife and son as his heirs in equal shares, can this first will still be given effect? Ibibigay ang rice field sa church and then all others to the brothers? Hindi na pwede. Okay? Because clearly that would at least impair the legitimacy of the spouse and the children. Okay? Even without the second will. Pero with the second will, pwede pa ba at least ang rice field ibigay sa church? Okay? There are of course, two schools of thought dito. Some would take the view na with the second will, totally revoked ito. Okay? Total ang revocation. Kaya, who will be entitled to the rice field? The wife and the child. Okay? Mukhang 50-50 ang dating. Okay? Designating so as his heirs in equal share. Pero, if there is only an implied revocation, tingnan nyo, 300,000 ng estate upon death. How much of this estate ay freely disposable? If you remember, kalahati bigay mo sa anak. This is 150. Pero ang surviving spouse, ang legitimate lang niya ay 1/4 dahil isa lang ang anak. Therefore, 1/4 of 300 ay 75. I-add mo sa 150, ang legitimate lang ng dalawa ay 225. So, mayroon pang freely disposable portion ng estate na 75,000. Personally, ang position ko din ay the disposition as to the church. Malinaw kasi ang disposition na as to the rice field given to the church. It was not expressly revoked. This is only in a way, if at all there's only an implied revocation, kung pwede namang i-accommodate sa free portion, it should be accommodated. Therefore, if ever there will be a revocation as to the device, kasi lupa, okay, it will only be up to 25,000, up to 1/4 of the rice field. In other words, the church may still be entitled to 3/4 of the rice field. Okay? Dahil covered yan, can be covered by the freely disposable portion. Okay? Kaya ito yung mga widow and son will share the rice field equally. Ang premise dyan, total revocation, okay, ng buong will. Pero dito, son 2/3, widow 1/3, walang basis, okay? Again, yung church, ang premise dyan, walang revocation, ay mali din naman, okay? But this one, church 3/4 ng rice field, but the son and widow will own the 1/4. Kasi kasama sa legitime sila yon. Otherwise, may impair naman ang legitimes ng compulsory heirs, okay? Now, then, this is one good example on the modes of revocation, okay? Mr. Reyes executed a will, completely valid as performed. A week later, however, he executed another will, which expressly revoked his first will, following which he tore his first will to pieces. Upon the death of Mr. Reyes, his second will was presented for probate by his heirs, but it was denied probate due to formal defects. Okay? Assuming that a copy of the first will is available, may it now be admitted to probate and given effect. Kasi, sabi nga, in order for a revocation to be effective, the will revoking another will must be a valid will. So if it was not, it is not a valid will, it was not probated, denied probate, then the revocatory clause would have no effect at all. Therefore, does it mean that the first will can be probated? Mali. Because the first will was revoked not by the execution of a subsequent instrument, but by destruction. If you read the facts carefully, which the will, a week later, he executed another will, which expressly revoked, following which he tore his first will to pieces. Kaya there may not have been a revocation by the execution of a subsequent instrument, but there was a revocation by destruction. Kaya as I said, wag focus lang sa isa. O sige, walang revocation sa mode na ito, but there may be a revocation in the other modes. So yung tatlo, isipin nyo palagi pag may tanong na, is the revocation valid? Okay? Now, the answer is no, because it was revoked when he tore his will to pieces. This is revocation by destruction. Okay? Ito yung no, because a copy of the will not suffice for the probate of such will. Hindi totoo yan. Okay? Kung walang revocation, yung copy na yon, dahil hindi naman ito ordinary will. Mukhang hindi ito ordinary will, the first will. Okay? Kaya it can be proven by a copy. Okay? At tama, kasi may copy a copy of the first will is available. Kaya lang, may revocation okay? Kaya it cannot be probated. So, we can proceed to allowance and disallowance of wills. Okay? In probate proceedings, what are the only questions which a probate court can determine? Okay? Probate, again, probate proceeding would go into the extrinsic validity of the will. Okay? Kaya, the only questions which a probate court can determine would go into the genuineness, okay, of the instrument. Genuineness and authenticity would go into the solemnities, would go into the due execution of the will, and of course yung intention of the testator, okay, would have to be considered. So ang pwedeng ganito ang formulation in probate proceedings, what may not be inquired into by the probate court: authenticity, animus, testandi, testamentary capacity, or the validity of a testamentary disposition. The answer here is letter D, validity. This goes already into the extrinsic validity. But, having said that, I have to remind you that in exceptional circumstances, okay, that ang sabi nga ng Supreme Court, it would be useless to proceed with the probate of the will, but even if the will is probated, the dispositions cannot be given effect because they are intrinsically void on its face. You have to disallow the will immediately. Sayang ang oras, sayang ang pera ng korte, o ng mamamayan. Okay? Why? Ang halimbawa, nag-probate of a will, pero on the face of the will, the testator would admit that he is living in an illicit relationship with a woman, okay? And the only provision in the will is a disposition in favor of that woman. Clearly the disposition is void. So even if the will is extrinsically valid, wala namang problema sa formalities, okay? After the probate, would the disposition be given effect? Wala din, diba? So sayang lang ang oras, sayang ang pera ng korte, just disallow the will right there and then, okay? But that is really exceptional, okay? Now, so the allowance of wills would go into this. Genuineness and authenticity would go into questions on forgery, okay? Kung ang this is merely a forged document, hindi ito pirma ng testator, he never executed a will, that question goes into that. I would say the first thing that should be inquired into by the probate court is the genuineness, okay? Kasi walang saysay yung iba kung hindi naman pala ito ang will ng testator, di ba? But kung genuine yan, kung tunay na will ito ng the alleged testator, then you can go into testamentary capacity. Okay? I have not discussed sa testamentary capacity dahil hindi tinatanong sa bar exam. But basically, testamentary capacity, dalawa lang. Age and soundness of the mind. Okay? So as long as the testator is at least 18 years old and he was of sound mind at the time of the execution of the will, then he has testamentary capacity. Okay? Take note, hindi ito that the testator was of age. Okay? Kasi until 1989, maski 19 years old lang ang testator, at that time, before December 1989, he was then a minor. Kasi ang age of majority before Republic Act 6809 was 21. So kung 19, 20, or 18, minor pa siya. But may that will be a valid will? Yes. Kaya pag sinabi ng batas minor, then tingnan mo ang age of majority. Pero pag sinabi ng batas not less than 18, it doesn't matter kung minor siya under the law or not. Basta tingnan mo, 18 na ba siya? It doesn't matter kung minor or hindi. At sa succession, it is not less than 18. Okay? Now, yung soundness of the mind, okay? If a person has no testamentary capacity, does it mean that he is insane? Aba, not necessarily. He may not have testamentary capacity because he was less than 18 at the time of the execution of the will. Dahil 16 lang siya, it doesn't mean na baliw siya. Okay? Although wala siyang testamentary capacity. Pero, if he is of unsound mind, does that mean that he is insane? Aba, not necessarily also. Because a person may be of unsound mind without being insane. Like yung mga tao suffering from mga sakit, dementia, yung mga last stage ng dementia. Marami talagang ganun. Pag nagkaka-80 na daw yata, 82, medyo nagkakalimutan na talaga. Di ba? Pero siyempre, unang nakakalimutan na may asawa siya. Okay? Yun ang unang nakakalimutan. But hindi lahat daw ng stages. Kasi kung sa first stage pa lang ng dementia, baka he may still be considered to be of sound mind. Okay? Parang sakit lang ito na, yung mga para sa mga mayayaman. Alzheimer's disease. Pero pag sa mga medyo hindi mayaman, ulyanin ka lang. Di ba? Ganun lang yan. Okay? Pero pag medyo, Alzheimer's. Ang ganda ng pangalan, Alzheimer's disease. Okay? So, testamentary capacity. Formalities, we have discussed the formalities prescribed. Okay? due execution, and animosity standing. Hindi ko rin diniscuss sa holographic will ang ibang formalities. Ang diniscuss ko lang yung entirely written by the hand, di ba? Because the other two, somehow, I already mentioned yung signed. Okay na yan, okay? Ang isa yung dated, okay? Kasi may issue dyan sa dated. In the first place, what is the reason why it is so important in holographic wills? Pagdating sa ordinary will, mas hindi naman dated, okay lang yan. That will not affect the validity, di ba? Una, because it has to be dated, because ordinarily walang witnesses. No one would know kung kailan in-execute yan. And therefore, if no one would know when it was executed, we will never know whether he has the capacity to, he has testamentary capacity when he executed the will. Malay natin, it was during that time na medyo baliw siya. Okay? Kaya, yung date is very important to determine the testamentary capacity. At ang mas obvious dyan ay yung edad. Di ba? How would you know kung anong age niya kung hindi natin alam when the will was executed? But if you know the date, i-compare mo sa kanyang birth certificate, you would know whether he was 18 already at the time of the execution of the will. So that is so important. But normally when we say dated, dapat month, day, and year. That is what is meant by dated. Kung out of the three, dalawa lang ang nailagay, may the will nonetheless be a valid will? The answer is yes, as ruled by the Supreme Court in the Jesus case. Ang nailagay, month at saka year, February 61. The will, sabi ng Supreme Court, there was substantial compliance with the formalities prescribed because you will only consider from February 28 days to determine if he was already 18 during that period or that he was of sound mind during that period. Di ba? Ang mahirap, kung may month ka, may day ka, wala kang year. Baka grade 1 pa lang siya noon. Di ba? Kaya importante na yung year at saka ang month. Okay? The year and the month. Okay? Now, however, may isa pang reason dito. The requisite for the substantial compliance rule to be applicable here is there is no question as to the genuineness and authenticity of the will. It's just that yung date hindi kompleto. But there is another ground cited by the Supreme Court in a way interpreting the law liberally. Ngayon, month ang year lang pwede na. Because under the old law, sa Spanish Civil Code, ang requirement is dapat isulat mes, anyo, dia. In other words, the month, the day, and the year. Ngayon, hindi sinabi ng batas that the will should provide or state the month, the day, and the year. Ang sabi lang, it is dated. Kaya, may pagka-liberal na ang requirement ng batas. Okay? Hindi na talaga month, day, year. Okay? At least in that case. So, due execution would go into undue influence, fraud. Walang tanong dyan, hindi nagtatanong. Kasi mahirap ang fraud okay? Mahirap i-determine if the act was a fraudulent act or not, okay? Siguro that's the reason. Animosity standing, the intent to distribute his estate upon death, okay? Ang magandang tanong dito is there a particular material required by law upon which the will should be written for the will to be valid? Like, dapat ba papel? Dapat ba, size 20? Hindi yata size ang pangalan. Standard, tama ba? Basta substance 20, substance 24, wala. The law does not so provide. In other words, isulat mo ang disposition mo sa wall na yan, baka pwede. Kaya lang, paano mo ipoprobate yan? Uso na ang picture ngayon. Okay? Picturean mo lang, yun ang ano mo sa korte. The court may go to this place for ocular inspection kung gusto niya pa rin. Ayaw niya maniwala sa picture. Okay? But the fact that it was written on the wall, there may be a problem. Ang problem dyan ay intent. Okay? Dahil sa wall niya sinulat, baka hindi siya seryoso. He doesn't really intend to give his car to somebody else. Otherwise, if he was so serious, ang daming papel sa library, di ba, na pwede niyang gamitin. Okay? So, ganun din yan. Isinulat sa sand sa Boracay. I hereby give my car to my best friend. Ala, nasa sand. Okay? Mukhang walang intention ito. As the Supreme Court would tell us, there may be a question as to the intent, animo testandi. Okay? Now, so this one. A foreigner married B, a Filipino, and settled in the Philippines. They begat a son. They. Under the laws of A's country, the system of complete separation is allowed, and the husband can freely dispose of his properties without restriction. During the marriage, A bought a large number of shares of Philex Mining out of his salary as a World Bank consultant. Upon A's death, it was found that he left a will leaving all his Philex shares, the only property acquired during his marriage, exclusively to his brother D, totally omitting B and C. B and C therefore opposed the will on the ground of the preterition of C, among others. Okay? Additionally, B claimed that one half of the Felix shares of stock should pertain to her as her conjugal share. Is the will valid? If you were the judge, how would you rule on the issues raised by B and C? I think wala akong options yan. Is the will valid? Again, pag ang tanong, is the will valid? It should go into the two aspects. Okay? Intrinsic and extrinsic validity. So far, there appears to be no problem in relation to the extrinsic validity. Okay? Wala sa issue, wala sa facts. Okay? But the fact that the testator left his entire estate, okay, to his brother, excluding his son and his wife, okay, would that not affect the validity of the will? I dare to say it does not. Okay? Because he is a foreigner and under his law, the system of complete separation is followed and the husband can freely dispose of his properties without restriction. Okay? Kaya, it can be a valid will. In the first place, kung ang question dito goes into the extrinsic validity, if there would be an opposition to the probate of the will, it should not be entertained. Okay? Because if there would be if there is a basis, the question on probate, again, would only have to go into the extrinsic validity. Okay? Now, at pangalawa, there is nothing in the problem which would tell us that there is a ground for disallowance of wills. Yung enumeration ng grounds for disallowance under 839, I would agree with authors like Corrado that this is an exclusive enumeration. Wala nang ibang ground that should be entertained by a probate court for the disallowance of wills. Having said that, okay, what if, ano bang magandang scenario, okay? What if the will had already been revoked, okay? Can it be probated? The answer is no. But is it one of the grounds for the disallowance of wills that the will had already been revoked? Wala. Kaya, can we therefore say na hindi exclusive ang enumeration? Hindi pa rin. Because this ground that the will cannot be probated because it had already been revoked, okay, is only a jurisdictional matter. Goes into the jurisdiction of the court. In other words, before the court can take cognizance of the petition as a probate proceeding, for a probate proceeding, it should have been satisfied first that the will had not yet been revoked. So jurisdictional matter ito. Hindi ito probate court ang nagsasabi. Kaya kung nakita ng korte that the will had already been revoked, walang probate proceeding. It is the petition that should be denied. It is not the will that should be disallowed. Because in the first place, there is no will to be disallowed because it had already been revoked. Ganon din ang ground. What if the petition, there was a motion to dismiss on the ground na improper venue. Okay? Is that a ground for disallowance? Hindi. But that is a ground to dismiss the petition. It goes into the jurisdiction of the court to entertain the probate proceeding, okay, as a probate court. Okay? So, itong mga proceedings na ito, jurisdictional, pag hindi na comply, ay walang probate proceeding. Halimbawa, is it a jurisdictional requirement that the testator must already be dead? And therefore, there must have been a death certificate. Pag walang death certificate, therefore, the court cannot acquire jurisdiction. Hindi totoo. Kasi nga, meron na tayong ante-mortem probate. Kung buhay na buhay pa ang petitioner, siya mismo ang nag-file, kailangan mo ng death certificate niya, masyado ka namang nagmamadali. Okay? Buhay pa siya. Okay? Kaya hindi jurisdictional requirement ang death certificate in that scenario. Okay? Na buhay pa ang testator. Now, although, what if this is a petition for the probate of a will, pero the will itself was not attached to the petition? Is that a ground immediately for the dismissal of the petition? Denial of the petition? Hindi. Okay? Because the court should read the allegations. Because the petitioner may allege that the will is in the possession of a third person who refuses to surrender that will to the court or to the petitioner. If that is the case, kung totoo yun, dapat i-order ng korte ang taong yon to surrender. In fact, the law provides for a penalty. That's a crime not to surrender within a certain period. Kaya lang kung ayaw niya, ano naman ang pwede magawa ng korte? Contempt. Okay? So, pwede siyang ikulong habang hindi niya sinusurrender ang will doon sa korte. Okay? Now, but also, another reason why it was not attached ay because it was lost or destroyed. Kaya walang ma-attach. Okay? But, if that is the case, may the will nonetheless be probated. Pag walang naka-attach na will doon sa petition, ito yung ibang bar exam questions. Okay? Maria, allowance muna to. Maria, to spite her husband, Jorge, whom she suspected was having an affair with another woman, executed a will unknown to him, bequeathing all the property she inherited from her parents to her sister, Miguela. Upon her death, the will was presented for probate. Jorge opposed the probate of the will on the ground that the will was executed by his wife without his knowledge, much less consent, and that it deprived him of his legitim. After all he had given her, no cause for this inheritance, added Jorge in his opposition. Okay? Ang tanong, how will you rule on Jorge's opposition to the probate of Maria's will if you were the judge? I will really rule against Jorge. Okay? Because the grounds relied upon are not grounds for the disallowance of the will. Ang grounds niya ay because Maria executed the will without his knowledge, much less his consent. Well, it is not one of the grounds required by law, provided by law for the denial. Okay? At pangalawa, that it deprived him of his legitim. Not only is it not a ground, but also it goes into the intrinsic validity, which is not within the jurisdiction of the probate court. Okay? So it cannot be entertained by the court for the denial of this allowance of this will. Okay? Then this is similar kanina sa problem. Should the will be admitted in said probate proceeding? Okay? Ang sagot dito, the will can be admitted in the probate proceeding because there may be other dispositions aside from the disposition in favor of the paramour. I think ito yung sa paramour, okay? Except the free gave to X who was living with him. Okay? In the probate, X asked for the issuance, they opposed. Should the will be admitted in said probate proceeding? It says when his wife devised the estate except the free portion which he gave to X who was living with him at the time of his death. Practically, the court may have the right to deny or to disallow the will on the ground that it is intrinsically void because ang entire free portion ibinigay sa paramour That is the only disposition in favor of this paramour. Anyway, the forced heirs would really be entitled to the entire estate even without such will. Okay? Kaya there's no purpose, okay? No sense in admitting the will to probate, pero ganun din naman the disposition in favor of the paramour will not be given effect. Now, but this is a good question, okay? Johnny, with no known living relatives, executed a notarial will giving all his estate to his sweetheart. One day, he had a serious altercation with his sweetheart, okay? Kaya wag mong aawayin ang sweetheart mo, okay? A few days later, he was introduced to a charming lady, okay? Who later became a dear friend. Soon after, he executed a holographic will, kanina notarial, expressly revoking the notarial will and so designating his new friend as sole heir. One day, when he was clearing up his desk, Johnny mistakenly burned, along with other papers, the only copy of his holographic will. His business associate, Eduardo, knew well the contents of the will, which was shown to him by Johnny the day it was executed. A few days after the burning incident, Johnny died. Both wills were sought to be probated in two separate petitions. Will either or both petitions prosper? Okay? May dalawa, notarial and holographic. And the holographic expressly revoked the notarial. But the revocation clearly is only by the execution of a subsequent instrument. Walang revocation by distraction dito. Di ba? Kaya lang, can the second will, the holographic will, under the circumstances, be probated? It was destroyed. At walang kakopya-kopya. If you remember the case of Gunn versus Yap, a holographic will cannot be probated if that will is not presented to the court. Okay? Kasi, that is the only basis of the court in determining whether it is in the handwriting of the testator. Paano niya malalaman kung handwriting kung hindi niya nakikita ang will mismo? Other people can just easily say, I know that it is in his handwriting, pero sabi nga, best evidence ang dokumento. Okay? Kaya lang in that case, sa footnote lang nakalagay, however, a photostatic copy of the will would suffice. So pag may holographic will, pinasirox mo, ang Xerox copy can be a sufficient basis for the court to issue a probate decree. Okay? Kaya sa susunod na kaso, decided by the court, photostatic copy lang, the court probated the will. Okay? Which, ako personally, I also have reservations. Kasi pag photostatic copy lang, ang dali-daling ma-falsify. Okay? Alam natin lahat yan, madali mag-cut and paste pag photostatic copy lang. Akala mo nga signature niya talaga eh. Ikinuha mo lang yan sa ibang document, yung signature na yon. But also, somehow I studied on question documents. Halimbawa, sa pen, okay? Sa pagsusulat, if you are using a pen, it is easier to determine kung forged ang document, makikita mo sa strokes. Okay? Kung forged, nako, nag-i-stop-stop yung pagsusulat. Nag-i-stop-stop, kaya ang ink nag-blot-blot, which cannot so easily be seen kung hindi ka gagamit ng isang instrument. At kailangan yung original na papel. Pag Xerox lang, makikita mo pa ba ang mga blots? Hindi na. Okay? Whereas kung walang forgery, ay tuloy-tuloy ang pagsusulat. Walang blot-blot, di ba? Kaya medyo, I hope there would be a reconsideration ng ruling na yan. But in this case, malinaw naman na only copy, wala. The second will cannot be probated, the holographic will. Therefore, if the second will cannot be probated, may the first will be given effect? The answer is yes. Because the revocation by the second will of the first cannot be given effect, molo versus molo. Okay? For the revocatory clause to be given effect, that will itself must be probated. Okay? Because this is a revocation by the execution of an instrument, subsequent instrument. Kaya ang sagot dito, only the notarial will, because the holographic will cannot be probated. Okay? Di ba maganda ang tanong na ito? Okay? Now, this one. A presented for probate a will purporting to be the last will and testament of his deceased wife. The will was admitted to probate without any opposition. 16 months later, the brothers and sisters of the deceased discovered that the will was a forgery. Can A now be prosecuted for the criminal offense of forgery? Okay? Give your reasons. The Supreme Court had already ruled on this matter. A probate decree which becomes final and executory is binding even as to the due execution of the will. And therefore, later on, no one can question that the will is a forged will and therefore can be the basis of a criminal complaint. Hindi na pwede. Okay? Binding na sa lahat yan. Okay? Now, no, because when a probate decree becomes final, it is binding as to the due execution of the will. Okay? Now, last year, the following are the grounds for disallowance of wills except the formalities required by law have not been complied with. The testator was insane or mentally incapable of making a will. The will was executed through force or under duress. The will contains an attestation clause. Of course, this is not. Kung holographic, kung notarial will nga ito, why should be that a ground for disallowance when it is required? Okay? Pero pag holographic will, does it matter kung mayroon o walang attestation clause? Okay? Now, preliminary na lang sa ibang topics, collation. This is not a favorite. For the past 30 years, isa pa lang ang tanong ang collation somehow. But malay mo, magtanong na naman, okay? At dito kayo mag-top, okay? Sa bar exam dahil sa collation na ito, okay? So X died intestate in 1985, leaving 3 legitimate children, A, B, and C, and 2 acknowledged natural children, D and E, okay? He donated 30,000 to a friend, to F, a friend, in 1970. To A, 40,000 in 75, and to D, 50,000 in 1980. He left an estate amounting to 100,000, with debts in the amount of 40,000, who will inherit from the estate and give the respective shares. Okay? In computing yung una, who will inherit, okay? 3 legitimate children, 2 acknowledged children, acknowledged natural children, and they will inherit, okay? Yung ABC, teka, may donations pala. If there are donations, or even if there's only one donation, okay, which is an inter vivos donation, clearly from the facts, inter vivos yan. Ano ang operations, okay? Una, you have to consider, syempre, the value of the estate. Malinaw naman sa facts, 100,000, okay? 100,000, Anong susunod sa operation? You compute the net hereditary estate, okay? And you can do that by subtracting yung debts, okay? 40,000, diretso agad. Do not collate kaagad. Deduct the debts, okay? This will be 60,000. This is a very important figure. This is the net hereditary estate because ordinarily, the executor can only distribute the net hereditary estate. Yun lang ang paghati-hatian ng mga heirs unless may in-officious donation. Kaya someone has to return a sum of money to the mass of the estate. So, pwedeng madagdagan ang 60,000 na yan. Otherwise, walang in-officious donation, ang mga heirs, yan lang ang paghahati-hatian nila. So, that figure is a very important figure. Nalaman mo na ang net hereditary estate, saka ka mag-collate. Okay? Pag nag-collate, what is the purpose of collation? Okay? This is to protect the compulsory heirs. Okay? In other words, if the testator made donations, pero upon his death, wala namang compulsory heir, ay there's no need to collate. Wala namang protektahan na heir. Okay? But, however, what if mayroong isa man lang na compulsory heir who survived? Tapos may donation during the lifetime. Kailangan ba talaga ng collation? Not necessarily. Kung ang donee ay ang heir mismo, ano pang i-collate? Siya din naman ang donee. Or, ang mga heirs, 10 sila, sila din naman ang donees eh. So there will be no impairment of their legitimes. Okay? Kaya it may not be necessary. But dito malinaw, iba ang mga donees. Okay? Except for 1 or 2. Kaya, kailangan i-collate ang 30,000. Okay? Minus 40. Tama, no? 40. 30,000, tapos 40,000, tapos 50,000. Okay? Ang total niyan ay 180,000. Okay? 60, 100, 180,000. Ang tawag dito ay distributable estate. Anong relevance ng 180,000? This will be the basis in the computation of their legitimes. Okay? Doon sa legitimes, makikita mo kung may impairment o wala. Okay? So, from 180, how this will be divided? Again, basically, 90. Okay? And the other 90 sa free portion. Pero sa kalahati na 90, it should be given to A, B, and C as the legitimate children. Kaya, ang legitimes nila, 30, 30, 30. The other 30, doon kukunin ang legitimes ng concurring compulsory heirs, the legitimate children. Kaya, si D and E, ang legitime nila, 15, 15. So, na-compute mo na ang legitimes. Ang susunod mo na gagawin ay charging. Okay? Yung mga donations to these compulsory heirs or to strangers should be charged. Okay? Because that will tell us later on kung may in-officious donation. Okay? Una, to a friend. Ang tanong, as to the friend F, saan i-charge? Hindi naman siya heir, hindi naman siya magmamana. I-charge siya sa freely disposable portion. Kaya may 15-15 na, may 30 pa. 30,000 to a friend. Okay? Kay F yan. And then, yung kay A, kasi compulsory heir siya, unless otherwise stated by the testator na wag i-charge sa kanyang legitime, it should be charged to his legitime. Okay? Kaya, ang 40,000 to A, i-charge sa kanyang legitime, sobra pa. Okay? May sobra na 10. Ang sobra na yan, dahil kulang ang legitime niya, 30 lang. Ang donation sa kanya, 40. Okay? Yung sobra na 10, i-charge mo doon sa free portion. Kasi baka in officious yan. So, madadagdagan dito, 10. Okay? But finally, may 50,000 to D. Si D, 15 ang legitim. Minus 50, aba, merong sobra na 35. I-charge mo ulit sa free portion. So, 35. I-total mo lahat yan. 5, 10, 15, 5, carry 1, 3, 4, 5, 6, 7, 105. Take note, 105 na ang total, 90 lang ang free portion. Mukhang sumobra ng 15. Pero, i-check mo dito sa legitims. Si A, may makukuha pa ba? 0. Sobra na nga ang donation sa kanya eh. Si B, may makukuha pa ba? Siyempre, buo. 30. Minimum yan. Kung meron pang freely disposable, pwedeng dagdagan. Pero kung wala na, inofficious pa nga ang donation, it is the only amount. Si C, wala din, 30. Si D, wala na, sobra. Pero si E, may 15. Take note, 30, 30, 15 is 75. Pero, ang net hereditary estate is only 60. 60 na lang ang pera. 75 ang dapat ibigay. In other words, kulang ng 15 ang estate. Pero pagdating sa freely disposable portion, sumobra nga ng 15. So, parang accounting lang ito. Balance sheet lang. So, may sobra sa freely disposable portion, may kulang doon sa legitims. In other words, somebody has to return to the mass of the estate 15,000. Ang pera ito, hindi ito property. It's a sum of money. Kasi ang mga donations na yon, valid yon. Inter vivos yun eh. They already took effect. Okay? Pero they have to give back a sum of money. This time, collation pa rin yan of the second type. Kung kanina nag-collate tayo, mathematical lang yan. Pero pag may inofficious donation, the second type of collation is the actual return of a sum of money. 15,000, ang susunod na tanong, who will suffer that 15,000? Who should return? Isa ito sa mga donees. Ang rule dito ay priority in time, priority in right. So kung sino ang pinaka-last na donee, sino ang pinaka-last? Si D. Si D has to return kasi 1980 lang siya, has to return the 15,000. Sobra-sobra ang donation sa kanya by 35, pero isusoli lang niya 15. Kaya ang 60,000 na net hereditary estate, dagdagan mo ng 15, magiging 75, which will be sufficient to cover the legitims of the other heirs. Okay? So sila ang bibigyan mo ng 75,000 each. Kaya, yan ang sagot, okay? A, B, and C, mali yan. B and C, 30, E, 15 is the correct answer, okay? Based on this, okay? Who will inherit? So, ito ang operations. Una, inventory. Sa bar exams, sasabihin na ng examiner ang value of the estate. Sa tunay na buhay, trabaho yan ng executor, okay? To know the value of the estate. Collation of the first concept after deducting the debts. Okay? So, saka ka lang magko-collate itong operation dito. And then, compute the legitim. Pag nakuha mo na ang distributable estate, compute the legitim. Okay? Ibigay mo ang kalahati sa legitimate children. And then, pag nakuha mo na ang legitims ang bawat isa, mag-charge ka na. You impute yung mga donations doon sa mga legitims ng mga donees na compulsory heirs. Kasi i-charge mo sa kanila yon, okay? Pero pag ang donee ay third person, i-charge mo sa freely disposable portion. As in this case, yung 30,000 na ito sa friend. So, after ng charging, pag makita mo na, dito mo na makikita kung may inofficious donation, you may have to reduce or annul the donations. You follow the rule, priority in time, priority in right. Okay? And finally, restitution or the collation of the second type, the actual return of the 15,000. na in officios na donation to the extent of 15,000. Okay? Kaya for example, between donation mortis causa and legacy and device, which is preferred? Pareho lang. Kasi they would take effect at the same time. Di ba? So, they will suffer at the same time. Pero, between donation inter vivos and donation mortis causa, which would have to suffer a reduction? In mortis causa. Because ang inter vivos already took effect during the lifetime. Kaya pag may in officios, yung donation mortis causa yan. Yun ang magsasuffer ng reduction. Okay? Ang susunod ay uwian na. Okay? Uwiin muna tayo. Meron pa naman bukas. Okay?